Yay, you made it. I made it. I made it. I'm here. I'm here. Yes, it is Monday. It is 3 o'clock. Today is October 6th. Yeah, we had a mishap of a live over the weekend that I guess I scheduled it, didn't come, but I'm here now, and we're gonna get this all solved up today because at the end of today we have a verdict on this case. So I am ready to get started. This is let's go back and we'll get a brief rundown of what this case is about. Um, I should have been going to the right page because I'm in Caitlin Spence. Here we go. Nope, wrong page. All right, Michigan versus Carlos Hernandez and Joshua Zuazo. Zuazo, because I can't pronounce it. Put the glasses on so I can read. And so this is what it says. It says there was a pawn shop, and it was owned by Hussein Murray. And I believe he was 72 years old. And today is the final day of testimony. I believe the defense also rests today. This was aired on Friday, so we are a business day late in airing this because it was aired Friday. There were a whole bunch of shoes that they found. And right now, the two men, Carlos Hernandez and Joshua Zuazo, are the two charges are one count of one count of felony murder and 2 counts of unlawful imprisonment. Sam and Linda were married for 54 years. They owned 2 businesses, a pawn shop and a jewelry shop. They were very well loved in their community. There's been a lot of talk in the trial about Carlos being a very recognizable man. So, Friday, or not Friday because we don't stream on Friday, but Thursday, our witnesses were David Packmeyer, and remember he talked about Krispy Kreme donuts. I have dogs in the background. They're very, very noisy today. Hey, TCN, how are you, honey? We also, they talked to Eric Hill, which was an Asian guy that really threw me off because when they said Eric Hill, I expected like this plain Jane white boy to walk up there, and he was an Asian guy, and I made note about that. He was the one that was the firefighter that caught the white Ford F-250. We had Martez Dixon. He was a fire investigator. We had Casey Jones. He was a detective that went over all the masks and the boots and all the stuff that was purchased at, was it Home Depot or Lowe's? One of the two. And then we had Sierra Ramirez. She did the DNA stuff that talked about Octillion that threw everybody off. The graphics designer was in court on Thursday and went over how they scammed to get the graphics put for the side of their truck. So they did get the graphics made. Anybody can make graphics. It's not illegal. I used to have graphics made all the time when I owned a business. So anyways, then they had that long interview. As you remember, Thursday we ended with a very long interview of him in the at the police station. Sorry, I'm trying to adjust my lights here. Everything's a little too bright. And he did that police interview. And Joshua didn't want to be in the courtroom when they did the police interview. So, and after listening to the police interview, we do realize why he didn't want to be in there. There was a lot of stuff being said by Carlos and the detectives that I'm sure Joshua wanted no part of. So we're going to jump into today. Nope, that's still not the right screen that I want. Let's see. How about this one? Nope. How about this one? Nope. How about this one? Yep, there it is. That's the right screen I want. Told y'all it's going to take me a minute. Hey, 80s, how are you? I'm a little all over the place today. I have had a very, very stressful morning. I'm not going to lie. So I'm a little kind of scattered just yet. I do have my coffee. Hector bought me a new cup. So I have a huge, huge cup and it is full of coffee. So I have plenty of coffee to get me through stream. And the dogs are noisy, so I'm going to mute a little bit to kind of buffer all their growling and playing, because they were in timeout for a little while this morning because they have been bad. So we're going to hit play on this. Let me boost the sound and turn this down and get situated. Okay, let's go.
Help, yes.
And I have no.
Yes, please. Remind me who was sitting out there at the end of the day, because
Well, at the end of the day, it was Miss Lofton's because of the other topic we were dealing with only with Miss Lofton.
okay, so then that's
But I think they were in the audience part.
No, playing the 1 hour video of my jury sat there the other day.
But I think
I'm going to turn this down, and while they're getting to trial, I do want to make it known that as of right now, I'm doing a lot of uploads to the Rubber Ramada channel. What I'm doing is I am in the process of transferring the trials and stuff that I have covered on this channel to my original Rubber Ramada channel, because there may be some more changes in the future. Unfortunately, there have been issues. I have talked to Katya, and I'm just going to leave that there. But y'all will see things being uploaded on the original Rubber Ramada channel. And it may say live and stuff, but they are not live. They are just me transferring all the information of trials that I have covered to my channel. So I just want to everybody be aware of that. There's nothing crazy going on or anything, just until I can. Yeah, let's leave it there. Okay, I'm gonna give y'all some volume.
is Dr. Shauna Bryan.
yes, Your Honor.
Okay, and then there was a movement by the parties, prosecution to admit 4A through 4P, is that right?
Yes, Judge.
And there's no objection?
There is no objection. They haven't mentioned Zuazo.
No objection on behalf of Mr. Hernandez.
All right, so 4 through 4P are admitted into evidence, and you may call your witness.
Thank you. People call Dr. Bryan. And Your Honor, request permission to publish when we get to that exhibit for testimony.
Is there any restrictions regarding the images being streamed?
Unfortunately, the juries are going to have to see this.
Oh, one more thing. While I am making short, quick announcements, I will be streaming today and probably the rest of this week to both channels, because I am trying to build up the hours there for the original Rubber Ramada channel. So you'll have to bear with me if you may end up in the wrong chat. I will try to redirect you. Again, thank you for all your understanding, everybody.
Okay.
Good approach to be sworn in by the court.
Good morning, Dr. Bryan.
Good morning.
Stacey, any raise your hand, I'll get you sworn. And do you swear from the testimony you're going to provide us the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. Please be seated and then tell us your name.
My name is Shauna Bryan.
Your witness.
Good morning, Doctor.
Good morning.
Tell us how you're currently employed
I am the Deputy Chief Medical Examiner for Oakland County
and how long have you been a medical examiner?
for 6 years.
And do you have a medical degree?
Yes, I do.
And you have enhanced medical
County.
And how long have you been? Good morning, Doctor.
Good morning.
Tell us how you're currently employed
I am the Deputy Chief Medical Examiner for Oakland County
and how long have you been a medical examiner?
for 6 years.
And do you have a medical degree?
Yes, I do.
And you have enhanced medical training after your basic medical degree. And I don't mean basic as basic, because it's not. But after graduating medical school, you also had more training.
Yes.
And have you had specialized training as a pathologist?
Yes, I have.
And have you testified in criminal cases before?
Yes, I have.
A part of your duties as a medical examiner to document what you've seen in reports.
Yes, it is.
As part of your duties as a medical examiner to photograph the injuries that you see so that they can be documented through photographs.
Yes.
And as a medical examiner, are you to determine a manner of death?
Yes, I am.
And can you tell the jury, when you determine a manner of death, what does that mean?
The manner of death means how the death came to be about.
And define that. What does that mean?
Well, there's only 5 manners. So one would be homicide at the hands of another person, suicide, your own hand, natural, and you form a natural disease like cancer, for example, heart disease. And then there's accident, which is unintentional, like a car accident, and then undetermined when we can't assign or we don't know.
Okay. And do you also determine a cause of death?
Yes.
And tell us what a cause of death is.
The cause of death is the initial injury or disease that leads to death.
Okay. And there's all different types of causes of death.
Yes.
Okay. You could have drowning as a cause of death.
Yes.
You could have a stab wound.
Yes.
You could have a gunshot.
Yes, of course.
And those things you document in your autopsy report.
I do.
Do you have an autopsy report that corresponds to this case?
Yes, I do.
I'm going to show you what's been marked as People's Exhibit number 4. It's an autopsy report for Hussein Murray, case number 246922, with the date of death of October 11th, 2024, and the date of your autopsy is October 12th, 2024. Do you recognize that?
Yes, I do.
And that is your signature at the end?
Yes.
And there's attached diagram at the end of that?
Yes,
And also a toxicology report?
that's correct.
And those are all done in the ordinary course of your duties?
Yes, they are.
And when you do a toxicology, what is a toxicology report?
Toxicology, we usually take fluid from the eye, blood, and then sometimes urine, sometimes gastric, but usually we'll send blood out for toxicology studies, which will test for any alcohols, drugs of abuse, certain prescription medications, things like that.
And that's a standard thing you do as part of autopsies?
Yes, it is.
Your Honor, if it wasn't in the record, I'd move People's Exhibit number 4 into evidence.
All right, it's in.
And I have no objection to its admission.
Doctor, I want to direct you specifically back to your autopsy on October 12th of 2024. Do you recall conducting the autopsy on Mr. Murray?
Yes, I do.
Okay, I'm going to show you what's been marked as People's Exhibit number 4A. It's going to show up on your screen close by. These exhibits we've already agreed to enter, so I'm not going to ask you all the questions that otherwise I would. You understand?
Yes, I do.
I forgot something. Have you been qualified as an expert before in the courts of the state of Michigan?
Yes, I have.
And how many times have you testified as an expert before?
Around 15.
Okay. And had you actually testified as an expert in this case itself in district court?
Yes, I have.
Your Honor, the people would move Dr. Bryan as an expert in forensic pathology.
Your Honor,
Yes, any objections?
I had no objection in the preliminary examination. I also have received your curriculum vitae, and I have no objection for the trial purposes qualified the doctor as an expert.
Okay, Ms. Lawson?
No objection, Your Honor,
All
thank you.
right, the witness will be deemed as an expert in the field of forensic pathology.
Okay. Looking at exhibit number 4A, is that a standard placard that you would give any autopsy that you're going forward with, so that whatever is logged in as far as photographs could then be referenced to that number?
That is correct. So the top number is the case number that was assigned, and the bottom number is the date that I did the autopsy.
And when you get a body in to begin an autopsy, do they usually come in if they're closed from a scene where they're already dead versus unclothed?
They can come in either way. It depends if they're on the scene and they have clothes, they will come in with clothes. If they make it to the hospital and the hospital does any measures, usually they do not have clothes.
Okay. And in Mr. Murray's case, did he come in dressed or
Yes, he did.
undressed?
Yes,
Dressed.
dressed.
Okay. I'm going to show you what's been marked as Exhibit 4B. Do you recognize Mr. Murray?
Yes, this is how I saw him when I entered the room.
And when he entered the room, you'll notice that his hands are bagged.
His hands have bags, yes.
Okay. And are there any bindings that you notice on Mr. Murray's body?
Underneath the bags, yes.
Okay. And what did you notice underneath the bags?
Underneath the bags, his hands are bound by duct tape and a couple of zip ties, as well as you can see the binding around the mouth and the head, and his feet were also bound by duct tape.
I'll show you what's been marked as People's Exhibit number 4C. You recognize that photograph as a different angle of the bindings around his hand?
Yes,
And that also depicts the black duct tape that you had discussed and zip ties around that wrist?
yes,
Were those eventually removed?
Yes, we did remove them.
Were those bindings tight to the body of Mr. Murray, or did they just come off easily?
They were tight.
I'll show you what's been marked as People's Exhibit number 4D. Do you recognize that as another angle of those bindings?
Yes, I do.
And do you notice the condition of those bindings in regards to the Rolex watch?
Yes, where the watch is in between the bindings are tight on there.
And I'll show you what's been marked as Exhibit 4E. Do you recognize that as a side photograph of Mr. Murray's right side?
Yes, it is his right side.
Okay. And that there's a gun holster on his right side?
That is correct.
Okay. And it came in without a gun, is that correct?
That is correct.
I'm going to show you what's been marked as Exhibit 4F. Do you recognize that as a photograph of the lower legs of Mr. Murray?
Yes, I do.
And were they also bagged as were his hands by the sheriff's office?
That is correct.
And is
Yes.
that common procedure when you receive bodies in?
Yes.
I'll show you what's been marked as 4G. Do you recognize that as a photograph of Mr. Murray's lower ankles after the bag is removed?
Yes, I do.
And can you tell us what you see in that photograph?
There was duct tape around the feet.
And there's a shoe on one foot.
One shoe on one foot.
And which foot is missing the shoe for the record?
The left foot.
I'm going to show you what's been marked as 4H. Do you recognize that photograph?
Yes, I do.
And can you tell us what you see in that photograph?
In this photograph, we've taken the clothes off and we've cleaned him off so I can properly see the injuries to his face and body.
Okay. And what observations do you have of any injuries that may catch your attention of Mr. Murray's face?
In this photograph, you can see that there's purple blotching around the eyes, which is bruising. On the face, he has a bunch of bruising all the way from the forehead all the way down to the front of the neck to basically the collarbones. And he has some lacerations, which are tears in the skin and around the jaw. That's what it has. And then the jaw is also fractured. You can't really see it, though, in this picture.
I'll get into your internal investigation as we go forward. But for 4I, People's Exhibit 4I, can you tell us what you see in Exhibit 4I?
Yes, this is his lower lip as that we've pulled down to take a photograph because there's some tears on the left side of the lip and bruising on the inside.
I'm going to show you what's been marked as 4J. Do you recognize that as Mr. Murray's right hand?
Yes,
And can you tell us what you see in that photograph?
it's just his hand.
There's no cuts to his hand.
There are no cuts, no injuries.
I'm going to show you what's been marked as 4K. Is that another angle with the fingertips of Mr. Murray's right hand?
Yes, it is.
And again, do you see any injuries or cuts to his right hand?
No.
I'll show you what's been marked as 4L. Do you recognize that as Mr. Murray's left hand?
Yes, I do.
Again, do you notice any type of injury, bruising, or cuts to his right hand?
No.
I'll show you what's been marked as 4M. This is, again, a different angle with the fingertips of Mr. Murray's left hand. Do you see any type of cuts or bruising to his left hand?
No injuries.
I'm going to show you what's been marked 4N as in Nancy. Do you recognize that photograph?
Yes, I do.
And can you tell us what, if anything, is of interest when you're looking at photograph 4N?
Yes, so this is the back of him. You rolled him over to take pictures of the back. You can see on the scalp, kind of up toward the top of the picture, there is a laceration or a tear in his scalp there.
And can you tell us what type of force does it take, or what type of object does it take to create that type of injury?
Lacerations, bruises, and abrasions like a tearing, superficial tearing of the skin are all caused by blunt force trauma. Anything blunt can cause these injuries, or like from a fall, as long as it's not like a knife, let's say.
I'm going to show you what's been marked as 4O. Is that a close-up of what was in 4N?
Yes, it is.
And can you tell us what we're seeing in 4O?
So it's a close-up, as you said, of the scalp, kind of like the left right here, and he has the tear in the scalp right there.
Was there a second injury to his scalp?
Scalp, yes.
I'm going to show you what's been marked as 4P. Is that depicting the second injury to his scalp?
Yes, so this is a close-up. It's on the back of his scalp, about here, another tear.
Okay. And is that something that can be caused by blunt force trauma?
Yes, it is caused by that.
And any type of blunt object can be able to cause something like that with enough force. Is that correct?
Yes, that's correct.
When you started your physical observations of Mr. Murray, was he consistent with an individual to be 72 years old?
Yes.
Did you determine his weight?
Yes, I did.
And what was Mr. Murray's weight at the time of his passing?
295 pounds.
And how tall was he?
He was 72 inches or 6 feet tall.
Now, you noticed the zip ties around his hand and wrist. Is that correct?
Yes.
You photographed that, and you photographed the evidence of his injury, correct?
Yes.
Now, you started to discuss something about the internal injuries that you later noticed to Mr. Murray's jaw. Can you tell us what, if anything, you noticed regarding the internal injuries to Mr. Murray's jaw?
Yes, so inside, you could even see it in one of the pictures where the lip was down, his jaw, this bone here was fractured.
Okay.
And then there was a lot of bleeding and bruising just on the skin and underneath the skin.
I hear the terminology. Over time, I get used to it, but a lot of folks aren't used to it. So we've talked about lacerations, we talked about bruising, but what do you mean when you say fracture?
Fracture is broken bone.
Okay. And there's different types of fractures?
There are different types, yes.
Okay. How would you describe this type of fracture?
I would say comminuted, meaning broken into multiple pieces.
And does it take substantial force to create that type of injury?
Yes,
Did you notice injury to the left side of his scalp?
yes, I did.
Okay. And how did you designate and describe that injury?
He had a laceration or a tear there on the left side. Once we open the head and reflect the skin back, he has hemorrhage underneath the scalp.
And when you say, go ahead.
Oh, and there are two muscles here that help you chew. He had hemorrhage in those muscles.
We're going to slowly go through the definitions, but when you say hemorrhage, what does that mean?
Sorry, bleeding into the tissue.
And does it take substantial force to get bleeding underneath the scalp so that you could see it in the way that you did?
Yes, and it's a blunt force.
Did you notice any type of injury to his face?
Yes,
What injuries did you notice to his face?
his face has bruising, some tears in there.
Okay. Is it in one location or is it in multiple locations?
It's multiple locations. Basically, the whole entire face
Had bruises to
has bruises and tears.
it. When you started to continue your autopsy, did you notice anything that stuck out about his throat area?
Yes, I did.
Could you tell us what you noticed regarding Mr. Murray's throat area?
On his throat, it looked the same as the face. It has from the anterior neck here, which is the front of the neck, it had diffuse bruising and some kind of linear, no patterned, nothing like a pattern that I noticed, just some linear bruises.
Okay. And what did you notice when you got to look at his throat area internally?
Internally, we lift up the skin. He had soft tissue, which is bleeding into the fat and then the muscles in the neck that control the head. All of that was had blood soaked, and then he had a fracture of a bone in the throat called the hyoid bone.
Okay.
2 fractures.
Again,
broken hyoid bone.
the location of that bone, because we're not going to know by definition and description. Can you point to your actual throat to show us where that would be on a person?
Sure. The hyoid bone is a U-shaped bone, and it sits high up in the neck. If you feel when you swallow, your Adam's apple, that's called the thyroid cartilage. It sits just in front of that. That's high up in the neck and relatively well protected.
And what did you notice about that bone?
It was broken in 2 places.
Okay. In your experience in doing autopsies and going through school, is that a rare injury that you've seen?
It's rare.
And does that take a lot of force to accomplish that type of injury?
It does.
Can you tell us what type of other evidence of injuries you saw to the neck?
The fracture of the bone and just bleeding into the tissues.
Okay. And did you make any determination of how that could occur? How would that type of injury occur?
Neck compression.
Okay. Now, neck compression literally means compressing of the neck. Is that
Yes.
part of the definition I'm okay
That's
on?
literally, yes.
Okay.
literally.
Now, hypothetically, would somebody with a lot of force using their hands be able to create that type of neck compression?
Yes.
Would an individual using a knee on the throat be able to create that type of neck compression?
Yes.
Would an individual using a shoe or boot on the throat be able to do that type of neck compression?
Yes.
How long would it take for continued compression of the neck to result in death?
So the answer to that question is a little complex. If somebody is unable to defend themselves, let's say they're unconscious or they can't move for some reason and pressure is applied to the neck, it's only going to take a matter of minutes, 5 minutes, less than 10 minutes, opposed to somebody who's able to fight back. It might take a little longer. How long, I don't know.
And were you able to determine if Mr. Murray was still alive when this was going on?
Yes.
And how were you able to determine that?
So the cause of death I've listed here is neck compression, but there's also a mechanism of death. Just because you break a hyoid bone doesn't mean you die from that. What he actually died from was asphyxia. This is the mechanism of death. Asphyxia, in the lightest terms, you compress the neck and the jugular veins and carotid arteries, which bring blood to the head and from the head, are compressed. This is where the asphyxia occurs. It takes only about 11 pounds of pressure to do that, which is basically the weight of your head. The reason I know it's neck compression is because the hyoid bone is fractured.
Okay. Did you determine a cause of death?
Yes,
And can you tell us what the cause of death was in Mr. Murray's passing?
neck compression. And I contributed blunt force head and neck trauma too.
And did you determine a manner of death?
Yes,
And what was your determination of manner of death?
homicide.
The injuries that you observed and the multiple injuries, was there anything about those injuries that indicated it could only have been caused by a single individual acting alone?
No,
Was there anything about the multitude of injuries that you observed that excluded multiple participants in the causing of that death?
no,
Was there any type, talk about those neck compressions that we talked about. If I was, let's say, a 130-pound male, and I was trying to cause that neck compression, could a 130-pound male cause those neck compressions?
yes.
I don't have any other questions, Judge.
Okay, thank you. Cross-exam Zuazo.
You want to maybe approach?
Come on up.
Oh, that was horrible on my ear.
Bring you back, Austin, too. For a break. The break is going to require you to sit in your jury room. We'll bring you back, Austin, too.
What?
All right.
Okay, we're sending the jury out. Oh, he's going to ask her some voir dire questions.
And so now we're cross-exam Zuazo.
Thank you very much. Dr. Ryan, my name is Michael McCarthy. I know I met you back on the 17th of December when you gave your preliminary examination testimony in this case. I have questions to ask you. I'll tell you the same thing I told you that day. I have some questions to ask you this morning regarding your testimony. And if I don't make myself clear, please tell me that and I'll rephrase the question. Okay? All right. Thank you. Now, the manner of death is neck compression. That's the main thing that led to the death of Mr. Murray, correct?
Yes, the cause of death.
The cause of death. And while he sustained some tears in his scalp that are documented through the photographs that we've just looked at, those by themselves would not be the cause of death, correct?
No, the tears in the scalp would not be a cause of death.
It was the asphyxiation that actually caused his death, correct?
Yes, asphyxiation by neck compression and by the blunt force trauma sustained to the head and neck. Why? Because when you have blunt force trauma and he's breaking his jaw and it's bleeding into his nose and mouth, he's inhaling while he's still conscious, inhaling blood. If you're inhaling anything but air, you can't breathe. So that's part of the asphyxiation and why that's contributing.
And the way that you were able to make that determination is by examining Mr. Murray's lungs, correct?
That's correct.
And you found inside those lungs something that should not have been there, as well as all these other injuries, but blood in his lungs.
That's correct, under the microscope.
And that is the thing that led to the asphyxiation that ultimately caused his death.
Yes, that's correct.
Now, this hyoid bone, you've given a description of where it is, just at the top of your neck before you get up into your jaw area. Is that right?
Yes, that's right.
And you also talked about a fractured jaw. Those are two separate injuries, correct?
This is correct.
And now we have a jaw that, well, it's on both sides of our face, obviously. Was Mr. Murray's jaw fracture on one side or the other, or was it in the middle?
It was on one side, I believe the right side, and I don't recall the other. It was multiple places, not in the middle though, but on the sides.
Okay, so the jaw fracture is separate from the hyoid bone fracture, which was multiple, correct? The
This is
hyoid
correct.
and
Yes.
the jawbone was also multiple, correct?
Yes,
You said it took substantial force to create that injury and also sustained compression in order to fracture the hyoid bone, correct?
yes,
Now, because the jaw and the hyoid bone are in close proximity on the body to one another, would the same actions lead to both of those injuries, those fractures to the jaw as well as the fractures to the hyoid bone?
so the jaw is more from a blunt force trauma, any kind of hitting with an object or kicking or punching. The hyoid bone being fractured is the neck compression, more specifically.
Can you tell, after you conducted the autopsy or while you're conducting the autopsy, which of those injuries was sustained first?
No,
You can just look at the body, or all you're able to do is look at the body and note the injuries, correct?
this is correct.
All right. But you also said that as to the compression, the neck compression, it was over a sustained period of time, correct?
This is correct.
Now, on direct examination, Mr. Petrofessa asked you a question regarding whether a person of 130 pounds would be able to put that kind of pressure, that sustained pressure on the neck and cause the fracture of the hyoid bone. Remember that question?
Yes, I do.
And you said that's a possibility,
Yes.
correct? And that's all dependent upon somebody being unable to defend themselves, correct?
Unable or not, somebody could do that. It just would take a longer time if somebody was able to defend themselves and, push somebody off of their neck, because really you're compressing the blood vessels there and you're asphyxiating.
Yes. And
So
so,
that's why the time has to be sustained for the brain to just go anoxic, meaning oxygen is not being delivered, and for you to die.
So a person who's got their hands bound is going to have a hard time, and their feet have a hard time fighting that off, correct? That's
Yes, they
sustained
might.
compression.
Yes.
Now, would a person, I asked you this question at the preliminary examination, and I asked then, I formed the question in such a way, I asked if a person in excess of 300 pounds would be capable of providing the amount of sustained pressure, the compression that led to the fracture of the hyoid bone, the two fractures that Mr. Murray sustained.
Yes.
Now, having more information, I'm going to ask you a similar but somewhat different question. Would a person, a man, weighing 450 pounds be capable of exerting the type of sustained pressure that is caused by that led to the death of Mr. Murray because of the fracture to his hyoid bone?
What you're saying, if somebody that weight can sustain
That
the
weight.
injury? Yes.
And 450 pounds is a substantial amount of weight, correct?
Yes.
And a person of that size could put that amount of pressure, or the required amount of pressure, to fracture the hyoid bone, correct?
Yes. This is correct.
Now, I know you said that a person that's 130 pounds could do the same thing, correct?
Yes.
All right, but you don't have any evidence about a person being 130 pounds doing that, correct?
No, I would not know who did it, what they
Sure.
look like, or what they weighed.
And when a person sustains that type of injury, I know you said there was internal bleeding, but I noted from the autopsy photographs that Mr. Murray, unfortunately and tragically, had quite a bit of external bleeding around the head, correct?
Yes, he did.
And that blood flowing, coming from his body when he was alive, correct?
Yes.
Rather than being dead, correct?
Yes.
Because when, and I know you understand this, and I just want to make certain that the jury understands it, when a person dies and their heart stops beating, then blood does not emanate freely or flow from the body, correct?
Yes, this is correct.
It's
Maybe
more-
maybe it will, but just a little bit, not as much as he had.
Because what it is then, when a person is deceased and their heart has stopped, it's gravity that leads to the blood coming out of the body, more so than the pump that is
Well,
your
no,
heart.
not gravity. It actually is the pump. If the heart is no longer pumping, then blood's just going to cease to flow and it'll stop where it is.
That's what I'm saying. It's going to stop.
Yes.
But the fact of the matter is, you know, from your study of Mr. Murray, your examination of Mr. Murray's body, that this went on for as long as 10 minutes while he was alive, and the cause of his death, the blood in his lungs, accumulated while that tremendous compression was being placed on his neck, correct?
Yes, correct. Although I
And-
don't know how much time it
Okay.
took.
So would you agree that if a person is immobilized, as it's evident Mr. Murray was at the time of his death, and this person is, the pressure is being exerted by a person weighing 450 pounds, it might not take the entire 10 minutes, correct? On
It
a
might.
hyoid bone?
It might not if he's completely unable to fight back.
The timing, well, you said it looks, and you don't have any evidence based on what it was that you were able to observe of the body with the bagged feet and the bagged hands, how Mr. Murray's body was delivered to your autopsy room, that he did any fighting back, correct?
I would not know that, no.
Right. And it doesn't look evident that he did, given those circumstances, right?
If he were tied up and then sustained injuries, he probably would have a harder time fighting back, yes.
And one of the things that you documented in the photographs that we looked at was his hands, both his right and his left hand, correct?
That's correct.
And you didn't note any injuries to those.
No injuries.
Okay. So that means nobody's in a fist fight, or he wasn't in a fist fight.
Correct.
I mean, it doesn't look that way
Doesn't
in
appear
terms
that
of what you're able to observe during the autopsy, correct?
That's correct.
So then this 10 minutes that you talked about, is that, I mean, obviously you weren't there, so you don't know as an eyewitness, but 10 minutes is an approximation. It could have been a shorter period of time.
It could have been shorter, it could have been longer.
Okay. Is there, I know you measured or I don't know that, tell the jury, did you measure the amount of blood that was in each of Mr. Murray's lungs?
No, I did not. And the reason is I can't quantify it. It's kind of like you get like a soaked rag of blood and you're trying to squeeze and measure. So it's not something that I can quantify.
Okay.
I just know it's there.
You know that it's
'Cause I can
there.
see it.
And would you consider what you were able to see and know for a fact was indeed blood in each lung? Was it a minimal amount? Was it a medium amount? Was it a substantial amount? What measurement would you use just because of the way you, based on your experience as an expert, you were able to observe?
It was a moderate amount, and this is the reason it contributes, moderate to severe. If it was minimal, I probably wouldn't contribute it, but it's more than that.
And because it's more than that, that is the reason why your cause of death, or what you have said is Mr. Murray's cause of death, but your conclusion is this neck compression leading to asphyxiation.
Yes.
And the asphyxiation is caused by the blood in the lungs.
The asphyxiation is caused by the compression of the vessels in the neck, one, and number two, the blood in the lung.
Two causes.
Yes, it's a contributor. The blood in the lung is a contributing cause.
Okay, the real cause
And then
is
the
that
main cause is
sustained
the
pressure
neck.
on the neck.
This is correct.
And whether it's 10 minutes, 5 minutes, 12 minutes, that's the cause of death, no matter how long it took, correct?
This is correct.
And the bigger the force, the faster it would have gone.
Likely it could have. Yes.
A 450-pound person could accomplish that end a lot more quickly than a hypothetical 130-pound person, correct?
Maybe if they were able.
Okay, thank you. I have nothing further.
Will you redirect?
Yes, Sheila.
Okay, go ahead.
Just a few questions on that. You didn't go to the scene, correct?
I did not.
Okay. And if the scene had shown a lot of blood at the scene, you would agree from what you just testified, that means that the heart is still pumping to put that amount of blood out there. Is that
Yes,
correct?
this is correct.
The blood isn't flowing at the scene until his heart stops. Would you agree with that?
It is not flowing, or
It wouldn't continue to flow
This is
until he
correct.
passes, correct? Okay. Now, there was some testimony earlier that you said he was conscious during this period because you have the blood inside his lungs, right?
right.
And Mr. McCarthy asked about him being immobile, I think at some point in his cross-examination. Immobile has a lot of different terms, and it can be vague for definition. Would you agree with that?
Yes.
Okay. If I'm bound with my hands and zip tied, that doesn't mean I'm immobile at that point, does it?
No.
Okay. I can still struggle with my hands like this.
Sure.
Okay. I can still fight back with my hands like this.
Yes.
Okay. The pressure on the neck, is that pressure on the neck from a frontal pressure? Could it be from a side pressure? Could it be from a rear pressure?
It's not from the rear because the bone is in the front, so it could be in the front or the side.
Okay. So if a person is conscious and they're struggling, there would have to be some other way to keep that head from flailing while that pressure is being placed on the throat. Would you agree with that?
Yes.
And there's nothing that you've testified to that couldn't be caused by a 200-pound man. Is that correct?
That's correct.
And the amount of time and pressure on that throat, if you start that pressure and you're choking and you're struggling and you're fighting, but you break loose of it for 10 seconds, for 30 seconds as you're struggling for your life, could that reset the clock of how long it's going to take?
Well, yes.
Okay. If a person is conscious and they're just not lying there letting you do this, that time period could change depending on how much of a fight is going on.
Yes, that's right.
I don't have any other questions.
Did you want to follow up?
Just on the fight going on, Doctor, you don't have any evidence about a fight going on. You can't see that from what you observed in the autopsy, correct?
Correct. I just know injuries on Mr. Murray.
Thank you. I'm nothing further.
Anything can follow up on that? Okay. Come on. Give you a break. So you're going to go back to your jury room. The break is going to require that you stay in your jury room.
All right, for the jury, please.
All right, we'll take that moment for discussion. Everybody please be seated.
So I believe what's happening here, I'm not muted, is each side is independently, without the other jurors in the room, they're independently interviewing the witness. They're not wanting to do it in front of each juror. The defense, I'm sorry, the defense.
Please be seated.
Good morning.
Sam.
Thank you.
All right, so I want to go over a couple of things that I noted in your report. So under evidence of injuries, which is on page 3 of the report, you have a section that you labeled blunt force injuries. Is that correct?
Yes, it is.
Okay. And blunt force, as we talked about a little bit previously, but I'd like to make sure the jury understands, blunt force means that the person that you're examining was hit with something, correct?
Something blunt, yes.
Okay. Which could be a fist, could be an object, correct?
This is correct.
All right. And blunt force trauma, would you agree with me? It's not as definite as, let's say, a gunshot, where you're able to determine that a bullet hit someone because there's an entrance and an exit wound. Blunt force, you can't really say what the force was. You just know that it was blunt, correct?
This is correct.
Now, unless there is evidence of like a bite wound or a ligature mark or an imprint of a boot, again, you're not able to determine exactly what the cause of the injury was, correct?
That's correct.
Blunt force can even be when someone falls and hits the floor, correct?
Yes, of course.
So it is possible that some of the injuries that Mr. Murray sustained were caused by him falling, correct?
It's possible, yes.
Now, I believe you testified that none of the injuries to the head, the lacerations that we saw, are immediately life-ending, correct?
Not by themselves,
Correct.
immediately.
All right, so let's now move to the neck. You listed obviously neck compression as the primary cause of death, correct?
Yes.
Now, a fractured or broken hyoid bone does not mean immediate death, correct?
This is correct.
Now, you previously testified that to fracture or to break this bone, it would have been direct pressure, specifically to the neck, correct?
Yes.
Again, that could be an object being pressed to the neck, correct?
Yes, it could be.
Could be hands, could be a knee. You're not able to tell us.
That's right.
Now, is it fair to say that it's not actually the amount of force, it's actually the location of force that's most important for any type of injury to that area?
To the neck, you mean?
Yes.
Not the amount, but sorry, say that again.
Yeah, so it's not necessarily the amount of pressure, it's actually where you're pressing,
It's,
or a combination of both.
well, it's a combination of both.
And as you described the hyoid bone, you said it's pretty high up in the neck, correct?
Yes, it is.
Okay. And here we saw that jaw or the mandible was fractured, and that is pretty close to the hyoid bone, correct?
That's correct.
Here you did not observe any type of ligature marks, like as if something like a rope or something had been tied around the neck, correct?
That's correct.
You did not notice any finger marks either, correct?
That's correct.
Now, I want to spend a little bit of time going over the rest of your report. You spent a good amount of time on the cardiovascular system, is that correct?
Yes.
Okay. And you noted that he had 3 bypass grafts in his main coronary arteries, correct?
Yes, I did.
You also noted that he had heart.
What I'm thinking is what they did is they took Carlos's jury out, and Joshua's attorney crossed her without their jury in there, so they wouldn't be tainted by what the medical examiner said, because she's the medical examiner. So I think what happened, and so now they took Joshua's jury out and brought Carlos's in, and now Carlos is crossing the medical examiner. His attorney's crossing the medical examiner. I'm sorry, I'm a little scattered today. Y'all have to excuse me, but I think that's the purpose of this, is so the juries won't get their facts of what the medical examiner said confused between the two guys.
Correct?
Yes, he does.
You also noted he had aortic arteriosclerosis severe.
Yes.
Yeah, I think
And the
so.
aorta is responsible
Yes.
for carrying the oxygenated blood from the heart to the rest of the body, correct?
Yes, it is.
You also noted in that same section that he had an enlarged heart, correct?
Yes.
Would you agree with me that someone with severe heart disease has a greater chance of dying during loss of blood compared to someone with a healthy heart?
Just in general or in this case?
In general.
In general, yes.
Now, you testified that when someone's heart actually stops, the blood would stop coming out of the body. Is that correct?
Yes, or very minimally it would come out.
Okay. And I think you testified that you had not actually seen photos of the scene. You just see the person that is brought to you. Is that correct?
I did not go to the scene, but I did see photos.
You did see photos. And from those photos, you were able to determine that there was quite a bit of blood surrounding Mr. Murray, correct?
Yes, I do recall that.
Okay. So taking that with the evidence of finding blood in Mr. Murray's lungs, it was your determination that he was alive for a period of time, correct?
Yes.
After sustaining the injuries, I should say.
Yes.
You also testified that the injuries to the neck, which ultimately led to Mr. Murray's death, when Mr. Petrofessa asked you, could have been done by a 150-pound man, correct?
Yes, they could have.
If we were just looking at the binding with the duct tape, the binding on the wrists and the feet and the mouth, that would have not caused death without any other injuries, correct?
Correct.
I have nothing further.
Redirect.
Just briefly. We're in agreement that Mr. Murray didn't die of a heart attack. Is that correct?
That's correct.
Okay, and we're also in agreement that he was conscious during this attack up until his heart stopped.
Up until he asphyxiated or lack of oxygen to the brain. Yes.
And there was a lot of blood at the scene.
Yes, as I recall.
And you've already noted that Mr. Murray was almost 300 pounds,
Yes.
and he was 6 foot tall.
Yes, he was.
If Mr. Murray, when he was bound, wasn't just laying with his hands down at his side, not fighting back, then somebody would have direct access to that throat area, correct?
Yes.
But if he's fighting, if he's struggling, at that point in time, it would be very difficult because you're also dealing with the person that's struggling and fighting as you're doing that. Is that correct?
Yes, it would make it more difficult.
And once a neck compression starts to that throat, if somebody was to break that pressure as it was going on, even for 20, 30 seconds as they're struggling around, would that reset the clock of how you have to start again to inflict that injury to stop?
Yes, it would.
Really?
No other questions, Judge?
Okay, I have a problem with that just because, and this is just me. I mean, he's saying reset the clock till you have to start the choking all over again. But that's not necessarily true because you're already like short of, so you're not like totally starting from the start. I mean, you have to start the asphyxiation over again, the choking sensation of however you're doing it. But, you know, I don't think it's a complete start over because obviously your person has already had lack of oxygen, lack of blood flow and everything with the current choking that's happening. So okay, Cindy, I'm glad you said it doesn't make sense either because I thought maybe I just was, I wouldn't think it would totally reset, you know. Okay, Hannah will be here. Oh, my coffee has not cleared my throat this morning. I need to go get my cup and pour this in my cup because this is keeping I love Hector for buying me a new cup and it's keeping it too hot and I need another cup to pour it in to drink it out of. So, okay, we're going to hit play again.
You want to follow up? No. Okay. All right. Come on up, lawyers, please.
Come to the bench, lawyers. We're going to talk again.
So I will see you back.
What did she say? Hang on.
Take a break. So I will see you back momentarily.
Take a break. Okay. And they all go up to the bench and talk, and then they leave, and we get a new witness. Okay, on to the new witness. And I have to say, Morticia has a lovely black dress on today.
Your Honor.
All right, Dr. Bryan, you may step down. In no objection excusing Dr. Bryan?
No objection, Your
All
Honor.
right, you are excused. Thank you for your patience. People, next witness.
You call Ted Conley.
All right, thank you. Please be seated and tell us your name.
Detective Jordan Conley,
Your witness.
And Detective, you spell your first name and your last name for us, please.
JORDANCONLEY,
And Detective Conley, where are you employed?
with the Oakland County Sheriff's Office.
And what's your current title?
I'm a detective out of the Rochester Hills substation.
And how long have you been a detective?
Just under 6 years.
Okay. And prior to being a detective, were you what were your duties?
I worked road patrol in Rochester Hills.
Okay. And how many years total do you have of law enforcement experience?
17.
17 years. Okay. And are you the officer in charge in this case that you've been here for all week?
Yes, I am.
Okay. And what does it mean to be an officer in charge?
You're assigned the case. You obviously, in a case of this magnitude, there's a lot more moving parts. On a normal case, you would do the full investigation yourself, all the way through delivering it to the prosecutor for review of charges. Obviously, in this manner, there's a lot more moving parts, a lot more detectives, and other people were involved. So usually I was a point of contact. As detectives did jobs, they would report back to me, or man who would then relay the information to me about what was obtained, what was found, information that I needed to be aware of in the case. As well as Detective Packmeyer, we'd heard earlier, he was assisting OIC in this matter. Once the evidence was collected and information was collected, it was submitted to the prosecutor's office, and we saw the case through all the way till we sit here today.
And how are you assigned to be an OIC in the case?
Through one of my command officers, whether it be a lieutenant or sergeant, is normal route of how I would be assigned.
Okay, and on this, do you recall when you were assigned to be the officer in charge of this?
The night of the incident, I don't recall if it was our detective lieutenant or our detective sergeant, but I was advised that I would be OIC of the case and that Detective Packmeyer would be assisting me.
So would it be fair to say it's just luck of the draw at that point if you're working that day, things like that?
It's a decision that they made.
Okay. And were you, did you arrive on scene to the 3730 Newcastle Drive on the day of the homicide?
I did.
Okay. And were you initially dispatched there, or was that something you came to later on in the afternoon?
It was, we overheard the call while in the office over the radio. Obviously, there was multiple road patrol units heading to the area. I then got into my vehicle. I drove normal traffic as I have an unmarked vehicle, so I thought it would be, appropriate to drive normal traffic without lights and sirens in case the suspect vehicle was to be observed. I wouldn't be coming with all the lights and sirens to indicate that I was a police officer at that time.
And prior to arriving on scene that day, were you given the assignment of officer in charge, or did that just get handed down later?
No, that was handed down a little while into the incident. I don't recall exactly the time frame.
Okay. I'm going to jump ahead a little bit because we've heard a lot of testimony from Detective Packmeyer and some of the other detectives and deputies who did things in this case. I want to ask you a question. Does the Oakland County Sheriff's Office have a computer crimes division?
Yes, we do.
Okay. And what function do they serve in your role as an officer in charge investigating crimes?
As most of the time, if we have a cell phone that we view as evidence, computers, any electronic storage devices, they're able to examine those items, obtain information off of those items. We've also used them where they'll come to scenes and help with security footage. A lot of times gas stations, other places with security footage, they don't even know how to use their own system or obtain the video off that. So the computers crime unit will come out, assist with obtaining, videos such as that.
So during investigations, and if there's Ring camera or surveillance video, and you would request their services to come out and help obtain any sort of digital media that would be necessary?
Yes, if it was something that was above our knowledge or ability, yes, we would.
Do you usually give them cell phones to examine or extract data from during your investigations?
Yes, it's very, very common in investigations. Everybody has cell phones on them. Everybody uses cell phones. Cell phone examinations very common in multiple investigations that I've completed.
Okay. And once you give them a cell phone, what do they give back to you?
Usually, sometimes if they find something that is blaring, they may just provide a report regarding that. Most of the time, they provide a USB, which has a program called Cellbrite on it. It essentially dumps all the information from the phone into that program. It's an exact, from what my understanding, it's an exact copy of what's on that phone, whether it's stored on the phone, recently deleted, some of that is still stored on the phone. It's a copy of what was on the phone, and you use this program to view through the items that were taken off of the phone at that time.
I want to follow up on a question that you said. Sometimes if something's blaring, they'll send it over to you. Is that what you testified to?
Yes, sometimes they do go through some things if you tell them that there's something very specific that you're looking for. And if they notice that item, they will contact you and send that item over.
So that was the next question. Sometimes, because the computer crimes aren't necessary, they're not the officer in charge, sometimes they go on scene. Do you give the cell phone examiner or the detectives at the Oakland County Sheriff's Office certain parameters that you may be looking for in your investigation to speed it up?
It depends on the investigation. Obviously, if it's a child sexually abusive material case, you would indicate to them that that's something that you're looking for in this device. And, obviously if they see images such as that, they would give you the heads up and indicate to you pretty quickly that information is available.
So it'd be fair to say if you don't give them the certain parameters or certain things to look for, they just then give you an image or a copy of that particular cell phone in that Cellbrite software. That
is correct. I would receive a USB or hard drive and would have to go through all the contents of the phone myself.
And you were mentioning Cellbrite. Is this a report mechanism or software that they then give you and you can review?
To be honest with you, it's an application that comes on the USB, and that's how the information is viewed through that program.
So outside of how the software works or anything like that, that's not an area.
Yeah, I don't have much knowledge beyond. That's the program that's on there, and that's what's used to view the contents of the phone.
So another question is, so is that Cellbrite program they give you, does that allow you to help search easier and things like that? It's just a report.
Yes, it has different tabs such as instant messages, chats, photos, videos. There's multiple different tabs that it breaks down the information into to make it a little bit easier to search. If you're looking for certain pictures, you can click on the photo and begin to go through the data that's in the images or photos. I forget how it's actually titled on the tabs.
Okay. But it's just an easily presentable thing for you to read and look at and search for information.
Yes.
Okay. And your knowledge and experience in your years in the detective bureau, do you know how many cell-right reports that you've gone through?
I couldn't even make a guess at this point. Probably 50 plus at least.
Okay. And as part of being the officer charged in this particular case that you're here for today, were you tasked with authoring and obtaining search warrants of cell phones?
Yes, I was.
Okay. And this matter, did you obtain a search warrant for defendant Joshua Zuazo?
Yes, I did.
Okay. And do you recall when you were able to obtain the search warrant?
I believe that search warrant was obtained on October 14th, following him being taken into custody.
Okay. And to draft the search warrant for the cell phone, how did you know that cell phone that you were getting a search warrant for?
I find it interesting. I think what's happening with these that last witness, and I don't know if they'll do it for any of these other ones. This is going to go into the text messages and stuff of what happened, but they don't want the jury to be tainted with what the other defendant is in trouble for, and like I said, this is going to be interesting to know if they come back with different charges or what. So I don't know. We'll see. I'm just amazed at this. But right now they're both in there for direct examination. Now, when cross comes back, I don't know if they're going to separate these two because this goes into cell phone stuff, text messages.
Or belong to the defendant?
It was removed from him when he was taken into custody.
Okay. And after obtaining a search warrant for the phone, what did you do with this phone?
At that time, one of the computer crimes detectives, Detective Boyce, was actually at our office at the time. The cell phone was handed to me by the transporting deputy, Deputy Bander. I then took it, handed it to Detective Boyce from the computer crimes unit, who put it into a sealed bag and transported it to the computer crimes their office once I had obtained the search warrant and handed him a copy of the search warrant.
Okay. And once you gave that phone, or Detective Boyce took this phone, did you eventually get returned a cell-right extraction of the defendant's cell phone?
I did.
Okay. And when you were given this cell-right report of his phone, did you review that cell-right report?
I did.
And did it include text messages that you reviewed?
It did.
Okay. And this particular report, did you review text messages from Mr. Zuazo and Mr. Hernandez?
I did.
Okay. And how were you able to determine that was communications between Defendant Hernandez and Defendant Zuazo?
Through the investigation, obviously on the cell-right report, for that particular phone, it indicates the cell phone number, indicates who the owner is and what the owner number is. And through the text message conversations, both phone numbers are listed, who it's to, who it's from. And I recognize the other number as the phone number for Mr. Hernandez, specifically that he used when purchasing the signs, as we heard yesterday.
And you personally reviewed those messages?
I did.
Okay, give me 1 second. And of course, the computer. Okay. And at this time, Your Honor, the people are going to move to amend Published People's Proposed Exhibit 23. There'll be text message between Mr. Hernandez and Mr. Zuazo. Those were previously given to both counsels.
Any objections?
No, you're right. I have received and reviewed all of those documents.
Okay. For 23 then.
Okay. And detective is going to bring it back to probably 9 minutes from elementary school. We're going to have to sit there and read through some of these, and we're going to ask you a question about these, okay?
Yes, sir.
And does that pop up on your screen right there?
Oh, yes, it did.
Okay. And this is a copy, or this is what a cell-right report would look like, an extraction report. Is that fair to say?
Yes, it appears to be an extraction report from cell-right.
Okay. Is this the extraction report that you did for messages between Defendant Zuazo and Defendant Hernandez?
It's the one I viewed. I believe it's the one that was supplied to me by Detective Boyce.
Oh, Detective Boyce?
I believe he made the actual extraction report.
Okay. And so I see there's a little, I would say, column on the left that says participants.
Yes, sir.
Okay. And based on your review of other extraction reports, it lists the participants that are going to be in that particular messaging that you're reviewing.
Yes.
Okay. And what is that first name on there for the participant?
Joshua Zuazo _ 07 at iCloud.com.
Okay. And the way that's presented as the first name, is that the device with this particular messaging of the report is extracted from.
I'm not sure what order they would actually,
Okay.
the Cellbrite actually puts that in.
Okay, and you see the second one, it says, it's SOSO. And who do you know that to be based on your investigation of this?
Based on the phone number and through the investigation, that's the phone number used by Carlos Hernandez.
So the SOSO is Carlos Hernandez's phone number.
Yes, sir.
Okay, and that other participant is going to be that phone number. Who is that associated with?
I believe that's the actual device, the phone number that's for the device of Joshua Zuazo.
Sorry, do you mind if I sit down so I can easily scroll through here? Okay. And just by reference, detective, this particular message, can we know who the sender is on this?
Yes, if you notice at the top, it says from, and then it gives a phone number and the contact name is SOSO, which in the participants was determined to be Carlos Hernandez.
Okay, and as far as you know, I'm an Android user, so I'm not friendly in group messaging. The colors would be different. The colors on this particular report, does that?
Okay. I am helping with my little magnifying glass, trying to expand these so we can see them a little bit better. I'm shocked at what I'm reading. They haven't even read it yet, and I read ahead of them. I need to stop doing that.
Correspond to the type of device, or that's just the way Cellbrite does it?
I believe that's the way that Cellbrite does it.
Okay. And this message is coming from Defendant Hernandez to the phone number that you have associated with Defendant Zuazo?
Yes, as it indicates next to the phone number, it shows the designation as owner, which is the cell phone that we provided to obtain these messages.
Okay, and what does this message say that's coming from Defendant Hernandez to Defendant Zuazo?
It says, I know how to use a lockpick set, and I'm a get one.
And what is that dated?
That was September 16th of 2024. It appears to be at 11:45 p.m.
Let's scroll down to some more messages, okay? And would this be the same person sending it, the same person receiving it, and this next set of message in the top left?
The blue one?
Yes.
Yes, it is the same sender and receiver.
And what is that saying?
That says we can get into some shit now.
And what is the response?
The response is from the owner phone, which was Mr. Zuazo says to Mr. Hernandez, and it states any lock, ?
And the response from Mr. Hernandez?
Mr. Hernandez responds, any lock.
And the response?
Yes.
And this message, the one in blue right here, from Mr. Hernandez to Defendant Zuazo, what does that say?
We need a car.
What is that dated?
That's September 20th, 2024 at 7:21 p.m.
And the response?
Let me call the lot.
And the next group of message, and what does Defendant Hernandez say?
Okay.
And the response?
Mr. Zuazo states, he said no luck yet.
And what is the response from Mr. Hernandez in this message?
We have to have one.
Is that also dated September 20th, or is that dated September 20, 2000?
Oh, that last message is September 20th, 2024 at 7:24 p.m.
And what does Defendant Zuazo say in this message in green right here?
He says, we may have to get one.
And what is the response from Defendant Hernandez?
It don't matter. We need one. However, we do it.
And the next message?
And possibly a dolly.
Oh my
Do you have
God.
clarification on who's the sender and possibly the dollar?
No issue with that. And on here, who is the sender of the message and possibly a dolly?
That appears to be a message from Mr. Hernandez to Mr. Zuazo.
And just for the record, all these messages here are going to be from Defendant, or to and from Defendant Hernandez and Zuazo and vice versa.
I believe in so far that appears to what it should be, according to the participants.
Okay. And going over several Cellbrite reports in your being a detective bureau, this is appears to be a text message containing some images. Would that be fair to say?
Correct.
Okay. And then during the full extraction, if we were to have the full extraction here, would it be fair to say you'd be able to click on it and the image could be either thumbnail or big image, depends on how that is.
Yeah, the images may have also been saved in the image folder, as your phone during messages sometimes takes snippets of images that are in messages and places it in different in places that would fall into the image folder when the Cellbrite and the phone number are done.
Okay, and Detective Conley, on this message that we're reviewing right here on your screen and up there, this message is being sent by who?
It's being sent by Mr. Hernandez to Mr. Zuazo.
Okay, and the date of this is?
This is October 4th, 2024. Looks like 6:00 p.m.
And this particular message is this second message, what is that display?
displays DTE images that through the investigation were very similar to the images that were sent to him by Mr. Saucedo from the sign shop.
And this is, again, this is from defendant Hernandez, defendant Zuazo.
Yes, sir.
And then these up here, I'm not gonna have you read out loud since it's not relevant. What this right here on
Oh,
from
y'all.
Mr. Zuazo to
Potty mouth.
Mr. Hernandez, the bottom right
you
here. what
don't
does it
use
say?
that word.
Says
Sorry.
Sam might be fired. No vehicle to work in. I'm finna go all in on something soon.
And this message right here on the top, who's setting this?
Mr. Hernandez to Mr. Zuazo.
And what does that say?
I promise you, bro, what we planning gonna be it.
Okay, when was that sent?
That was October 6, 2024 at 2:25 p.m.
And this next message, detective, what does it say?
Wow.
Can you scroll down?
This one's from Mr. Hernandez to Mr. Zuazo. It states, it's gonna get us where we need to be.
And when was that sent?
October 6, 2024 at 2:25 p.m.
Wow.
Okay, what's the date of this message on the top right here?
You mean the top left?
Top left, yes, sir.
October 9th.
The date
Yes.
is October 9th, 2024 at 8:55 p.m.
Okay, and who's sending this message?
That's from Mr. Hernandez to Mr. Zuazo.
And what does that say?
I know
I'm
that's what I'm
about to
trying to
leave now.
highlight them.
And what about the response? It would be the response from,
Mr. Zuazo to Mr. Hernandez is okay.
and that's October 9th.
That's October 9th, 2024 at 8:55 p.m.
And the next message down here at the bottom of this page, was that it?
That's from Mr. Hernandez to Mr. Zuazo. It states, you ready?
Okay, a date in the bottom, what date is that?
That's October 10th, 2024.
Okay, and what time is that?
That's 8:20 a.m.
So this is communications the night before the homicide in Rochester Hills between Mr. Zuazo and Mr. Hernandez.
Yes.
Excuse me, was it the time in the evening or the morning of the?
Is it? Is that 8:20?
That's 8:20 a.m.
Thank you. And this message in top right from Mr. Zuazo. What does he state here?
I already ate.
Okay. And this next message, would that also be Mr. Zuazo to Mr. Hernandez?
Yeah, that one is Mr. Zuazo to Mr. Hernandez. I specifically do recall that as being a property release form, which Deputy Haglin also indicated he had found at Mr. Hernandez's house during the search warrant.
In this image that we have here through the cell phone.
While in the program, I was able to observe that image at full size.
Okay, and you've been
Y'all have to excuse me. I know I keep looking over the wrong way. It's because that screen that all this is actually on, not my screen where my StreamYard and where the chat and everything is a total nother screen. So in order for me to put the magnifier on it, I have to be on that screen and it's off here to the side. So I know I look kind of weird looking over here at the side, but that's what I'm doing.
To be fair to say.
Yes, sir.
And that is that one of the exhibits that people have admitted through Detective Haglin regarding something that he found during a search
Yes, sir.
of Hernandez's house.
Yes, sir.
And this message right here, what's the date on this?
That is October 10th, 2024 at 4:35 p.m.
And that's a copy that you saw of that release form.
Yes, it was a release form similar to the paperwork that I don't know if it's the exact physical copy that was found, but it's similar to the ones that were located at Mr. Hernandez.
Okay, and based on your knowledge, that particular piece of paper that we admitted as an exhibit through Detective Haglin, that was found at the house that Mr. Hernandez and Man Diaz were staying on at the Lincoln Park.
Yes, from his testimony yesterday. Yes, sir.
And this particular message, though, is a copy of that image that's sent from defendant Zuazo to defendant Hernandez.
Yes.
And this message right here, top left in the blue,
That's from Mr. Hernandez to Mr. Zuazo. It states, what is this? And that's on October 10th, 2024 at 4:55 p.m.
and this next message in the green, what is this?
Mr. Zuazo.
And I will take a moment to point this out. Hang on just a second. Are you good, bud? You're good? Looking at me. Is Lola there too?
Yeah.
They're laying on the couch relaxing. Okay, well, don't lock the gate so they can keep playing, okay, bud? Sorry about that. Son was in here. He was checking on the dogs. But what I wanted to point out before that was looking at these. If you look out, these are all deleted, user deleted. When they scroll, I can see it right here on this one. It says user deleted. It says deletion date October 10th at 4:58. So as soon as he sent it, it said delivered October 10th, 4:58:20. Message deleted, reason user deleted, deletion date October 10th at 4:58:20. So no sooner than he was sending these messages, they were deleting them.
To Mr. Hernandez.
I believe. I don't know that for a fact, but from what I understand and my knowledge of Cellbrite and reading these reports, that is what was happening.
States waiver of damages. That's October 10th, 2024, 4:58 p.m.
And this next message in blue.
Mr. Hernandez states to Mr. Zuazo, that's for a landlord though. Read it. That's October 10th, 2024, 4:58 p.m.
And this one is top right. Can you read that first?
Mr. Zuazo's to Mr. Hernandez. I get that. Just giving you an idea in case they refuse. Something else to sign. October 12th or October 10th, 2024, 5:01 p.m.
And the next message.
Mr. Hernandez writes to Mr. Zuazo's, the light's working. October 10th, 2024, 5:47 p.m.
And the next message over here.
Mr. Zuazo states to Mr. Hernandez, the baby has my phone, so just call it back to back and he'll give it to me. October 10th, 2024, 6:02 p.m.
And the next message that we have here.
Mr. Hernandez states to Mr. Zuazo's, okay, October 10th, 2024, 6:02 p.m.
And based on your reading of Cellbrite reports, I see that it says message deleted reason. Do you know what that is?
I don't have exact knowledge of that as my understanding of Cellbrite and the way phones store data is sometimes you think you deleted something and your phone actually stores it in a separate location that can be extracted for some time, but I can't exactly testify to the fact of where these messages were located in the phone.
Thank you. And the next message.
Mr. Zuazo states to Mr. Hernandez or beep, October 10th, 2024, 6:02 p.m.
And the next message.
Mr. Zuazo states to Mr. Hernandez both October 10th, 2024, 6:02 p.m.
Okay. And before I go down the next message, based on your investigation, was there people who came to the Murray's residence on October 10th?
Yes.
Do you recall about what time that was?
I believe it was somewhere, I believe I was after 9 o'clock, before 10 o'clock, somewhere in that area. I would have to actually review the ring footage to see the actual timestamp of their exact.
But these messages between defendants, this would be before the time that the DTE workers or the people who were dressed up as that came to that residence in Rochester Hills.
These last messages that
Yes,
were
sir.
just read, yes, that is prior to that time period.
And this next message, what's the date and time on that?
The date and time on that is October 10th, 2024 at 11:05 p.m.
And who's sending this message?
That's Mr. Hernandez to Mr. Zuazo's.
What does that say?
States home, bro.
And what about this next message, Detective?
That's Mr. Zuazo to Mr. Hernandez. Good shit. That's October 10th, 2024 at 11:06 p.m.
And as an officer in charge, would that be after the time? Do you remember if this is after the time that the ring video that we reviewed on October 10th at the Rochester Hills?
Yes, that's after the time period.
And this next message, Detective, what time is this at? Date time.
That one is October 10th, 2024 at 11:06 p.m.
And what does that say?
It appears to be a time. It's from Mr. Zuazo to Mr. Hernandez and states 8:45.
And the next message,
Mr. Hernandez to Mr. Zuazo, okay, and that's on October 10th, 2024 at 11:06 p.m.
and Detective Connolly, this next message right here in the middle. What time is that?
The date and time on that one?
Interesting.
That one is October 10th, 2024 at 11:20 p.m.
And who's this message from and to?
That's from Mr. Hernandez to Mr. Zuazo. It states, am I picking you up at 8:45 or you want to be out there by 8:45?
And that's from Defendant Hernandez to Defendant Zuazo.
Yes.
And this next message, Detective, what does that say?
That's from Mr. Zuazo to Mr. Hernandez. That says, be here at 8:45.
What's the date and time on that?
That one is October 11th, 2024. That's at 2:35 a.m.
This next message right at the top in the blue. Can you, the date and time of that, please?
That is October 11th, 2024, 8:47 a.m.
And who is that to?
That's from Mr. Hernandez to Mr. Zuazo. And that says, on my way.
And this next message right here in the green, Detective.
That's from Mr. Zuazo to Mr. Hernandez says, I'm up. And that is on October 11th, 2024 at 8:47 a.m.
And the next message, sir.
For Mr. Hernandez to Mr. Zuazo says, okay, and that's October 11th, 2024 at 8:48 a.m.
And October 11th, 2024, that's the date of the death of Mr. Murray.
Yes, sir.
And while you were sitting here in the courtroom and while you reviewed all that evidence that's often charged, were you aware of that Lowe's surveillance video that was admitted as exhibits?
Yes, sir.
Okay. And this date and timestamp, was that before that Lowe's home video date timestamp?
Yes.
And also, as part of your investigation, did you obtain a cell phone that belonged to Amanda Diaz?
That was obtained by Cato Parish and transported back up here when Detective Wendell Smith and Detective Weedman went down and picked up the property.
Okay, and as the officer in charge, did you alter or request a search warrant for that phone?
That one I believe Detective Weedman did because there was some logistics where we weren't sure when we were going to be able to get the property. So he had initially authored one for Cato Parish to do a search of the phone. Then a secondary one was authored when it was determined that we were going to be bringing it back in a timely manner.
And was that phone searched pursuant to a valid search warrant here in Michigan?
Yes.
Okay. And did you give the cell phone in the same course and manner that you gave defendant Zuazo's phone over to the Oakland County?
That one came in a little bit different because in the they arrived back from Louisiana after driving for hours in the middle of the night. So detectives logged all the property into our property room. Those items were later picked up from the property room and transported over to the computer crimes unit by us.
Was a full cell phone extraction done of Mrs. Diaz's cell phone?
Yes,
Okay. And did you review that cell phone report of Amanda Diaz?
I did.
Okay. And did you go through that phone and review messages between Mr. Hernandez and Mrs. Diaz?
I did.
You know, at this time, the people are going to move and admit people proposed exhibit number 22 at this time, Your Honor.
I have no objection to that.
No, it's not.
And Detective, we're going to kind of have to do the same thing, okay?
Yes, sir.
Yeah, my personal opinion, Cindy,
Okay, this is a copy of the cell.
just my personal opinion, and this is from everything I'm hearing. I think he was ambushed once he got down there, and I think it was probably fairly quick. I believe they both took part in it, and this is just my opinion. I believe they both took part in the crime. I believe they both probably took part in the murder. I don't think one should weigh more than the other in this incident. I think they are equally across the board, no matter who actually broke the hyoid bone, caused the asphyxiation with the blood going into his lungs and all that. It doesn't. They're both culpable and equally responsible, and that's my opinion.
Phone extraction report.
And I only hope for Mr. Murray that it was quick, because that I have heard is a very painful way to go.
Continue. Or created in this for Mrs. Diaz's cell phone?
Yes.
Okay. And who are the participants in this particular cell phone extraction that we're going to go through?
The first one is a contact of and it is the phone number for Carlos Hernandez.
And that's the same cell phone number that we were just reviewing messages between the defendants?
Yes, sir.
Okay. And who is this other participant here?
The other one is the owner phone, which was the phone known to be Amanda Hernandez's, or Amanda Diaz, which was taken in or seized while in Cato Parish.
Okay. And this first message on the top, do I have to do this the same manner? Who is this to and who is this from?
This is from Mr. Hernandez to Amanda, states baby.
Okay. And then the next one?
That's from Amanda to Mr. Hernandez, states, yes, my love.
And this, these next three right here, would this be fair to say, are these from Ms. Amanda Diaz to Mr. Hernandez?
Yes, they appear to be.
Excuse
What's the
me.
first thing to say?
Okay. Now. Okay. Hold up. Okay. I'm gonna take my glasses off. I'm gonna get myself all situated here for a minute, because this, I have, y'all know I don't want you to do this ahead. So this is all me and my mouth, and who knows what I'll get into. What I'm guessing, what are you eating, Lola? So what what I'm guessing is they're fixing to get, just for my sneak peek of these texts, and I hovered over it and I seen, guess what? And the following text said, the badges are here. He scrolled back up and we can't see it. So there goes her involvement and why she still may have charges pending coming against her, because these text messages, God, my finger is so crooked. And every time I see it up against that black chair, I see exactly how crooked it is. Squirrel. These text messages are damning for her. So no wonder she's got charges still maybe possibly coming that we're not sure of yet. Ooh, okay, Amanda. We see you, girl. We see you, Amanda.
States, but I got a free Jackson.
And then the next one.
Guess what?
Okay. And this next one, can you give me the date and time on this one right here?
That is October 1st, 2024 at 1:46 p.m.
And who is that from?
That's from Amanda to Mr. Hernandez.
And what does that message say?
The badges were delivered.
And the next message?
You account still negative, and that's from Amanda to Mr. Hernandez on October 1st, 2024 at 1:50 p.m.
And then this next message, kind of same procedure, date and time.
That one is on September 28th, 2024 at 11:57 a.m. That's from Amanda to Mr. Hernandez. It states, remember what I said. If you have to leave with nothing, that's okay. You're the most important.
And what's the next message?
The next message is from September 28th, 2024 at 11:58 a.m. from Amanda to Mr. Hernandez says, what if he's not home?
And what about the next two messages? Is that responsive from Mr. Hernandez to Mr. Diaz?
Yes, it's from Mr. Hernandez to Amanda. The first one states, I know, baby. The second one states, he will be.
Okay. And what about this message up in blue right here?
Amanda
That's from Mr. Hernandez to Amanda on September 28th, 2024 at 11:58 a.m.
And what does that say?
I'll text you when we make it up there.
And what about this next one, Greg?
That one's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 11:58 a.m. Says, as long as you know your life and freedom is important to
This
me.
girl.
And what about that one?
That's from Amanda to Mr. Hernandez on September 28th, 2024 at 11:58 a.m. States, okay, baby.
And what about this next one?
The next one's from Mr. Hernandez to Amanda. That's going to be September 28th, 2024 at 12:08 p.m. Says, I know it is, baby.
And can you read this next message?
The next one's from Amanda to Mr. Hernandez. It's on September 28th, 2024 at 12:29 p.m. Says, I'm gonna have to buy a hoodie. This weather ain't it.
And the next message is not a response. And then what about this next message, the date and time?
That one is on September 28th, 2024 at 12:44 p.m. from Amanda to Mr. Hernandez. States, turn your phone off when you're out there, just in case.
Shady
next message?
bitch.
The next one's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 12:45 p.m. States, or you think you don't need to.
Ooh.
And then kind of can you read the stop message first?
That's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 1:31 p.m. States, I'm so nervous, but you guys seem to have it down. And I feel better now that you have a good getaway car.
What's the next message?
Next one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:36 p.m. States, I still am really nervous though.
Detective, next one, please.
That's from Mr. Hernandez to Amanda. That's on September 28th, 2024. That's at 1:40 p.m. Mr. Hernandez states, it's going to be okay.
And what about the next one? Right?
That one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:40 p.m. Amanda states, promise.
And can you read the next message?
That one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:57 p.m. States, I've been creeping on you.
And the next one?
That's from Amanda to Mr. Hernandez, September 28th, 2024 at 2:09 p.m. That one states, make sure you don't forget to take the tag off.
Okay. And what about the next one?
That one's from Mr. Hernandez to Amanda on September 28th, 2024 at 2:39 p.m. It appears to be we FKD up.
And the next one, sorry. In this next one right here.
Amanda writes to Mr. Hernandez, what? And that's on September 28th, 2024 at 2:39 p.m.
And this top message here in blue.
That's from Mr. Hernandez to Amanda. That's going to be on September 30th, 2024 at 1:03 a.m. I am, baby.
And this next message is effective.
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:03 a.m. And it states, and make Yogi take it. Don't be doing all the work.
Okay, based on your investigation, this
Make Yogi take it. Don't be doing. She called Joshua Yogi. She's gonna have charges coming. She has to have charges coming. This girl, ma'am. Oh my gosh.
case detective, were you made aware of a stolen vehicle from Dearborn Heights?
Yes, the vehicle that was located burned out in Detroit, as we had heard from Mr. Keelan earlier, was stolen between the time of late the evening of September 29th and the early morning on September 30th.
In this message from Mrs. Diaz to Defender Hernandez says, and make Yogi take it and don't be doing all the work.
Yes.
In fact, can you read this text message right here in the middle?
Yes, that's from Amanda to Mr. Hernandez. That's going to be on September 30th, 2024 at 1:05 a.m. States, makes me mad. It's all on you because you're the brains and then the message ends.
And what about the next one?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:15 a.m. States, where you appears to be going, it's misspelled to get a.
And this next message up here at the top right.
From Amanda to Mr. Hernandez on September 30th, 2024 at 1:18 a.m. States, okay, just be careful. I'll be in the living room.
And the next message.
That's from Mr. Hernandez to Amanda on September 30th, 2024 at 1:18 a.m. Says, okay, I love you.
And the next message and the right here in the green.
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:18 a.m. States, I love you more, husband.
Hey, Tucker, do you read that last message right here at the bottom right here?
That one is from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:42 a.m. That message states, I know you not gonna take a actual DTE car.
Thank you.
So if she knew he wasn't going to take an actual DTE car, so she knew he was going to go out and steal a car to do this crime with, she knows a lot. She was very involved from the beginning, Cindy. She knows more. Ooh, man, he screwed up. I wonder if they have children, just out of curiosity, because when she goes to jail, who's going to take care of the children? It's just a question. I don't know. My mind's roaming now. I've got thoughts, like crazy thoughts now. This couple is just, I don't even, he does have kids, because I remember him stating it in one of his interviews that he had children. Man.
And can you read this message?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 2:05 a.m. States, you good, baby? ?
And what about the next one?
That's from Amanda to Mr. Hernandez. That's September 30th, 2024 at 2:29 a.m. I'm going to go to sleeps.
And detective, this message right here in blue, can you do that for us?
That's from Mr. Hernandez to Amanda. That's September 30th, 2024. It'd be at 2:43 a.m. States, we just got a car.
And this time that stands here on September 30th, does that correspond with the reporting from the Dearborn Heights police report that you guys were?
Yes, it's within the time period that the vehicle was seen and then found to be gone.
And he said, we just got a car.
Yes.
And this next message right here in green?
That's from Amanda to Mr. Hernandez on September 30th, 2024 at 2:43 a.m. States, are you okay?
Can you read this next message?
That's from Amanda to Mr. Hernandez on September 30th, 2024 at 2:43 a.m. States, you driving our car? ?
And what's the response?
From Mr. Hernandez to Amanda on September 30th, 2024 at 2:43 a.m. He responds, yes and yes.
And can you go ahead and read the one in green?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 2:44 a.m. States, Could you please move the
Yes.
cursor? Thank you. You sure there was no cameras around?
And what is the next response?
Mr. Hernandez responds with, yes, I'm sure. That's September 30th, 2024 at 2:46 a.m.
And these next messages, these are just these are just messages from Ms. Diaz to Mrs. Hernandez, or to Mr. Hernandez.
They appear to be.
And were these particular messages just
Irrelevant.
mundane marriage things?
Yes, appear to be.
And this message here in the blue, can you read that?
That's from Mr. Hernandez to Amanda. That's on September 30th at 2024 at 3:07 a.m. States, about to take Yogi home now.
Let's get this without place. And then this message right here, that one of the great.
That's from Amanda to Mr. Hernandez. That's October 1st, 2024 at 2:28 p.m. What else you got to do?
And then what about the response?
Mr. Hernandez to Amanda responds, get this shit. That's October 1st, 2024 at 2:28 p.m.
And what is the response in the green?
Amanda states to Mr. Hernandez, what shit? That's October 1st, 2024, 2:29
This
p.m.
next message down here in the blue is, what is that?
That's from Mr. Hernandez to Amanda, states the signs. That's October 1st, 2024 at 2:29 p.m.
Wow.
These messages have nothing in them.
There was no content in the subreddit to those indicated.
And this one down here in the bottom, can you read that for us?
On October 3rd, 2024 at 5:55 a.m., Amanda writes to Carl or Mr. Hernandez, you're probably going to have to move that truck. Laugh out loud. She's like, that's not stolen, is it?
Where did they park the
And
truck for
read,
somebody? Where did they park the truck that somebody questions that it was there? Yogi, bam, nailed it. I know. I'm thinking, I can see, you know what? Okay. Picture this. Yogi and Boo Boo. Okay. Carlos is actually Yogi because he's the bigger one. I'm sorry. I shouldn't have done that, but I couldn't help it. I just got these two ding dongs running around in the forest. Hey, Boo Boo. Hey, Boo Boo. Hey, Yogi. I don't know. I went there. I'm sorry.
This message right here at the top, detective.
That's from Amanda to Mr. Hernandez on October 3rd, 2024 at 5:55 a.m. States, I told her it was Yogi's.
I'm not going to read these two. And detective, this one on top here, can you read this one?
Amanda writes to Mr. Hernandez, how much money do you have, baby?
You know, she's really put herself out there in these text messages. She knew about the truck. She knew about the signs. She knew everything. So, she's in trouble.
It's October 3rd, 2024 at 3:45 p.m.
And then can you read the next one in this chain?
The next one's from Amanda to Mr. Hernandez on October 3rd, 2024 at 5:13 p.m. States, did you make sure the tracker is out of that truck?
And then can you read these next two messages and give us a date and time?
Amanda writes to Mr. Hernandez on October 3rd, 2024 at 6 p.m. I love you, baby.
And can you read the top one, please?
Amanda writes to Mr. Hernandez on October 3rd, 2024 at 7:13 p.m. OMG, or oh my God.
And what is the response here?
Mr. Hernandez to Amanda is what's wrong, baby? That's October 3rd, 2024 at 7:17 p.m.
And what's right, this one right here, date and time. Can you read this for us?
That's from Amanda to Mr. Hernandez on October 3rd, 2024 at 7:24 p.m. Says, you got to move the truck so we can take the garbage out.
And then this message on top.
Amanda writes to Mr. Hernandez, what do you need it for again? October 4th, 2024 at 6:26 p.m.
And then the next message that's down there.
Mr. Hernandez writes to Amanda on October 4th, 2024, 6:26 p.m. to make the pages and the badges.
So she knew
And then
all
response
about
from,
the paperwork.
Mrs.
She knew
Yes.
all
Amanda
about the
to Mr.
badges.
Hernandez. Okay, October 4th, 2024 at 6:26 p.m.
She knew
And then,
about the
this
truck
one,
decals.
That's Amanda to Mr. Hernandez. That's October 6th, 2024, 8:53 p.m. States, I'm worried.
and then what is the response here include?
Mr. Hernandez to Amanda about what? October 6th, 2024 at 8:53 p.m.
And what about the response agreement?
Amanda states to Mr. Hernandez, our house, October 6th, 2024 at 8:53 p.m.
And of course, the next question I ask you, what about the blue one?
That's for Mr. Hernandez to Amanda states, it's okay, October 6th, 2024 at 8:53 p.m.
And the top one, sir?
Good evening, Christine.
Amanda to Mr. Hernandez, you sure, October 6th, 2024 at 8:53 p.m.
And what about this response in blue?
That's Mr. Hernandez to Amanda, trust me, it's okay, October 6th, 2024, 8:53 p.m.
And do you read the top one?
Amanda to Mr. Hernandez, well, we are only 5 days late on rent, not too bad, ANF, it's 7:54. And that's October 6th, 2024 at 8:54 p.m.
So they were late on their rent and they needed money to pay their rent. And this was what, October 6th? Whoo.
And then what about this message right here in the green?
That's from Amanda to Mr. Hernandez, October 6th, 2024, 8:55 p.m. and states, we just spent too much money in PR. That's what fucked us.
And what about this message here in blue down the bottom?
That one's from Mr. Hernandez to Amanda states, yeah, but it will be okay. Them things will be ready tomorrow, and then we can go do that. That's October 6th, 2024 at 8:56 p.m.
So exactly right there. She knew a lot more. She knew a lot more. I mean, they're even planning it to pay their rent to get this burglary done. Not, mind you, nothing to do with the murder. They just needed the money to pay their rent, obviously.
And then can you read the top one?
That's from Mr. Hernandez to Amanda. I don't know either. That's October 7th, 2024, 9:51 p.m.
And the next one?
Amanda to Mr. Hernandez, you sure you don't need anything else, baby? That's October 8th, 2024 at 12:04 a.m.
And what about that next bottom one?
Mr. Hernandez to Amanda, I don't think so. Them badges would be nice. That's October 8th, 2024 at 12:04 a.m.
Got Yogi and Boo Boo. Say, how you doing there, Boo Boo? How you doing? You can go picnic. Oh my gosh, these two.
And then can you read this bottom one here in green?
That's from Amanda to Mr. Hernandez. Yeah, but I don't know how to make that. Plus, I don't think you need it. I'll look it up. That's October 8th, 2024 at 12:04 a.m.
So he had her. Wait, he had her trying to make the badges. Are you serious? I told y'all she is involved. She is way involved. Amanda Diaz, come on down. You're the next contestant.
And then right here, this message right here in green in the middle, that one is dated October 8, 2024. When you were reviewing the cell phone, did you make a note of this particular text message? Do you recall?
I believe that was a link due to the computer that we have to use to usually view the Cellbrite program. It's not connected to the internet because a lot of times cell phone dumps are used for incidents with child sexually abusive material. So I'm not able to click on that link, but I do recall there being photos inside the phone that showed ID badges.
And can you just read off what that?
That's from Amanda to Carlos. The information in the message states custom ID badge, personalized employee photo identification card, customized plastic ID card for office worker, doctor, nurse, student / no punch hole. And that's on October 8th, 2024 at 12:06 a.m.
And then what is this next message here?
That's from Mr. Hernandez to Amanda. Says something like that with no pictures. October 8th, 2024 at 12:06 a.m.
Okay. And this top message here, can you read that for us?
That's from Mr. Hernandez to Amanda on October 8th, 2024 at 12:07 a.m. states, takes too long to ship. I'm trying to be gone by Thursday.
And that was October.
That was October 8th, 2024 at 12:07 a.m.
Okay. And do you recall what day of the week October 11th of 24 was when you arrived to the house?
I believe that was a Friday.
Okay. And so the night before on 10th, when you reviewed the ring camera, that would have been a Thursday.
Yes.
And can you read this message right here in the middle after that blue one?
That's from Amanda to Mr. Hernandez states, wait, I just needed the link to open my Amazon. That's October 8th, 2024 at 12:08 a.m.
And this one right here in blue, can you read that for us?
That's from Mr. Hernandez to Amanda states, okay, and make one for Yogi. Do his name as Jonathan Wright. That's October 8th, 2024 at 12:12 a.m.
And then what about this one here in blue?
That's from Mr. Hernandez to Amanda states, make him an inspector too. October 8th, 2024 at 12:12 a.m.
An
And what about the next one?
inspector.
Amanda states to Mr. Hernandez, I did. That's October 8th, 2024 at 12:12 a.m.
And this message, these two messages, Luke, can you go ahead and read those?
Both are from Mr. Hernandez to Amanda. The first one states, okay, that was on October 8th, 2024 at 12:13 a.m. The second one states, did you print them? Same date at 12:13 a.m.
Can you read top message and the other blue one underneath that as well?
That's from Mr. Hernandez to Amanda. It states, it's BS. That's October 8th, 2024 at 1:10 a.m.
And what about the next one right here?
That's from Mr. Hernandez to Amanda states, but we will be leaving soon. October 8th, 2024 at 1:10 a.m.
Okay, and I think we just want the green that's right here in the middle.
That's from Amanda to Mr. Hernandez states, I know, baby, but I don't want you rushing this. I don't want anything happening to you. October 8th, 2024, 1:11 a.m.
And what about this message in the blue at the bottom?
That's from Mr. Hernandez to Amanda states, it's going to be okay. October 8th, 2024 at 1:12 a.m.
And the second is top one of the blue, can you read that for us?
It's from Mr. Hernandez to Amanda states, I hope we get enough money to buy a house. October 8th, 2024, 1:14 a.m.
What about this next message in green right here?
That's from Amanda to Mr. Hernandez. Me too, baby. Our own home. October 8th, 2024 at 1:15 a.m.
What kind of money did they think this man had laying around? What kind of money? They thought that they were going to do a robbery and be able to buy a house with what? The cash? How do you think you're just going to go up to somebody and say, here's some cash for a house and it's all good. Give me the, what's wrong with you people? That's not even how you.
What about this next one here in green?
On the same date and time, she also writes no rent. And that's Amanda to Mr. Hernandez.
And what about the response?
Mr. Hernandez, on the same date and time, from Mr. Hernandez to Amanda, yes.
And can you read this one in blue?
That's from Mr. Hernandez to Amanda. States, if what I feel is here, we gun be good. October 8th, 2024 at 1:16 a.m.
What's that response in green?
That's from Amanda to Mr. Hernandez. That's on the same date and time. She replies with, so we can have a nice backyard.
And can you read this one, the green one down at the bottom for us?
That's on the same date and time. That's from Amanda to Mr. Hernandez states, I know I'm like, I wonder what's there.
And then, all right, read those. What's this down here? This blue one. Can you give us a read that? Give us a date time of that.
Well, that's from Mr. Hernandez to Amanda. That's on October 9th, 2024 at 9:17 p.m. States, okay, just pulled up to Yogi's.
And we'll have this message here in green.
That's from Amanda to Mr. Hernandez. States, okay, baby, don't be long. You need to do the truck and sleeps. That's October 9th, 2024 at 9:17 p.m.
And can you read the one in blue?
That's Mr. Hernandez to Amanda on October 9th, 2024 at 9:18 p.m. States, I know.
And what is the response in green?
Amanda responds on the same date and time. Be safe.
And what about the message in blue?
That's from Mr. Hernandez to Amanda. States, always am. That's October 9th, 2024 at 9:19 p.m.
Cindy, just to stop and talk for a minute too, I made ID jet badges for our business. When I had my motorcycle business, we had ID badges and stuff because, I wanted people to know when they came in, they looked down upon me like I shouldn't have been there. And I'm just a secretary, I'm supposed to just take their money and do their receipts and stuff. And I'm like, no, that's not my job. I have a secretary to sit and do invoices and all that. So I made ID badges with my own laminator and stuff, but that was for my business. I would never in any, bless you, son, I never in any mind would even fathom making IDs for somebody else's business. And like you said, your nonprofit volunteers. These people are crazy out there. These people are just crazy. I realize how normal we are when I watch shit like this. Just saying.
Okay. And this top message right here, can you read that for us?
That's from Amanda to Mr. Hernandez. States WYD love, commonly known, what are you doing? That's October 10th, 2024 at 7:09 p.m.
And this message in blue, can you read that for us?
That's from Mr. Hernandez to Amanda. States he's grabbing weed, then we coming back to get the truck. That's October 10th, 2024 at 7:10 p.m.
Okay. And
okay, a little smoke on board makes things go a little smoother.
Before, when they appear on the Murray's porch on October 10th in the evening.
Yes, a couple hours prior.
Especially in green, can you read that for us?
That's from Amanda to Mr. Hernandez. States, okay, baby, you ready and got your head ready? October 10th.
You ready and you got your head ready. Go smoke some weed and get all okay with yourself, and then go do this because you can't do it sober. Excuse me. What are you saying, Amanda? Right, Amanda. Office Depot, Staples, any office supply store. You can just. Oh my good Lord. Get your head in it, Carlos. Come on, go smoke some weed and get your head in it, and then you'll be okay to do this crime and help murder somebody.
2024 at 7:10 p.m.
And what about this message in blue?
That's from Mr. Hernandez to Amanda. States yes. That's October 10th, 2024 at 7:10 p.m.
This one in green, please.
Amanda to Mr. Hernandez. Just be careful. October 10th, 2024 at 7:11 p.m.
And what about this message in blue?
Mr. Hernandez to Amanda. I am. October 10th, 2024 at 7:11 p.m.
And message in green.
Amanda to Mr. Hernandez. Promise. That's the same date and time.
And what about this one in blue?
Mr. Hernandez to Amanda. States promise. October 10th, 2024 at 7:19 p.m.
And message in green.
Amanda to Mr. Hernandez.
She got a Tammy Wynette problem, don't she? She always gonna be standing by her man. She gonna be in a jail cell just like her man too eventually if she ain't careful.
I love you so much. October 10th, 2024 at 7:22 p.m.
And what about the response in blue?
Mr. Hernandez to Amanda. I love you too. October 10th, 2024 at 7:36 p.m.
There got to be some love there to do
What about
this.
this message right here in green? We'll make her serious.
Amanda writes to Mr. Hernandez. You guys are gonna go this late. That's October 10th, 2024 at 7:43 p.m.
And what's the following message?
That's Amanda to Mr. Hernandez. States, remember what I said. Shit seem weird. GTFO, commonly known as get the fuck out. That's October 10th, 2024 at 8:14 p.m.
And then right here on top of the green.
Amanda,
Oh, y'all, I hit the wrong button. I'm sorry. Oh, I hope it goes back to where I was. Oh, shit. I'm sorry. Give me a minute to figure out where we were.
And this message here in the blue, can you read that?
that's from
On the Murray's porch on October 10th in the evening.
yeah.
And what about this next one?
That's from Mr. p.m.
Okay, I think we're at the right spot. Oh, I hit the wrong
And
button.
this one on top.
That's Mr. Hernandez to Amanda. I'll call you when we done. October 10th, 2024 at 8:16 p.m.
And what about this message in green?
That's from Amanda to Mr. Hernandez. States, wear a mask when you get close.
Oh my
October 10th,
God.
2024, 8:16 p.m.
And then what's this message here in green?
Amanda to Mr. Hernandez, okay. October 10th, 2024 at 8:17 p.m.
And what is this message right here?
That's Mr. Hernandez to Amanda, says, I got it on now. October 10th, 2024 at 8:18 p.m.
And again, is this message, this communications before the ring video camera that?
Yes, it appears to be a little bit prior to that.
Can you read this down for us, please?
It's this damn magnifying glass. It's up in my toolbar, and every time I have to click it each time to come back down, and I accidentally click my Adobe image remover. That's what happened.
That's from Amanda to Mr. Hernandez, says, okay, baby, get your head good. October 10th, 2024 at 8:19 p.m.
Devin, can you read the next one, please?
From Amanda to Mr. Hernandez, states, you put the magnets on. October 10th, 2024 at 8:22 p.m.
Next message.
Amanda to Mr. Hernandez, sorry, just checking. October 10th, 2024 at 8:22 p.m.
And the message in blue, detective.
That's from Mr. Hernandez to Amanda, states yes. October 10th, 2024 at 8:27 p.m.
Can you read the stop message right here?
It's from Amanda to Mr. Hernandez, says I love you too. October 10th, 2024 at 8:28 p.m.
And what about this
Uh-oh.
bottom message down here? This one in blue.
That's from Mr. Hernandez to Amanda, states 216 Greendale, October 10th, 2024 at 8:41 p.m.
In this message, there's no list of city. Is that fair to say?
Correct.
Okay. And during your investigation, did the Greendale address become of significance to you?
Yes, it was
Right.
in the general area of where the vehicle was burned. Also, we had obtained video from, I believe the address was 90 Greendale and Highland Park.
And this next
Well, let me comment to this, Cindy. The only thing dumber, they could have printed their own money on a computer. But you know what? As dumb as that would have been, Mr. Hussein Murray would still be alive. Think on that for a moment. I much rather had seen them go to jail for crimes of printing their own money on a computer than taking Mr. Hussein Murray's life. Just saying.
message right here in green, can you read that for us?
That's from Amanda to Mr. Hernandez, that states, that's where I go get the food. That's October 10th, 2024 at 8:41 p.m.
And the next message there.
Mr. Hernandez to Amanda, yes, October 10th, 2024 at 8:41 p.m.
And can you read this top one for us?
It's from Amanda to Mr. Hernandez, states okay. It's October 10th, 2024 at 8:42 p.m.
What's the next message there?
That's from Amanda to Mr. Hernandez, states, are you done? It's October 10th, 2024 at 9:28 p.m.
And this message in blue?
That's Mr. Hernandez to Amanda, states no. That's October 10th, 2024 at 9:29 p.m.
And the next one, sir.
That's from Amanda to Mr. Hernandez, states what happened? October 10th, 2024 at 9:29 p.m.
But we
And
put
with
the
this
comedy,
date time-
we put the comedy in the chaos, right, Hannah? My favorite line. We put the comedy in the chaos. We have to laugh about this in order to keep our own mental health sometimes. You know, unfortunately, yes, Mr. Hussein Murray did pass away. And, you know, they could have made money on a computer and everything, and, you know, not to make light of the situation, but sometimes making light in the situation and Hannah encouraging chaos is us being able to deal with this mentally and making it okay in our own minds. So with that,
Time correspond to after the two people who appeared on the Murray's doorstep left on the.
I believe that's slightly after or right in the
then again, Hannah could be just a rogue member. Hannah's rogue anyways. I love you.
time frame. I would have to view the video to see the actual timestamp.
And what was this top message say?
That's from Mr. Hernandez to Amanda, states, I'll tell you when we get there.
And when is that date?
October 10th, 2024 at 9:29 p.m.
And the next message?
That's Amanda to Mr. Hernandez. You need me to pick you up. That's October 10th, 2024 at 9:29 p.m.
And what about this next one?
That's from Mr. Hernandez to Amanda, states, yes, we did good though. That's October 10th, 2024, 9:29 p.m.
And the next message, detective?
Amanda to Mr. Hernandez. Okay, should I leave? That's October 10th, 2024 at 9:30 p.m.
And can you read this message on top?
That's from Amanda to Mr. Hernandez, says, where do I park to get this food? That's October 10th, 2024 at 10:01 p.m.
And the next message?
8074 Homer. That's October 10th, 2024 at 10:04 p.m.
And was this address at all significant to you?
I don't recall that address being significant or any evidence coming from that specific address.
And then this message right here, can you read the one in green?
That's from Amanda to Mr. Hernandez, states, I just seen a hooker.
And what's
October
the-
10th, 2024 at 10:07 p.m.
And the next response was?
It's from Mr. Hernandez to Amanda, laugh out loud, October 10th, 2024 at 10:07 p.m.
And then can you,
That's Amanda to Mr. Hernandez. Be there in 12 minutes, October 10th, 2024, 10:07 p.m.
and
Then-
that would have been after the October 10th
Yes.
video. Okay. And this next message, can you read that in green?
That's from Amanda to Mr. Hernandez. Wait, don't leave yet. And that's October 11th, 2024 at 9:02 a.m.
And the next message?
Okay. Pause. We went from October 10th at 10:07 p.m. of her coming to pick him up from the first night of the Ring doorbell. From the first night of the Ring doorbell that we've seen video of, that didn't work out to their benefits. And the next text we go to is the morning of the 11th at 9 a.m. Wait, don't leave yet. And we know that it was on the 11th that the murder happened. So, okay.
That's October 11th, 2024 at 9:02 a.m.
And the next message?
That's Mr. Hernandez to Amanda. I already left. October 11th, 2024 at 9:16 a.m.
And this message in green right here, detective.
That's Amanda to Mr. Hernandez. That was before I came upstairs. Laugh out loud. October 11th, 2024, 9:17 a.m.
And can you read the top one?
Amanda to Mr. Hernandez. I know. Hello. LMAO, which is commonly known as laugh my ass off. I saw you leave, silly. October 11th, 2024 at 9:17 a.m.
And what about this message in blue?
That's Mr. Hernandez to Amanda, states, put the hard hats on the porch, please. October 11th, 2024 at 9:17 a.m.
And
The culpability of this woman, right? Case one, hope she gets, I mean, this is just, was she in on planning it? I mean, I'm like, she's so involved, and to have not been charged yet? Goodness.
what about this message in green?
That's Amanda to Mr. Hernandez. Okay, October 11th, 2024 at 9:17 a.m.
And the next message?
It's Amanda to Mr. Hernandez. Where are you parking the Jeep? That's October 11th, 2024, 9:17 a.m.
And what's the message in blue?
Mr. Hernandez to Amanda at the house, October 11th, 2024, 9:18 a.m.
And this message in green?
Amanda to Mr. Hernandez, Warren, that's October 11th, 2024, 9:18 a.m.
And what about the message in blue?
Mr. Hernandez to Amanda, at your mom's. You're gonna have to come get us. October 11th, 2024, 9:18 a.m.
And the next message.
Amanda to Mr. Hernandez. Oh, okay. October 11th, 2024, 9:18 a.m.
And the top message.
Amanda to Mr. Hernandez. I was confused. October 11th, 2024, 9:18 a.m.
And the message in blue.
Mr. Hernandez to Amanda. Okay. October 11th, 2024, 9:19 a.m.
And the message in green right below.
Amanda to Mr. Hernandez. When do you think I'll have to do that? In like 2 hours. That's October 11th, 2024 at 9:19 a.m.
And this next message, sir.
That's from Amanda to Mr. Hernandez. Just bring the keys inside. I'm going to sleep. October 11th, 2024 at 9:59 a.m.
And this top message right here.
Mr. Hernandez to Amanda, you sleep. October 11th, 2024, 10:24 a.m.
And the next message on the page.
That's Amanda to Mr. Hernandez. I was. Why? October 11th, 2024, 10:25 a.m.
And can you read this middle one?
That's Amanda to Mr. Hernandez. Here, October 11th, 2024 at 12:08 p.m.
Okay, Detective. What's the date and time stamp of this bottom message right here?
That is October 11th, 2024 at 3:43 p.m.
And what was this a link to?
This, reading the link, it's from Amanda to Mr. Hernandez. It's from WXYZ, which would, I believe, be Channel 7. And it's a link to a headline that states suspects posing as workers, murder man, duct tape woman at home in Rochester Hills.
Amanda, let me speak. Let me get my mic closer. Let me speak to you, woman to woman, Amanda. Amanda, take a plea. Take a plea deal. Yep. Look, see, look, Denise, she's taking a damn plea. See? I would know. What she better be doing is figuring out who is going to raise their kids, explain to the kid that mommy and daddy were both very, very bad and have to take their punishment. Amanda, take a plea. Take a plea. Otherwise, you're going to be in more trouble than you even think. If this shit goes to trial, you screwed, baby. You screwed. I mean, she put the article in a text message.
Can you read that top message?
Amanda to Mr. Hernandez, what do you want to do? October 11th, 2024 at 3:57 p.m.
And the next message.
That's Mr. Hernandez to Amanda, we need to leave. October 11th, 2024 at 3:57 p.m.
And can you read the next one, please?
Amanda to Mr. Hernandez, we need to get you out of here faster. October 11th, 2024 at 3:58 p.m.
And what's the following message?
That's the same date and time and states, we don't have the money to do it.
Can you read the top message?
So Amanda to Mr. Hernandez states sweating. October 11th, 2024 at 4:41 p.m.
And the next message.
Amanda to Mr. Hernandez, WYA, commonly known as where you at. That's October 11th, 2024 at 4:42 p.m.
And what's this message in blue?
It's Mr. Hernandez to Amanda, driving. October 11th, 2024 at 4:42 p.m.
And what about this message in green?
Amanda to Mr. Hernandez, coming here. October 11th, 2024 at 4:42 p.m.
And this message on top in blue.
That's Mr. Hernandez to Amanda, states, I'll talk to you when I get home. That's October 11th, 2024 at 4:43 p.m.
And what about the message in green?
It's Amanda to Mr. Hernandez. Are we still leaving tomorrow or what? That's October 11th, 2024 at 4:43 p.m.
And this message following one.
That's Amanda to Mr. Hernandez. Call me FT audio. That's FaceTime audio. October 11th, 2024, 5:06 p.m.
And then your review of cell drive extraction reports when it says FaceTime audio, what does that mean?
No, she's
Right, Denise, you're exactly right. She knows charges are coming. She stood before the judge at the beginning of the trial saying she would plead the fifth if called as a witness and was barred from the courtroom as well. Yes, because she sure did. She went in there and the judge talked to her and she said she wasn't going to tell anything. And that I know the prosecutor had mentioned something about possible pending charges or possible charges is coming. Charges. My words are hard today, people. See, look, finish reading, Sheila. Because of pending charges. What is wrong with that word coming out of my mouth today? It is just not working. Pending charges. They didn't want her seeing the proceedings. Yes. Girl, that word is hard for me today. But yeah, so she hasn't been allowed in the courtroom this entire trial. Now, my curiosity, this is being aired on YouTube to the public. Care to guess if she's watching or not? Just a thought. Just a thought.
That's a text message she's requesting. FT usually normally stands for FaceTime, as FaceTime audio is to make the phone call.
Thank you. And then this message down here at the bottom.
Mrs. Amanda, or that's Amanda to Mr. Hernandez. Don't get the plate just in case. October 11th, 2024 at 5:14 p.m.
And then what about the top message?
Amanda to Mr. Hernandez. What if there are cameras you can't see? October 11th, 2024 at 5:14 p.m.
Well, Amanda, that was a smart comment. What if there are cameras you can't see? Yes, because we know there's cameras everywhere and you don't know where they're all at. And they're going to pick your ass up on camera. Let's see, what else did Denise say? She sure is. She shouldn't be. But of course she is. I totally agree. I am sure she is back there watching in her recliner or wherever she may be going, oh, I am in so much trouble. Yeah, I mean, think about it. Told her she couldn't be in the courtroom, but that doesn't mean she's not sitting there watching on YouTube or somewhere else.
And what about the next one?
That's from Amanda to Mr. Hernandez. States, put gas in so it don't look like you drove far. That's October 11th, 2024 at 5:23 p.m.
Like your gas receipts are going to show.
Mr. Hernandez to Amanda, I am. October 11th, 2024, 5:34 p.m.
And the next one.
Amanda to Mr. Hernandez, I'm done. October 11th, 2024 at 5:46 p.m.
I'm done.
And the top one.
Amanda to Mr. Hernandez, I'm so sad, baby. I'm so sad. October 11th, 2024. That's 8:39 p.m.
And the next one.
That's Mr. Hernandez to Amanda. It's going to be okay. October 11th, 2024 at 8:40 p.m.
And then October 11th, 2024, about 8:40 p.m. That was after the homicide at Newcastle.
Yes.
And this message in green.
Amanda to Mr. Hernandez, promise. That's October 11th, 2024 at 8:40 p.m.
And this message in blue.
Mr. Hernandez to Amanda, promise. October 11th, 2024 at 8:40 p.m.
Can you read the top one for us, please?
Amanda to Mr. Hernandez, think it will blow over. That's October 11th, 2024 at 8:40 p.m.
What message in blue?
Mr. Hernandez to Amanda, yes. October 11th, 2024 at 8:40 p.m.
Oh, it blew over. It blew over like turds in a shitstorm maybe blew over because it, nope, you ain't getting out of this.
And can you read that message in green right here?
That's Amanda to Mr. Hernandez, states, I don't think anybody will tell that it's you. That's October 11th, 2020.
So sorry. I'm so sorry. That's a good one. Nobody's going to hold up. Nobody's going to tell that it's you, sweetie, Amanda. Your husband, your man, Carlos, he's a very distinguished looking character. you're going to tell me that you're going to think people are going to see that Ring camera and go, we don't know who this man is. Get the fuck out of here, y'all. Get out of here. I don't think anybody will tell that it's you. Yeah, y'all, look, she's lost her mind. This has gone to Amanda's head. And I'm sorry, I used a different gel today, and I got my hair cut yesterday, and I'm using different gel, and it's making my head itch. I don't like this gel. I need a new gel. I really think it's the gel I use. Oh my gosh. Oh yeah, nothing to see here. Nothing at all. Nope. You're not recognizable. You don't stand out like a sore thumb at your 6'6", and what did they say, 450 pounds? Nope. You don't stand out. We don't.
At 8:41 p.m.
In the message in blue.
Mr. Hernandez to Amanda, I pray not. October 11th, 2020.
Did he get on his knees to say that prayer? I need to know. Did he get on his knees to say that prayer? Come on.
4 at 8:41 p.m.
And can you read the top one right here?
It's Amanda to Mr. Hernandez, states me too. October 11th, 2024 at 8:42 p.m.
And the next one, please.
It's Amanda to Mr. Hernandez. I just got back here. It's October 11th, 2024 at 8:44 p.m.
And also, did you also examine other messages that belong to Mrs. Zuazo's phone as part of your cell phone extraction?
Yes, I did.
And there was other messages that was in his phone that was concerning the crime that you were investigating.
Yes.
Okay. At this time, people are going to move to admit and publish People's Exhibit number 24.
I have received exhibit number 24, no objection.
No objection, Your Honor. 24 is in.
And we're going to do it the same way. It's not going to be as many, but we'll read some of those messages, okay? And this is a copy, fair to say, it's a copy of the self-right extraction form that you were probably given from Detective Voice.
Yes.
Okay. And up here is Joshua Zuazo's
I apologize. I believe this one I actually extracted
You
myself.
actually extracted?
Yes.
And so up here on top is participants Joshua Zuazo and someone by the name of SD in that particular phone.
That is correct.
And then can you, in the same process and procedure we're doing before, can you go ahead and read some of these messages?
Yep.
I'm going to pause there for a second. I need a restroom break, and I don't want to miss any of this. So I'm going to pause. I'm going to play my little song in the background for just a second. I'm going to go use the restroom, and I will be right back, okay? Hold. I promise y'all I will be back. 2 minutes.
You're always online, chasing the thrill. In the dark corners where nightmares are real. Whispers and shadows, stories unfold. Innocence lost and the secrets they hold. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Sensational headlines, the dramas you muse. Capturing moments, the heartbreak you choose. Behind every story, a life to reclaim. Remember the human, not just the name. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. spotlights glow, don't forget to breathe. Disconnect to reconnect, it's okay to leave. Step away, take a break, find some peace of mind. True crime and drama, but balance you'll find. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. More than stories that keep you up at night. Ground yourself, find the light. Everything's alright. Reach out and touch grass, you'll be just fine. Breathe deep, step away. It's your time to shine. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. You're always online, chasing the thrill. In the dark corners where nightmares are real. Whispers and shadows, stories unfold. Innocence lost and the secrets they hold. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Sensational headlines, the dramas you'll muse. Capturing moments, the heartbreak you choose. Behind every story, a life to reclaim.
Okay, sorry. Okay. I'm back. I'm sorry. I couldn't miss anything, but I had to go. We had to release some coffee. We've had a whole mug of coffee. Okay. All right. Got me a new cup of coffee. Okay, we ready? Let's see. Let me get myself all situated here. Got my earphones in. Whew. See, I like this. This kind of shit. This stuff excites me. I know this may sound silly, but reading these text messages and being nosy, it's just me, guys. I'm sorry. Okay, ready? Here we go.
So this one's from Mr. Zuazo to the contact of SD. It says, "You got a second? I need to holler at you on some money shit. You really ain't got to do anything, though." And that was on September 28th, 2024 at 3:37 p.m.
Okay, and this message in blue.
Okay, but who is, they haven't said who SD is. Who's SD? Who's SD? They didn't say.
That's SD responding to Mr. Zuazo. "What's good? Damn, you just blocked me and shit." That's September 28th, 2024 at 10:30 p.m.
And then what's the message on top?
That's from Mr. Zuazo to SD. Says, "I'm not a finisher yet, but by next year, I'll pick up 2 or 3 more different tools." And that's September 30th, 2024, 3:14 p.m.
To SD.
To SD, I apologize.
Oh, no problem. And that next one, if you're in blue.
That's from SD to Mr. Zuazo. Says, "Yeah, I used to do hard surface with DT." That's September 30th, 2024, 3:15 p.m.
What?
And then this next message.
Immediately following, SD writes DTE. That's September 30th, 2024 at 3:15 p.m.
And then this message in blue on top.
That's from SD to Zuazo. Says, "I got all the stickers for you and the DTE helmet and a vest for you guys." That's October 1st, 2020.
Okay, who is SD? Because they're just as involved too. Hold up. I need to know. They have, hush, Google. Sorry, my Google answers me. whoever this SD, they're the ones that got the DTE stuff. They had all the sticker and the helmet and the vest.
24 at 10:49 a.m.
And this message here in green.
That's from Mr. Zuazo to SD, states bet. That's October 1st, 2024, 10:49 a.m.
Okay. And then this message here in green. Can you read that for us?
That's from Mr. Zuazos to SD, states, everything go right, I'll give it to you. That's October 1st, 2024, 10:51 a.m.
And the message in blue.
SD responds with bet. That's October 1st, 2024 at 10:51 a.m.
And then this message between those parts that we're talking about. Can you go
There's all the DTE
It's a
stuff.
screenshot of DTE items. It appears to be vest, hard hats, signs. I do recall there being a photo in the phone that was stored in the phone in the Celebrate program that resembles this exact picture.
Okay, and
That's from SD to Mr. Zuazos, and that's on October 1st, 2024
You're
at
right.
2:12 p.m.
and then this message right here.
That's from SD to Mr. Zuazos. I got it all ready for you guys. That's October 1st, 2024 at 12:12 p.m.
No, that's 2:12 p.m.
And then this
Read that
message on
wrong.
top.
That's from SD to Mr. Zuazos. Got lights for you guys too. That's October 1st, 2024 at 2:34 p.m.
And this message right here in green.
That's from Mr. Zuazos to SD. You can have both if shit goes as planned. That's October 1st, 2024 at 2:52 p.m.
And then the message in blue.
That's from SD to Mr. Zuazos. I hope it does. October 1st, 2024 at 2:56 p.m.
And this message here in green.
Mr. Zuazos to SD states it should. That's October 1st, 2024 at 2:57 p.m.
And while we're speaking of defendant Zuazo, while you're investigating this matter, were you able to determine what Mr. Zuazo's shoe size was?
Yes. During the investigation, we determined that a size 10.5 had been booked into property.
That belonged to the
Mr. Zuazos.
I have no further questions.
Cross-exam, so is it?
Thank you very much. Detective, I know that you've heard me explain to every other witness about the questions I'm going to ask you this morning, but if I don't make myself clear, please tell me that and then I'll rephrase the question.
Yes, sir.
Okay. You mentioned early in your direct testimony this morning about Mr. Zuazo being taken into custody on October the 14th. Is that correct?
I believe that was the date.
Okay, and that would be like the Monday following the Friday where Mr. Murray's and Mrs. Murray's house was, where the incident occurred at their home.
Yes, I believe that was Monday.
And he was arrested, as you understand it, by a group of fugitive apprehension team members.
Yes, I believe so.
And that's a combination of Oakland County Sheriff's deputies and also associated with the United States Marshals Service. Is that
I
correct?
believe so, sir.
And were you present for that?
I was not, sir.
But you received a report that Mr. Zuazo was arrested on that date by that team, correct?
Yes, sir.
And the place where he was arrested was in Plymouth, Michigan. Is that correct?
I do not know the exact location of where the arrest was made. I believe it was Plymouth, but I'm not 100% sure on that.
The place, regardless of the address, was a job site where a house was being built. Is that
Yes,
correct?
I believe it's taken into custody
And-
there.
And there were a number of people that were working at that job site on that day, one of whom was Mr. Zuazo, correct?
Yes, sir.
And so then he was taken into custody. No one knows, I assume, that the rest of those people went back to work, but they didn't go to jail or they weren't taken into custody, correct?
Correct.
And this happened in Michigan, while you don't know the address, somewhere in southeastern Michigan, correct?
Yes, I believe so.
And there wasn't any doubt about Mr. Zuazo being at work, correct?
I I don't know the facts of the actual observation.
You're the officer in charge. You understand, you saw the
I understand he
video
was
of
taken
his
into
arrest.
custody at work. Yes.
And in the background of that arrest where it occurred on a front lawn, there was a house under construction, correct?
Yes.
And the people that were there with him, that were all told to get on the ground at the time of his arrest, were working at that place, correct?
I believe so.
Okay. And so when Mr. Zuazo was arrested, he didn't run away, correct?
I don't believe so.
And he was cooperative to the extent that he obeyed what the commands given to him were by the fugitive apprehension team members, correct?
Yes, I've received no information otherwise.
Okay, thank you. And as I said, or I asked before, that happened in Michigan, not in Louisiana, correct?
Yes, it was in the state of Michigan, sir.
And so now we've seen a number of text messages back and forth between Mr. Zuazo and a person named SD. Did you ever determine who SD was?
We still have been unable to determine. The phone number has come back to multiple different sources. It appears to possibly be some sort of pay-as-you-go phone, which doesn't always have a history associated with it.
So there's our answer. They don't know who SD is. Wow. Oh my gosh. There's somebody still out there. Yes. And I dropped 5 memberships. So they went to Miss Muffins, which is my baby, Becky P, Kathleen Hensel, Rhonda G, and Starfish and Coffee. So welcome in and be sure to sub up to both channels. Interesting. Yes. Congratulations, new members. Always, 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 always. So there we have it. We don't know who SD is. They don't know who SD is. So if they don't know, then we're not going to know. Interesting. Come back to multiple phone numbers have gone through different people and all that because it was a prepaid phone.
That's a lot different than the situation with Amanda Diaz and the phone that she had and used with her husband during
Yes,
the weeks leading up to
Yes, sir.
October 11th, correct? And then would you agree that there are many more text messages that were exchanged between the husband and wife, Amanda Diaz, or the wife and husband, Amanda Diaz and Carlos Hernandez, than the ones that were exchanged between Mr. Zuazo and Mr. Hernandez?
Yes.
Thank you. I don't have any further questions.
Any redirect based on Zuazo's cross?
No, Your Honor.
No. Okay. All right. And so jury A, yes. Okay. We are going to take a break, jury A. It's not quite lunchtime yet for you, but it will be shortly. All right. So just stay in your jury room.
All right, the jury, please. Which one was jury A? So they're sending one of the juries out. So here we go again with separating the juries. So we're separating the juries again. Jury A just left.
Cross-exam Hernandez. Thank you.
So we're going to listen to this before I make any kind of every time I see my pinky finger, it looks horrible. I'm going to quit raising my hands up. Okay, just shut up, Sheila, and hit play.
Good morning for the next 10 minutes.
Good morning.
All right. So as you stated, you are the officer in charge. You've had an opportunity to review all of the discovery that was provided in this case, correct?
Yes, ma'am.
Okay. And you are aware that Mrs. Murray made a 911 call less than 10 minutes after the Ring camera shows the 2 individuals leaving. Is that correct?
I would have to compare I know the call was received around 11:47
Okay.
a.m.
That's what I have as well. Alrighty. You also were able to watch previously and then yesterday in court the interview of Mr. Hernandez, correct?
Yes, ma'am.
Okay. And you heard when Detective Wiegman stated, referring to Zuazo, he's afraid of what you and your people can do to him and his family. Do you remember that statement?
Yes.
Okay. That is not accurate, correct?
I know. I've had a chance to review the tape, and Mr. Zuazo states something along the lines of, I don't know what Carlos has going, but I made reference to protecting his family, but did not, that specific quote that you gave, no, that was not said in his interview.
Okay.
Or attempted interview.
And actually, Mr. Zuazo, was he given an opportunity to have a sit-down interview just like Mr. Hernandez was?
Yes, he was.
He decided not to give an interview, correct?
Correct. He exercised his Miranda rights.
Okay. Now, I want to draw some attention to the text messages, specifically between Mr. Zuazo and Mr. Hernandez. There was no text dealing with anything involving planning a homicide, correct?
I don't recall reading any text that plan a homicide, no.
No conversations about weapons?
No, ma'am.
You testified that some of the messages appeared that they had been deleted by the user in looking at those messages that were found on Mr. Zuazo's phone. Is that correct?
As I stated, Mr. McGarrow pointed out the user deleted. I don't exactly know how that actually works as far as the Cellbrite program. That's outside my realm.
Okay. And as you stated, a user may believe they're deleting something from their phone, but Cellbrite has a little bit of extra power.
From what I understand, there can be messages that are in the background that are not totally deleted from the phone. Yes.
Understood. In talking about the messages between Carlos and his wife, fair to say that the texts are about a larceny or a theft that is about to occur, correct?
It would appear so.
There's text messages like, if you have to leave with nothing, that's okay.
Correct.
I hope we get enough money to buy a house.
Correct.
No messages about a weapon.
I do not recall any.
No messages about planning a homicide, correct?
I do not recall any.
I don't have anything further.
We need to wrap.
Nothing, Your Honor.
Okay, let's bring in our other jury.
When is consent now, Judge?
No, because we'll wait till the jury comes up.
Jury's walking slow today. I'm speeding them up a little bit.
No, Your Honor.
All right, you may step down a second.
Thank you, Your Honor.
People, next witness.
Your Honor, at this time, the people of the state of Michigan rest.
Okay, all right. What I'm going to do now is, you guys are getting your steps in, okay, if nothing else, all right? We're gonna
I just
take
said
a
that.
break, and it's not yet lunch, okay? So take a break, go back to your jury rooms. All right, so the jury, please. Next, we're to close. Any motions for directed verdict?
Your Honor, I have a motion to
Go ahead.
present on behalf of defendant.
Go ahead and try,
Zuazo.
sir.
Your Honor, Mr. Zuazo is charged with first degree felony murder in count 1, and in count 2, unlawful imprisonment of Hussein Murray, and in count 3, unlawful imprisonment of Linda Murray. Your Honor, the first thing that I would like to address is the unlawful imprisonment of Linda Murray, because it's evident from the testimony that she gave that the person who bound her up and had her unlawfully imprisoned was the co-defendant, Mr. Hernandez. She never said anything about Mr. Zuazo apprehending her in any way. And furthermore, she testified that it was Mr. Hernandez who slapped her or smacked her or punched her when she didn't give the answers that he would have liked to have heard regarding where the money, the jewelry, and where the valuable property in the house was located. That seems to be a very clear case of unlawful imprisonment brought against Mr. Hernandez, but certainly not against Mr. Zuazo. And then when we talk about the unlawful imprisonment of Mr. Murray, there's no evidence to say exactly who did all of that. The person who was seen in the videos from the two different hardware stores, Home Depot and Lowe's, that's paying to buy these items that shows up on these receipts is evidently, there is clearly in evidence, Mr. Hernandez, who was taking money out of his pocket, and he's paying for all that. Who else is there? The second person has got either a bottle of Coke or a bottle of some sort of water, that is Gatorade water or something like that. He's not a participant in making any purchase. So those items that were used on Mr. Murray as well as on Mrs. Murray were purchased by the co-defendant, Mr. Hernandez. And so I'm asking for a directed verdict as to both of those counts, and then going directly to the first primary count, first-degree felony murder. I submit that there hasn't been enough evidence presented that would make Mr. Zuazo even be present in the place, in spite of the fact that Ms. Murray did identify Mr. Zuazo as having been present that day, because we have two other witnesses who testified, the police officers who spoke with her soon after this event took place. That was Detective Hagelin on Friday, the 11th of October, and then Detective Wiegman, who testified yesterday about 3 at least interviews he had with her. She didn't give a specific identification, and she didn't give the specifics about this, even the person. The only characteristic she gave about the second participant in the robbery was a person of average build, and that was it. Not 6 foot tall, nothing specific like that, even though that's what she testified to. So that raises the issue of identification. I know I'm going to be receiving an instruction on identification for the jury, but I'm asking here in this motion for a directed verdict that that charge be dismissed, directed verdict of acquittal as well, because of the lack of identification evidence presented during the people's case in chief. I understand that the standard is that you have to view the evidence in the light most favorable to the prosecution. People versus Hampton and all of its progeny stand for that proposition, and I certainly am aware of it, and I'm submitting on behalf of Mr. Zuazo that people haven't met that burden, and it is for that reason I'm asking for him to receive a directed verdict of acquittal on all 3 counts. Thank you.
Okay, all right, thank you, Mr. McCarthy. Ms. Hoffman.
Sir, I wasn't there. There's nothing to see here. I'm not recognizable. I am, no.
I'm asking for a directed verdict only as to the felony murder count. Obviously, as Mr. McCarthy just stated, you're to view the evidence in the light most favorable to the prosecution. But when we look at the elements of first-degree felony murder, obviously the second prong there is the mindset that Mr. Hernandez had at the time. I do not believe that there was any testimony, and that none can be inferred from the testimony that was provided. So I do believe, even in viewing the light most favorable to the prosecution, that count 1 as to felony murder should be a directed verdict.
Okay, thank you. Response by the people?
Judge, everyone knows the standard. This court knows the standard. And at this point in time, I don't believe any of these motions should be granted. The case should go forward to the jury. These are jury issues at this point in time regarding Mr. McCarthy's issue regarding his client, whether or not he was involved with Mrs. Murray's captivity up in the first story. I think 1, there's aiding and abetting, which would indicate that. 2, the defendant's DNA is on those duct tape rolls, as is the other defendants. Both duct tape that is down in the basement is found down there. And also Mrs. Murray indicated that the defendant, Zuazo, wanted to put her in the closet before they left. along with the defendant. So I believe a lot of this is for closing argument. Obviously, they're both ready for closing argument, but to direct a verdict out, I don't believe it's appropriate this time.
Okay, thank you. The court does review motions for directed verdict to the light most favorable to the non-moving parties, which is here is the prosecution. First, we'll start with Mr. Zuazo's motion for directed verdict pursuant to all three counts. Count 1, felony murder. Count 2, unlawful imprisonment. And count 3, unlawful imprisonment. The court finds that there is overwhelming evidence that Mr. Zuazo was a participant in count 1, felony murder, as well as the unlawful restraints of Mr. Murray and Ms. Murray. Of course, the questions as to whether or not he is to be found guilty or not guilty comes down to a question of fact to this jury pool, who is, court is confident will make appropriate decision regarding that. It is beyond me, Mr. Zuazo, that you sat through this trial for this past week and would believe that there would be any chance that this court would direct this verdict in your favor. Same with you, Mr. Hernandez. The evidence is overwhelming as to count 1 that you did partake in a felony murder, and the question is then going to be submitted to your fact finders, who the court is confident will make an appropriate decision as to their verdict. Both motions for directed are denied. Anything else?
Denied.
Your Honor, at this time, I think that we could address the issue of the defense and what will be presented.
Sure.
I have conferred with Mr. Zuazo during the time that I have represented him, and it is my understanding he intends to exercise his right to remain silent, and I would like to have him sworn so that he can inform the court about that.
Yeah, let's do that. Do you have any other witnesses?
The defense will not be presenting any witnesses.
Okay, Mr. Zuazo, stand up so I can get you sworn in, sir. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you. Put your hand down. Tell us your name.
Joshua Zuazo.
You want to ask? Or
Yes.
Go ahead.
Mr. Zuazo, you and I have been working together in your defense since I was appointed to represent you in October of last year, correct?
Yes.
And we have been diligently preparing for this trial that has been conducted during this week, correct?
Yes.
And one of the things that we have discussed is whether you would testify or not testify, correct?
Yes.
You understand that that's a choice that you make. It is not a choice that I make, correct?
Yes.
And you understand that in the event that you were to testify, certain items of your personal background, which are not in evidence right now, would be brought up during cross-examination that would impeach you.
Yes.
And you have made a decision about whether it is, keeping that in mind, that you will testify before the jury assembled to determine the facts in your case, correct?
Yes.
And can you tell Judge Polis what your decision is?
No, Your Honor, I'm not going to testify.
Sir, can you whisper that a little bit louder for him? Hold up. We're going to listen again. Lord. Joshua, pay attention. Pay attention, Joshua. We're talking to you.
Case, correct?
Yes.
And can you tell Judge Polis what your decision is?
No, Your Honor, I'm not going to testify.
Okay, all right, and you need to understand then you have an absolute right to remain silent, you have a constitutional right to remain silent, and you do also have a constitutional right to testify on your own behalf in your trial. Now that you've made the decision not to testify, be confident that this court will read an instruction to your jury that states the fact that you did not testify cannot be used against you in this trial, okay? And at any time you change your mind, I think we're gonna likely take a break between now and when we come back potentially for your closing. If there's any point in time where you change your mind, let your lawyer know, okay?
Yes.
Okay, all right. Ms. Lawson?
Yes.
All right, I'll get Mr. Hernandez sworn in. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Put your hand down. Tell us your name.
Carlos Hernandez.
All right, your lawyer's gonna ask you some questions.
Mr. Hernandez, I have been your attorney from the time that you were arraigned, correct?
Yes.
And we have discussed the fact of whether or not you would testify multiple times.
Yes.
And you understand if you wanted to testify, you do absolutely have that right.
Yes.
But also, if you did take the stand, you would be answering questions from me, but then the prosecution would have a chance to ask you questions. Do you understand that? And you understand also that you have a right to remain silent.
Yes.
And you understand that if you choose to remain silent, the judge would instruct the jury that they cannot use that silence against you.
Yes.
And you were present in voir dire when I actually asked the jurors if they would hold it against you. Do you remember that? Okay. Have you had enough time to make a decision whether or not you would like to testify?
Yes.
Has anyone promised you anything, forced you, or made you feel that you were unable to testify if you truly wanted to?
No.
Is the decision you're going to tell the court your own decision and your own free will?
Yes.
What is your decision? Would you like to testify or would you like to remain silent?
Remain silent.
Okay, and then same with you, Mr. Hernandez. You understand that by making a decision to not testify, you have a constitutional right to remain silent, but you also have a constitutional right to testify on your own behalf in your trial. The court would allow you to do that. Being that you told the court that it is your choice not to testify, be confident in the fact that I will read an instruction to your jury that the fact that you did not testify cannot be used against you. If you change your mind between now and the time before closings, let your lawyer know, and your lawyer will let the court know that you decided to change your mind, okay?
Okay.
All right, okay, thank you.
Your Honor, I do have one jury instruction issue
Judge,
because
just
we're going
one thing.
I'm feeling Morticia today with the black dress and the black sleek hair. I'm seeing Morticia today. Cher would have something more flamboyant and flashy and colorful. So no Cher today. We're on Morticia.
And before we get to the jury instruction, I know you had asked Mr. McCarthy if he intended to present any other witnesses. I don't believe you asked that of Ms.
You're right,
Loft.
you did. Ms. Loft, did you intend on presenting any witnesses?
I do not.
Okay, all right. What's the jury instruction, Michelle?
Your Honor, it's actually 16.4. It's the first degree felony murder. If you're looking at,
And this is in Hernandez finals.
yes.
Hi,
So when
Cindy.
we're
Thank
looking
you for
at the
being here.
actual Michigan model criminal jury instructions that give some instructions as to the use of the particular instruction.
What number is this?
16.4 is labeled
16.04, count one, first degree felony murder,
Yes.
okay?
If you're looking at the Michigan model criminal jury instructions, at the bottom, it says paragraph 5 may be omitted if there is no evidence of justification for excuse, and a jury is not being instructed on manslaughter.
Sir, those boogers were in my ears. Y'all, he blew his nose in my ears. I feel like I need to go clean my ear holes. Oh, that was gross. That was so gross. You hear she even pause. She even paused. Like, what is he doing?
Or any offense less than manslaughter. Here, there has been no evidence that there was some sort of self-defense claim. I'm not asking for those instructions. I don't think 5 is appropriate with the facts and the evidence that have been placed on the record. As to number 6, the model criminal jury instruction states, use 6 or 7 where factually appropriate. 6 states, to establish an attempt, the prosecutor must prove beyond a reasonable doubt, and then it goes to detail that. There has been no attempt established. The evidence clearly shows that individuals went into the home, items were removed. I don't think there's an attempt issue here, and I think that attempt instruction is going to confuse the jury, especially when they're going to be reading this in conjunction with an aiding and abetting instruction. So I am asking that 5 and 6 be struck.
Your Honor, I would join with Ms. Lofton's motion and also advise the court that as a member of the Model Criminal Jury Instructions Committee, this paragraph 5 has been the object of discussion. It is based upon a finding in a Court of Appeals case that is now being reviewed by the Supreme Court. But the Court of Appeals ruling was that it has no business in any of the homicide instructions because there's this not justified, excuse, or done in circumstances to reduce the lesser crime doesn't apply.
I feel like that does apply on the premeditation standard, but I don't see how element 5 applies to this particular fact pattern.
Judge, I don't have any objection if the defense wants 5 removed.
Yeah, because there's been no evidence presented that the killing It's not justified, excused, or done under circumstances that reduce it to a lesser crime. There's no lesser crime. I'll strike 5. Okay, so 6.
Okay, so they reviewed some jury instructions. So I fast forward a little bit. I don't know where we're going. Because y'all know I do this blindly. I enjoy doing it. Evidently, jury is coming back in. And I'm assuming this is where the defense is going to rest. Jury needs to walk faster. They're getting all their steps in today. All of them are going to have like 100% on their pedometers. Okay, everybody sit.
Mr. McCarthy, any witnesses on behalf of Defendant Zuazo?
No, Your Honor, the defense rests.
Thank you. Ms. Lofton, on behalf of Mr. Hernandez?
Your Honor, we have no witnesses, defense rests.
All right, ladies and gentlemen. So at this point, what we're going to do is give a lunch break. It's just almost 12:30. One group of you is going to get a longer lunch break than the other because we're going to try to resume back with closing arguments. Kind of like we had done with openings, those were done at separate times. That's what's going to happen with closings. All right. So I can only anticipate how long I think it's going to be. So please bear with me. I will make sure to let staff let you know if it's going to be longer than that. But because we all need to take a break right now, I am going to allow jury B, that's you guys, to go to lunch now for, it is 12:30. Let's say to be back in your jury room for an hour and a half. All right, so be back in your jury room at 2. Okay, so 2 p.m. for jury B. And then jury A, does 30 or 45 minutes sound okay for a break? Is that good? Long enough for a lunch? Okay, so then it's 12:30.
Right? No witnesses. So we are going to Zoom because as we see, they go to lunch and we just see all this. Hold up. I've seen a flash of court. I've seen a flash of court. Here it goes. I don't know what's happening. Let's see. They come back in. Okay.
Seated.
Common People versus Joshua Zuazo, case number 2024-291950 FC.
John Petrofess and Andrew McGarrett on behalf of the people.
Good afternoon, Your Honor. Michael McCarthy, P30169, appearing on behalf of the with Joshua Zuazo. Mr. Zuazo is standing next to me and to my left at the table.
All right, sir, tell me your name.
Joshua Zuazo.
Okay, we're ready for closings.
Yes, sir.
And we've gone through instructions and everyone's satisfied with the packet. That's
Yes,
in
Your
there
Honor.
on
The attorneys thank your staff for helping during the lunchtime break.
Oh, they'll appreciate that.
And
They were running
join.
around. Yeah, okay.
Yeah, that's right.
Thank you. I appreciate that. So I believe all your jurors are, Mr. Zuazo's jurors are back, so we will bring them in, get right into it, and then instruct them.
So we're going to do Joshua's jury first. So I guess they're going to hear a different closing statement from the state instead of the same closing. Interesting. Okay. Okay.
Please the court. Counsel. Good
Okay,
afternoon.
we're closing.
All the evidence, testimony, text messages are now before you. The case is going to soon be yours to decide when Judge Polis gives you the law to take back there. You'll have a written copy to read through. I was watching something just the other day, actually on YouTube. The guy was talking about perception versus perspective. And he was talking about how we go through life. Normally, we're looking at things as you go through it through your own perception. You know, you're seeing the events around you, the people around you. But there's also perspective, which is how are those folks looking at you? And that's stepping outside yourself and looking back. And I really thought about that coming into today's closing argument, because my perception doesn't matter. If it was my perception that mattered, I think I don't even need to make a closing argument. But that isn't what matters. What matters is your perception of the case, and that I don't know. So what we're going to talk about are things I think are important when you go forward, but it's impossible, and I'm not going to, and there's no way to do in 20, 30 minutes everything that we've discussed. It's impossible. We all have faith that you took notes. We all have faith that you paid attention. So go back and rely on that when you go forward. Now, we talked from the start about what this case is about and what this case isn't about. And from the start in jury selection, what we said is this is first-degree murder, but it's not first-degree premeditated murder. And we discussed that from the beginning. And Judge Polis will instruct you on what this is, which is first-degree felony murder. And that means, and the people have never said anything different, nor has law enforcement, that this was an intentional killing when they showed up on the doorstep on October 11th of 2024. And the judge will instruct you on the law, which is now before all the attorneys. And I'm not going to go through, there's a stack that Judge Polis will read to you, which there's no point going through it twice. But what you have to focus on regarding first-degree felony murder was that the defendants intended to commit a larceny, and that during that larceny, they caused the death of Mr. Murray by either intending to kill him or intending to do great bodily harm to him, or creating a high risk that death or bodily harm could occur. And then the judge is going to instruct you about aiding and abetting, which we also talked about. And it'll say anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. Now, I believe the facts have shown there were 3 people in that basement. Okay, and Mr. Murray is not able to talk about what happened in that basement. But I think the facts have shown throughout this, and I think the text messages tied everything in together even more, that from before, during, and after, these defendants had planned to commit a larceny at Mr. Murray's house. And each of them played different roles and different parts, but each of those parts were going together for that same mission, for lack of a better term. And you'll hear and you've heard that defendant Hernandez started a year before with his contact with Mr. Murray. He had personal contact at his pawn shop in Hamtramck a year before, October of 2023, where he was engaged in making pawns with Mr. Murray's shop. And then you heard, and you have the records, that in February of 2024, Mr. Hernandez appears again. And when he appears again, not only does he take some things out of pawn, but he asks to speak with Mr. Murray face to face. And Mr. Murray came over, shook his hand, looked him in the eye, and talked to the co-defendant Hernandez. And the other interesting part of that, because there are little bits that maybe don't seem that important, and maybe they're not, that's for you to decide. But what is Hernandez in there looking at? He's in there looking at Rolexes. What does Mr. Murray wear? He wears a Rolex. What does Mr. Murray have on him? He has jewelry. After that day, and as things went forward, you've seen the text messages, you've heard the connection between the 2 co-defendants, and it's a substantial connection. These are not Facebook friends who never hang out. These are not high school friends that only see each other at reunions once every 5 years. These 2 have had a close connection, and it continued throughout this time. And I think there's proof of that through witnesses and through the text messages. You heard from Ms. Diaz when she testified how the defendant, Zuazo, was going to be in the wedding in September of 2024. You heard from Ms. Diaz that she knows him by the nickname of Yogi. You heard from Ms. Diaz that she identifies the defendant that morning of October 11th when he's in the Lowe's with co-defendant Hernandez. You've heard as the testimony, the text, everything else is played out. You have lots of videos to show that they put their plan in place to physically start making it happen probably about 20 days before the murder. And you hear that through the text and through their actions. You start seeing the text that you now have today about we need a car between Hernandez and this defendant. And they go back and forth about getting a car. Why do they need a car? Well, they need a car because they want to get away with it, first of all. And they're going to do that by disguising the vehicle that they drive and then disguising themselves. They're going to disguise that vehicle after they steal it. And you've heard testimony from the victim of that theft about his car being left out and it gone, which coincides exactly with the text that you have now. You also saw a text that indicate that you need to disguise it with DTE materials. And you saw not just Hernandez walking in on video into that store to order up those signs for the sign of the car, but you saw this defendant text messaging his buddy, whether it's a male or female buddy, I don't know, but the buddy to get DTE products to disguise themselves. They go a step further, and that's to get rid of the plate, which was a very distinguished plate on the back of that truck, that POCO plate. And they got a DTE plate stolen from a DTE vehicle to make it even more unlikely that they're going to get caught if that vehicle is identified or if it shows up on a flock camera. Like everyone here now knows, is taking pictures of a lot of plates. Well, it would have come back with the DTE plate. And that disguise, as you heard, was so effective on October 11th that even Miss Niehaus, as she's walking her dog, and she said, my attention's drawn to that vehicle, first by the sound of it, but then it just seemed to be slow rolling through the neighborhood. And she said, I finally looked up and I saw it was marked as DTE. And I said, oh, it's DTE coming through to do something. And she was no longer concerned about the vehicle. Well, that's what these defendants intended. Now, you have the videos, you have the purchases at Home Depot, at Lowe's. They were getting the things that they were planning to use when they were going to get into Mr. and Mrs. Murray's house. They wanted duct tape, they wanted zip ties, they were disguising themselves as workers with different things that they purchased also at those stores. They were ready, but there was one thing that they could not buy at any hardware store for that day. And that was the will to do what was necessary. That will to go into that house and do what was necessary, you can't purchase that at a store. That came from in here. They were ready to go. And on that October 10th, when they drove there, it was this time of year, it is dark. You've got all the text before and after. And as they drive there, 40-minute, 45-minute drive, no one gets out of the vehicle. No one talks themselves out of doing what they're about to do. They're ready. They're planning, and as you saw through the text, Mr. Hernandez wants to buy a house. Mr. Zuazo is talking about needing a big score. And they had this impression that inside that house was going to be their big score. As they get to the house, and as you've heard, they approach the house, Mr. Hernandez in front, posing as DTE workers with Mr. Zuazo right behind him. And that does not, is captured on Ring video. There's the knock on the door, which catches everybody's attention inside. Mrs. Murray said she gets it on her Ring video from her phone, and Sam is already downstairs and heads towards the door. She's upstairs, and she's paying attention. So Sam opens the door, defendant Hernandez with the co-defendant right behind him. They're trying to talk their way into the house. Mrs. Murray says, it's a little late to be doing a gas check. And then she says, Sam, do you have your gun on you? And she said, I said it loud so it could be heard. Mr. Murray doesn't want to let him in, isn't going to let him in, and doesn't let him in. Mr. Hernandez says, we'll be back tomorrow. So they leave that night, and then they have a 40-minute drive back to where they came from. Did anybody decide not to go forward with this the next day? No, there was a different type of discussion. And there's unanswered questions that we talked about in jury selection. Some of those unanswered questions don't matter, okay? It only matters if it goes to what we need to prove in these elements. One of the unanswered questions is, why didn't they force their way in? Okay, well, they didn't force their way in is what happened. But if you remember the positioning, Sam is downstairs. He is not a small man. He's 6 foot tall. He's 300 pounds. Hernandez is in the doorway, okay? And it's been told that he's armed. Could they have gotten to Sam before he pulled his gun? Could they gotten to Sam before he backed up and pulled his gun? I don't know. But what I do know is if they had come in that house, they could not have gotten to Mrs. Murray upstairs on that balcony before she called 911. There was no way they were getting to her before that call was placed. So they leave to regroup, and they regroup. They don't cancel it. They don't say there's Ring cameras, I'm not going to do it. They don't say the guy is 6 foot and 300 pounds. He may be a problem. No, instead they revise the plan. The plan.
Y'all, there's nothing to see here. There's no problem. Nothing at all. Just move along.
Doesn't get canceled. How do they revise the plan? Well, now they go first thing in the morning to Lowe's to get the 18-inch zip ties. So they're upping what they expect they're going to need to subdue Mr. Murray. The duct tape no longer is enough. They need zip ties, and those are the same length zip ties that the detectives described that is in the bloody scene in the basement. They have the drive back. No one gets out of the car. They both arrive. And as they arrive this time, when they're at the front door, which is captured on the Ring video, they're able to trick Mr. Murray into opening that door. Mr. Murray goes to the door, as you've heard. He lets them in, as you've heard. And Mrs. Murray is there watching this. She says it sounded like Mr. Hernandez was going to go outside, but he didn't. And you also heard that defendant Zuazo starts lingering around where the dryer is, which is a gas dryer. So they start going downstairs. And what's important to note is the little pieces of things, which you have, I'm sure you have. So Sam goes down the stairs first. Who's following Sam? This defendant, not Hernandez. The first one to go downstairs behind Sam is this defendant. The first defendant who's going to encounter Mr. Murray is this defendant. And Hernandez goes down behind him. The door is closed. And you know some of what happens next. We don't know all of what happens next because Mr. Murray isn't here to tell us. What you hear next is defendant Hernandez comes up and he immediately confronts Mrs. Murray, who's right there. She doesn't hear anything for that 10 or 15 minutes, no screams, no shouts, no commotion. But she sees Hernandez, and he starts with, where's the safe, where's the money, where's the jewelry? And obviously, that conversation triggers the realization that these are not DT workers, that this is a problem. And she answers immediately, we don't have a safe, the money's in the purse, there's no real jewelry here. It's upstairs. And you hear at that point in time, defendant Zuazo comes upstairs. And when he comes upstairs, Sam isn't with him. And when Mrs. Murray sees Zuazo, she asks, where's my husband? And she's asking, where's my husband? And he comes up and hears that. Hernandez doesn't say anything in response to that. Zuazo does. And what he chooses to say is he's sleeping. And at that point, she sees the blood on this defendant's chest and she starts screaming. Hernandez immediately punches her on the left side of the face, as you've seen the photos and as you've heard in testimony. And what else does Mrs. Murray say that is important? And as you look back through everything, all that we ever want is for you to use your common sense about what makes sense, what doesn't make sense. And what makes sense is exactly what she says. She says she sees his whole face because the mask is no longer in position. And what makes sense about that, because he's tried to disguise his face with the mask, both on the 10th and on the 11th, but why it's not in place anymore is because he had just been in a struggle with Mr. Murray down in the basement. And that mask had been moved and dislodged during that life and death struggle. And that life and death struggle was just Mr. Murray's life and death. These defendants were never concerned about their life or death. And if you heard, the only blood, there's DNA from the defendants. There's never any blood from the defendants. The only blood that you see, and there's a lot, is from Mr. Murray. Now, she sees his face, she describes him to the police officer, she describes the facial hair, and you heard the officer yesterday testify when he was arrested, he had facial hair. And then you've seen the Lowe's video from that morning where the defendant is there with Mr. Hernandez with facial hair, with the bucket hat that's later found. So does that end it? Does the defendant head for the door? Does he say, I'm getting out of here? No. Where does he head? He heads upstairs to continue the mission, which is to find the jewels or this treasure that doesn't exist. So he goes upstairs, and you heard that when he goes upstairs, those rooms are ransacked. You saw those rooms are ransacked. The costume jewelry is every place. And you also heard Mrs. Murray testify that Hernandez never went upstairs. Only this defendant went upstairs. And what else is upstairs? The victim's blood on that swipe on the wall. Because there's so much blood that was downstairs, the defendant got the blood on him and left it upstairs. As that's going on, Mr. Hernandez is still looking for items, trying to get into the purse, trying to take the car keys, taking the cell phone, taking all these things. And the gun is missing. Gun's never been found. Last time it was seen, it was going downstairs with Mr. Murray. That gun is missing. Mrs. Murray tells you that she's bound up by the duct tape. You saw how Sam is bound up in the basement. He's not just bound up with duct tape, he's bound up with the zip ties that they had just purchased. And then you hear this defendant returns from upstairs, wanting to go. We need to go. But what does he want to do? This defendant, he wants to put Mrs. Murray in the closet. He wants to put her in the closet before they go. And he starts trying to do it with Hernandez, but she's duct taped in a position that she can't be moved into the closet. So as much as they tried to even do more, they weren't able to. So they depart and flee. It's not over because they got to try to get away with the little that actual value that they took. The only thing of value that they took that day was Mr. Murray's life. That's the only thing of value that was taken. The rest was junk. What do they got to do? They got to go get that truck down in Detroit. And you saw the text messages where it sounds like it's pre-planned. You hear that they set that truck on fire to burn its contents, burn any DNA that's inside the truck. And then it's time to get out of there. Hernandez gets home. You've heard the testimony that he quickly packs up that Jeep, packs up his wife, packs up her child, and they start headed down south. Now, when they get down south, they don't have much of a drive before law enforcement is quickly on them. Law enforcement finds a lot of objects of value that are later processed. You've heard about all those objects, which include the 13 size shoe, which is Mr. Hernandez. And in fact, the video, you can clearly see he's wearing those Nikes in one of those videos. You also have the brown boots that are size 11 that are not able to fit Mr. Hernandez's foot. And you also heard today that the defendant's shoe size is 10 and a half. And I don't know about anybody else who buys shoes, but my shoe size range it's a large range between what brand you buy. 10 and a half, 11, 10, they all can fit the same foot, as everyone knows out of their own common sense. So they find the bucket hat that belongs and is seen on the defendant. You also find the jewelry items that were taken by the defendant. All of those things plus more are found in that vehicle. Now, at that point in time, the attention of the sheriff's office has quickly been focused on Mr. Hernandez and this defendant also. You heard from Mr. Broad, who calls into the sheriff's office and says, I know that guy. He testified yesterday. I know that guy. I worked with that guy. He identifies him from the video. He identifies the clothing from the video, and he identifies those boots being consistent with the type of boots that are used at their scene. So then you hear more gruesome details today from the medical examiner about the manner that Mr. Murray was killed. Those photos show a lot of light about what happened in that basement. It was a brutal beating, a multiple hit beating, a beating that could certainly have occurred with two people, regardless of their size. But when we talked about the Rolex, it's important when I think about things about how did it physically transpire. He has two strikes to the back of his head from a blunt object, consistent with a gun, consistent with a lot of other objects that could cause that type of injury. Okay, so Sam goes down. You know, they ask for the safe, maybe. He's not giving an answer, maybe. He says, I don't have anything, maybe. But you know that conversation occurs. It occurs upstairs, and they don't like that answer either. So Sam is struck and he's bleeding, but he's not quitting. You heard Mrs. Murray talk about he's a strong man. You've heard he's a big man, and he's not unconscious, because if he's unconscious, how could I say that? I wasn't there. Well, because it doesn't make sense with the rest of the facts in the case. If he's unconscious, you don't have to bind him up like that. You don't have to duct tape him. You don't have to duct tape his mouth. You don't have to zip tie him. This is a struggle at a minimum with Mr. Murray and the two defendants. And what else do you hear? That as much as Mr. Hernandez loves Rolexes, as much as the only thing of financial value in that whole scene that day was probably that Rolex, what happens during the struggle? The struggle occurs to the point where he's duct taped and zip tied where you can't even get to the Rolex. If he was unconscious, if he wasn't there, the first thing that comes off is the Rolex. Maybe they try to get the ring off, but the thing of value is that Rolex. Can't even get to it, but they don't care because they're in a struggle with him. Now, that beating had many injuries to Mr. Murray that you've heard about. And we talked to the medical examiner about the compression to the throat and about if someone's struggling to break that compression, whether it's a knee, a hand, a foot, you know, it would reset your clock. You know, if someone's trying to choke you, you knock it away, it resets the clock, keep doing it. So I believe it's taking two people to try to restrain Mr. Murray. And that fact is borne out by the fact that you have blood on both defendants. There's no version where any defendant left that basement before that violence occurred. Impossible, because you're not getting blood on your boots, you're not getting blood on your Nikes, you're not getting blood on your shirt. both shirts because the T-shirt Mr. Hernandez is tested also has the DNA on the blood. So that battle is going on down there. And, you know, I try to think about it like just normal life, okay? I have a brother 4 years younger, okay? So growing up as kids, when we would roughhouse, wrestle, things like that, there was a point in time where I could get both of his wrists in one hand and I could put him down with one hand and hold him in place. And then I had one hand free. That stopped when we were about 12 years old. I could no longer control him with one hand. There was no way one person was controlling Mr. Murray all by themselves to both tie him up, keep him in a position, do all that. That doesn't seem to me to be reasonable. I think Mr. McCarthy is going to say a few things at this point. Give him your direct, full attention like you have throughout this trial, and then I'll have a few minutes afterwards to address what he says.
Thank you. Mr. McCarthy.
Thank you. Good afternoon. I want to thank you, first of all, for paying attention during the course of this trial. I talked about that in my opening statement. I think I may have touched on it a little bit while we were conducting the jury selection on Monday, but I did for sure talk about it in opening statement about how important it is to pay attention so that the 12 of you that are ultimately chosen to go back into the jury room and deliberate will have all the information you need in order to actively participate in those discussions. And I'm convinced that all 13 of you here present today, this afternoon, have fulfilled the solemn obligation of your oath. And on behalf of Joshua Zuazo, I thank you for having done so. And now it is, in a short time, going to be your opportunity as well as your obligation to do the one thing that brings us all together here, to discuss the one thing that brought us all together here this entire week. And that is to determine what the facts are. As I said in my opening, I'll repeat again, that a trial is a search for the truth. And you all are the truth finders. You are the people who are going to make a determination based upon the evidence presented during this trial of what that truth actually is. And then ultimately the practical reality of those decisions that you make in coming together and determining the truth is going to be whether you find that there's been evidence presented to the high standard of proof beyond a reasonable doubt to convince you that Mr. Zuazo is guilty of any one of these three crimes with which he is charged and for which he has undergone a trial before yourselves. First degree felony murder, unlawful imprisonment of Hussein Murray, and unlawful imprisonment of Linda Murray. One of the things that impressed me about the evidence that we have heard, and one of the things that I told you in the very beginning of the trial, is that this is about identification. And I understand Mr. Petrofess's argument, and he is attempting to convince you beyond a reasonable doubt that that second person who's there with Carlos Hernandez in the Murray home on the 10th day of October in the evening, and on the following morning, the 11th of October of last year, is Mr. Zuazo. But there's quite a difference between what you're able to perceive in all of the videos that have been shown to you, in which, are exhibits, and you are all welcome, as Judge Polis will tell you, any exhibits that you want to see, you're going to be able to see again and go through them. And I encourage you to do that very thing, especially from that Friday when it's daylight and you can see. And take a good look at who that second person is. And ask yourself, is that really proof beyond a reasonable doubt that it's Joshua Zuazo, or is it somebody else? Because when it comes to identification, besides what you can see just in little clips from those videos, comes from Mrs. Murray and Kelly Broad. He testified yesterday. I believe it was yesterday, it might have been Wednesday, but whichever day it was, he testified during the trial, and he is the person who used to be Mr. Zuazo's supervisor, 2 levels up from him, but some sort of a boss at the St. Mary Cement Company. And I don't know about you, but I had a little difficulty following what he was saying. I know he was here for a reason. First of all, he was subpoenaed, so he's obligated to be here, but he was here to make sure that who he says had threatened him when he fired him got convicted in this crime. He says that he knows it's Mr. Zuazo because in the video, he is wearing Wolverine steel-toed boots given to him by St. Mary Cement Company. And he's wearing safety glasses. Prescription, he says, given to Mr. Zuazo by St. Mary Cement Company. So the thing that I ask you to do is scrutinize what he had to say. And the reason I say that is because in the instruction that the judge is going to give to you a second time, she's already given this to you once before the evidence presentation began, is about witnesses and sizing up the witnesses and making a determination about who do you believe. And one of those things that she's going to repeat is words to this effect about, does the witness try to actually answer the questions, or does the witness argue with the lawyer? And I would add this, does the witness ask the question presented? Now, I've been doing this job of representing people in trial and conducting litigation in civil matters as well as criminal matters for 45 years. And so I consider myself pretty capable of keeping people on point and getting them to answer their question that I put before him. Ask yourself in your memory how many times I had to repeat a question and ask him to answer the question that I put to him. Was he honestly trying to answer the lawyer's questions, or was he arguing with the lawyer? And this is a huge piece of evidence that is presented specifically to fill in some gaps about who that second person is and make it be Joshua Zuazo. I submit to you that Kelly Broad was not honestly trying to answer the questions. He was here with an agenda. He claims that Mr. Zuazo threatened his life, but he never reported that to the police. And he says that he can tell that these are Wolverine boots. The fact is, when I asked him the question, I says, well, all you can see is down at the bottom. The person who's wearing those shoes is wearing long pants. How can you tell all these things? Well, he just knows that that's true. Well, if that's so true, and the people's theory about Mr. Zuazo's presence at that place, the home of the Murrays, then how come there aren't some brown Wolverine steel-toed boots in Mr. Zuazo's house when it is subjected to a thorough search? Why aren't those steel-toed Wolverine boots that Mr. Broad is so certain were present in that video in the Jeep that is racing from Michigan to Texas and is stopped in Louisiana? Those are Timberline boots. And there's no evidence that those are Mr. Zuazo's boots. There's no DNA in those boots that says it is Joshua Zuazo's DNA. There is DNA that says that the blood on top of one of those 2 boots is Mr. Murray's. No question about that. Who is to say, what evidence is there that is reliable that it's Joshua Zuazo whose feet were in that boot? Where is this shirt that Mr. Broad claims he recognizes as a St. Mary Cement shirt or covering, whatever it was, this yellow looking thing that you can see in the video? How do you know that that's from St. Mary? When I told him that there was this in the video that I watched of him, on his shirt, he had a name tag, or the company name is what he said. I couldn't see it very clearly in the video I watched. But he explained, yeah, he says that's St. Mary Cement Company says that on this green patch. And then he adds in, well, of course, those can be easily removed. Okay, well, there wasn't one of those on that shirt. And he claims there's this thing on the shirt, though, that says fire repellent. I think was the two words, FP or FR. And so there would be some kind of safety shirt that the St. Mary people have. He claims he can see that in that video. I encourage you to take a good look at that and see whether that's what you see. Or is what you see a name tag holder, a clip of some sort, something like all of you have for your jury badges up there on that shirt that this second person was wearing, and not some initials from the St. Mary Cement Company, but just the clip to hold on to the fake DTE Energy tag. Question of fact for you to decide. Then we have the fact that the other person making an identification of Mr. Zuazo is Mrs. Murray. She's a compelling witness. And who among us would ever want to be in her shoes? And this was without question, and she honestly answered this for me when I cross-examined her a couple of days ago, the terrible, traumatic situation, an experience that she's never had before, of course, and is living with to this day, and cannot get it out of her mind, and thinks about it all the time, and certainly has it on the forefront of her mind because she had to come here and give this testimony. And she's here present and has been throughout the time that has passed since the time she gave her testimony. And so one of the other instructions you're going to get is that you cannot let sympathy or bias or any human emotion enter into your decision making. And I ask you to think about the two witnesses from the Oakland County Sheriff's Department who testified yesterday, Deputy Hagelin and Deputy Wigman, about the description of the second individual that Mrs. Murray gave when they conducted interviews with her. Deputy Hagelin was not the first person who saw her. That was Deputy Copeland, who was the first man on the scene. And his interaction with her was rather brief, and he got her out of harm's way, or at least where he hoped it was going to be out of harm's way, so that he could summon more deputies, and he didn't have much interaction with her. Deputy Hagelin took her and put her into a vehicle, a police vehicle, for her own safety, and to give her an opportunity to be sitting down and out of all of the activity that was going on in her home, and talk to her. And what she told him was that it was a person of average size, black male, but a person of average size. Didn't give any specifics. That was the same thing that she said to Detective Wigman, who saw her more often. He saw her in the hospital emergency room on the 11th and then of October. And then he said two or three or four other meetings after she was discharged from the hospital that day, in the following days. And those meetings were conducted in the home of her son. But never once did she give a description to say that Zuazo, or this second person rather, who she has now identified as Mr. Zuazo, was 6 foot tall. It was always a black male of average size. Now, she was specific in her description to Detective Wigman about who is, we know, Mr. Hernandez. Very tall and fat, very fat. One of the pieces of evidence that's been admitted during the course of this trial is that when Mr. Hernandez was racing away from Michigan to Texas, where he thought he could hide out until he was stopped by the Cato Parish Sheriff's Department in Louisiana, Shreveport, he got taken.
Caddo Parish, sir. Caddo Parish.
Taken into custody, and as is the custom or the protocol for putting a person into custody and incarcerating them, they take some statistics or information regarding that individual, and they have him booked in at 6'6" and 450 pounds. Now, going to the basement of the home of the Murrays on the morning of October the 11th of last year, there was a person weighing 450 pounds who was very capable of squeezing the life out of Hussein Murray by using his foot, using his knee, using his hand, because no matter how you press down, what part of your body, when you're that big, you press down with your knee, your foot, your hand, you're going to have 450 pounds backing you up. And that is a tremendous amount of weight. So when we have this compression, because that's the cause of the death, is his neck compression, not only does Mr. Murray have a fractured jaw, but he has his hyoid bone right up here in the top of his neck. And that is an essential thing you need in order to be able to stay alive. His gets fractured not in one place, but in two spots. It's crushed by somebody's sustained effort to do that. Why is that going on? Who is intent about doing that? Well, I would suggest to you that the person who's text messaging back and forth between himself and his new bride, Mr. Hernandez, talking about getting a house, hope we have a good score. She's helping him plot this crime that he's committing. And remember, it isn't just a house, our house. Starting out, this young married couple with this dream of having a house will go out and commit a crime that includes a murder in order to have one. But also, not just any house. Look at those text messages that were admitted, I think, as exhibit number 22, but they're all in there. A house with a nice yard. I don't know why the plotter, the planner, who's up to her eyeballs in this thing, Amanda Diaz Hernandez, the new bride, is not sitting over here at the defense table. But that's not my decision to make. But if anybody is involved in a conspiracy to commit this robbery, this stealing of property from a person who they know to be, they being Hernandez and his wife, to be a man of property because he owns a jewelry store and he owns a
What just happened? I have no clue what just happened.
in Hamtramck, and then he's out there scoping out the house, and you can all see, as bad as the pictures are, given the circumstances under which they were taken, the home, the Murray home, on the 10th day of October was a beautiful place where the upstairs wasn't ransacked. And you can tell they had very nice furnishings and everything was properly appointed. And it was a big house with not one, but two stairways. So they've got this man targeted. And you heard Mr. Petrofessa say that Hernandez was over in that pawn shop asking to talk to and meet Mr. Murray. Why is he doing all that? You got any evidence presented to you about Joshua Zuazo pawning stuff at this place, going in, asking to talk to the owner? No. And who is the man in the forefront all the time? It's Hernandez. He's the guy right up there to the front door. He's the guy with the clipboard. And when the police come and they do the search at that house in Lincoln Park that mother, Danielle Diaz, who had the bad leg, was here yesterday with a giant chip on her shoulder, a little difficult to talk to also. When they come and they do that search, among other things, they find the DTE Energy cutouts designed by apparently one of the two of them, or maybe both of them, worked on it together, a kind of a joint project of the young married couple, so they can have their dream house. And that's not in Mr. Zuazo's house. It got searched thoroughly. You don't see one piece of evidence in this trial that came from Mr. Zuazo's house. But there's a lot that came from Hernandez's house. How about that white shirt in the back seat of the Jeep, or the back of the Jeep, that's got Mr. Murray's blood on it? Now, I made a point, and I'm not trying to make fun of somebody because they're overweight or big. I mean, this is only because it's an essential fact in this case.
Sir is going to talk about the big man behind the pole. He's going to talk about it. He's going there, guys. He's going there.
It's a 6X, and his DNA, Hernandez, is in the collar, of the shirt. And if it's his shirt, then that just makes perfectly good sense. But the blood, that is Mr. Murray's. There are no clothing items. There is no evidence that connects Mr. Zuazo to Mr. Murray's blood, period. There are shoes, size 13, in the back seat or in the back of that Jeep that are taken into custody by the Cato Parish Sheriff's Department and then handed over to the Oakland County, Michigan Sheriff's Office. And those are analyzed. We had the testimony from the DNA witness here, I believe it was yesterday, Ms. Ramirez, and it's up in the octillions, for one in so many octillion that it's Mr. Murray's blood on Mr. Hernandez's shoe. There's the black gloves. There's black gloves seen by Mr. Hernandez, or on Mr. Hernandez during the crime. And what do we have in the back seat? His DNA inside those black gloves. No question he was there. No question that this horrible crime was committed and that he is responsible for it. And this whole idea of all this was supposed to be as a robbery. Well, I can't tell you what's in somebody's mind any more than Mr. Petrofesic can on the day that this happened, this horrible, tragic, criminal thing occurred. I don't know what Mr. Hernandez is planning on doing, but I do know that while there's no doubt, no reasonable doubt, that he is responsible for all of those things that happen, there is no such evidence beyond a reasonable doubt that it's Mr. Zuazo. Let's look at one other video. It's at the Lowe's. It's at 9:30 in the morning, and it's down in Allen Park, I believe. And that video shows Mr. Hernandez walking around inside the store, and then he's buying items, and then he pays for those items. There's another person with him. The people allege and argue that it is Mr. Zuazo wearing this bucket hat. And the bucket hat gets found in the back seat of this Jeep. Now, I'm not much of a hat wearer. I have a couple of baseball hats, but that's about it. I understand, though, that there are people that like that type of style of hat. And I guess in sunlight or sunshine, warm days, maybe it's a good thing to have, keep your face from being burned up or your neck. Well, whatever the reason somebody's wearing it, if it was Mr. Zuazo, you would think that there would be some DNA on that hat, on the inside of that hat, hat for this person who's wearing it, if in fact that's who it was. We don't have that in evidence. We don't know whose hat that was. We don't know who was wearing it. We don't even know really whether the person who was wearing that hat left that hat in the back of the Jeep. But we have one other thing, and that is a number of items taken from the Murray home, stolen. Any of those at Mr. Zuazo's house? Any item from the robbery, the larceny rather, that took place as the predicate felony to charge first-degree felony murder in the hands of or anywhere near where Mr. Zuazo was? No. Let's talk a little bit about leaving town. This Mrs. Diaz, the mother, Danielle, testifying yesterday. She doesn't really know when they left. They were going to leave. They were always going to be leaving. But, all of a sudden they were going to be leaving maybe that day. She was asleep because she works these long hours. So she doesn't want to give you too much information. She surely wasn't, I would say, a cooperative witness. I wouldn't tell you that she lied, absolutely, but I wouldn't put a lot of faith in what she had to say. But I got thinking about the newlyweds, and what I didn't hear about from either one of them, even though they have this desire to have their own house, is that either one of them had a job. We got some text messages about being behind on the rent by 5 days on the house down in Texas, or the apartment, or whatever kind of a residence it is. And then, the response is, yeah, well, we spent all that money in PR, which I imagine is Puerto Rico, but I don't really know, probably the honeymoon. And so no job, no means of getting the dream house or even putting food on the table. What's going on here with Mr. Zuazo? Where is he when he gets arrested? Monday morning, October the 14th, or maybe it's the afternoon, but sometime on that day when the fugitive apprehension team comes to the job site where he's working. He didn't leave town. He didn't go anywhere. He's here, easy to find. The only reason they find him is because of this Kelly Broad coming in with his chip on his shoulder to identify him and say, well, I think this is the guy. Getting even for whatever it was that he's not happy about. But Mr. Zuazo's not down in Cato Parish, Louisiana, heading to Texas. He's not getting on a plane to fly to Europe or something like that. He didn't go anywhere. Well, now why would he just be sticking around while Hernandez has gotten out before the day is over? He's on the road heading home because he doesn't have a guilty conscience. He didn't do anything. He's got nothing to run from. Let's go back to Lowe's. 9:30 in the morning. You have this video. Maybe it's Mr. Zuazo in there. That's going to be for you to decide. Let's say, for argument's sake, that it was him. That doesn't prove that he went anywhere beyond that place where that store where Mr. Hernandez made the purchases or paid for whatever it was he got. And what do you see with Zuazo? What's he got? Bottle of pop. Look at those videos. Or a bottle of something. I can't tell you it's pop. Look at those two receipts, the one from Lowe's, the one from Home Depot. There's some sort of drink in both of them. There isn't any question that these men know each other. The question is, were they there together that day at the Murray house? Are they both responsible? And certainly Hernandez was. But is Mr. Zuazo with them then? Not at 9:30. There's no crime committed at 9:30 in the morning down in Allen Park. Is he responsible for the wrongdoing in which Mr. Hernandez was engaged at 11:30 to noon later that same day, the 14th day of October? That's the question. That is the key question of fact in this case. Now, in the instructions you're going to receive, you've heard this once before, and you'll hear it one more time by Judge Polis when she gives her final instructions. But it's the instruction about presumption of innocence, burden of proof, and reasonable doubt. And I ask you to keep this in mind because she's going to say this to you. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. And then it goes on to say a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful consideration and careful and considered examination of the facts and circumstances of the case. This is essential to making a determination of the truth here. You have to be firmly convinced that Mr. Zuazo is guilty of any one of these three crimes, because the same standard applies to each crime charged, and you have to consider each crime charged individually. But no matter which one you're deliberating upon at a given time during those deliberations or discussing, think about that. You have to be firmly convinced that he's guilty beyond a reasonable doubt. We haven't seen that level of proof. Firmly convinced. There's a big question here raised about identification. And I told you in the beginning that this would be the key to the defense presented. They have the right guy. And when she instructs you on this particular point of law, Judge Polis is going to say, among other things, in deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. So in the case of Mrs. Murray, this has particular relevance because her state of mind at the time would be one of terror. Whose state of mind wouldn't be that way? She had interactions with the police. They were back to see her multiple times. She's the only eyewitness. So she's a very important person. And I think it would be very difficult if I was a detective investigating this case to have to bringing up this wound with Mrs. Murray so soon after it happened and asking for more details. But they have nowhere else to go to get this information. And in the back and forth, the trading information, she comes to have an understanding of who it is that the other suspect is. And so she's able, without question, you know, when she testified here very clearly, she's able to use names. She knows who the defendants are without question. And she can certainly identify Hernandez. But I submit to you that she has adopted an understanding that Mr. Zuazo, because he is the defendant, is actually the person who was there at her house. She's testifying honestly. She's simply mistaken. And I think that that is a common enough thing that can happen to a person who's a victim of a crime. And even if she wasn't a victim herself, although she was or is, for the unlawful imprisonment perpetrated by Hernandez, who tied her up with duct tape, she's got all that trauma to deal with. So that could have an effect on her ability to recount the events completely accurately and to be able to identify Mr. Zuazo. Now, there's something about blood on the sleeve of the person, the second person, but we don't have that in evidence. So we don't know whatever happened to that sleeve, the shirt it was on. It's just not before you. It's something that was seen. And there's another thing, there's some blood on a wall upstairs, a blood mark. I didn't hear any evidence about any DNA being taken from that stain on the wall. So while one might, under circumstantial evidence, because you'll get an instruction on that as well, be able to say, well, you know, this is a blood mark up there, and there's this horrible thing that happened, and maybe that blood is Mr. Murray's blood. And maybe it is, and maybe something happened where some accident occurred and there was some blood that ended up on a wall that didn't get cleaned up immediately. I mean, I know there's been things in my own home that have gotten messed up that didn't get cleaned up immediately. Sometimes you don't notice something, and it's quite another when the police investigators, I think that Ms. Myra testified to like 15 people being there on the afternoon and into the evening of the 14th of October last year. They're going to see everything. They're looking everywhere. But how long that was there, we don't have any testimony to that. We certainly didn't hear Ms. Murray say, well, you know what? I never had anything like that there before. It wasn't there that day. That wasn't the testimony. At least it wasn't touched upon. Reasonable doubt. Whoever went upstairs did ransack the place. It's all terrible. It's a horrible tragedy. I, even though I'm an advocate for Mr. Zuazo, because I'm not a juror, can at least allow myself to have compassion or sympathy for Mrs. Murray. You all can't do that while you're deliberating and thinking about what the facts are. You have to use what I told you about in opening statement, or my opening statement, is that cold-eyed calculation to come to a determination of what the truth is. I know that's what you're going to do when you deliberate. I appreciate all the attention that you've paid to me here this afternoon, all the time, that you have, all the attention you paid during the course of what is now the fourth day of our trial, all 4 days. I've done everything that I can do for Joshua Zuazo. I'm going to sit down in a minute. Mr. Petrofessa is going to get up and attempt to poke holes in what I've just told you here this afternoon, because that's the way the system works. He gets to talk twice and I only get to talk once because he has the burden of proof. And so he gets the opportunity to give a rebuttal argument. And that's the way the rules work, and it's perfectly fine. I'm confident in that burden of proof business, and I am very confident in proof beyond a reasonable doubt that you will find Mr. Zuazo that hasn't been proved against him and that he would be found not guilty. But when Mr. Petrofessa makes his points, I ask you to keep in mind those things that you anticipate after I've talked so long that I would have said, given an opportunity.
You have talked long, sir. You're putting me to sleep.
And as I told you a moment ago, I've done
And it's not easy to put me to sleep. So the fact that he is making my head hurt
with you
and making
and
me tired, I think he's
your
just like
capable
babbling
hands.
at this point. I'm here.
Thank you. Thank you, Your Honor.
I agree with the cart. Let's cough. Everybody cough. Wake up. Breathe a minute. Oh, he was just rattling forever. Okay. Everybody. Take a break. Lola, what are you biting? Oh, okay. She's being good. Hi, baby. You want to come be seen? Okay. Everybody, Lola wants to be seen. Baby wants to be seen. Okay. Okay. Everybody, now that we've had a breather, whoo, back to court.
My goal now is to stop talking about 60 seconds before everyone stops listening. You've heard a lot. It's been very.
His goal is to stop 60 seconds before everybody stops listening. Sir, that would have been like 20 minutes ago when Mr. McCarthy was putting us all to sleep. Oh, goodness. Okay.
Very intense. The closing arguments have been long and also intense. So let me start by saying, in a response that wasn't how I was planning to say it. Mr. McCarthy, I've known for a long time. He's an excellent attorney. He's an ethical attorney. He would never intentionally mislead you from something that has occurred during the trial. A lot of stuff happened yesterday. A lot of DNA evidence came in, and I believe Mr. McCarthy misspoke just now in his closing. Mr. McCarthy said that blood swipe upstairs was never DNA tested. It was DNA
Yes, it was.
tested. That was in the lab test number 5 that we had testimony about yesterday. It's exhibit number 8E. It's the upstairs wall swipe, and it comes back to the victim, Sam.
Right.
You have the report, and that's
And
it. And I don't believe.
You know what?
and-
I'm going to even say I missed him even misspeaking that, because I'm not going to lie. He was putting me to sleep, guys. He was making me so tired. I was doing everything I could to stay awake. So yeah, and I can imagine if I'm doing it, imagine what the jury's feeling.
The same thing, if I misspeak on something, it's not intentional. I know Mr. McCarthy's wasn't intentional, but what he said wasn't correct. That was tested. Now, a couple other things that he mentioned was about missing evidence. Well, you know what the defendants did as soon as they left the residence that day. That was to go destroy evidence. So I don't know what was burnt up in the vehicle, but they attempted to burn up the vehicle, destroy DNA evidence. You know, a lot of things weren't recovered that were taken. Cell phones weren't recovered. The pistol wasn't recovered. The cash wasn't recovered. And Mr. Hernandez left town immediately because he had someplace else to go. This defendant was still here, but he had several days knowing what was going on, knowing what was in the paper and on the media to get rid of any evidence that he may still have had, so it wouldn't be as residents with the sheriff's office showed up. So it's not surprising that there wasn't any additional evidence that was found there at the house. Now, there's certain things that when we talk about Mrs. Murray, when we talk about the witnesses, that it's beyond common sense. It's beyond reason when you're looking at things. It's impossible. Just certain things about this identification of this defendant would be impossible to have happen if it wasn't accurate. I don't have to prove impossibility beyond impossibility, but it's actually impossible in my estimation regarding Mrs. Murray's identification. She says, square away, I saw his face when the mask dropped. She says that. She identifies the defendant. She identifies him under oath back in December of last year, says, I recognize him from the house. Okay. Now, what's impossible about that identification if it's a misidentification? Well, what's impossible about that misidentification when she says it a year ago, when she says it under oath? What's impossible for Mrs. Murray to know? It's impossible for Mrs. Murray to know that the defendant's DNA is going to be found in the basement of her house. That's impossible. And if you notice, the one thing we didn't hear, although we had opportunity to discuss anything, was anything about the defendant's DNA on that duct tape. Two sets of duct tape in the basement of that house. That wasn't discussed. That's identification. What else is impossible? Well, when Mrs. Murray is making that identification, she doesn't know if there's a connection between Hernandez and him. She doesn't know that they go back. She doesn't know that there's all these text messages. What if the investigation went back and it wasn't that? What if the investigation went back and it was somebody else's DNA in the basement? To discredit that identification? No, everything that goes forward says this is the right guy. And what else you have that can't be created? Mrs. Murray doesn't know that Ms. Diaz is going to know the defendant, that she's going to know the defendant and his connection with Hernandez. It's impossible for that connection to have been known by Mrs. Murray when she made her identification. It's impossible. And what else is impossible is that Mr. Broad
when he testifies, he says, yes, I also know him by Yogi. Impossible for him to know that Mrs. Diaz, who's also going to identify him, knows him as Yogi. It's going to be impossible that he knows the connection with Hernandez. Hernandez is the obvious guy on the video, but he doesn't know that. He never has talked about Hernandez, but he knows the defendant. It's the rest of the investigation that brings everything together, that all these are connected to the defendant. It was also said at one point that on October 11th at 9:30, he hadn't done anything wrong. You've seen the planning that had gone through this case way before the 11th. You had seen the planning that this defendant did to get the DTE items, to get the helmet, to get everything else that was needed to be impersonating DTE officers to get into that house. So we're supposed to believe that somehow he does all this preparation work, that somehow he's identified by all these witnesses, but somehow there was somebody else who was there with Hernandez on the night of the 10th. And then suddenly that person disappears and he's the one who goes with them to Lowe's. And then suddenly he disappears again. That's not reasonable, and that's not what the facts are. I'm going to end it here, but I believe when you go back, you're going to conclude this is the other person who was there, as the testimony, the DNA has said, and that the defendant is guilty as charged on all counts. Thank you.
Okay, thank you. Members of the jury, the evidence and arguments in this case are finished. I'm going to now instruct you on the law. That is, or did the witness seem I apologize. Obviously, my estimate.
Any through support? Counsel? Good afternoon. There's been a lot of evidence, a lot of testimony, experts who've testified. It's been a very intense 3 days. I understand that. Ms. Lofton understands that. And as I stand here before you, I'm always thinking about what do I say at the end of the case when I know you've all paid attention. I know you've taken notes. And I actually saw something on TikTok last week that made me think about this, which was the guy was talking about the difference as you go through life between your perception of things, which is how you walk through life and you look from your set of view to what's going on around you. You see your family, friends, work. That's your perception. But there's the perspective. If you step out of yourself to look back at you in that picture, you in the group of everything that's going on around you. And that's really what I think about now, because from my perception, I don't need to make any closing argument at all. I believe you've paid attention. The judge is going to give you the law. I really don't need to say much more than what you already know. But I don't have your perception of what's going on. I can't assume that. So I'm going to say a few things about the case and see if I can address things efficiently. I'm not going to go through everything that you've heard in depth because we could take another hour to go through the text messages like we did this morning. You've paid attention. I'm going to try not to be redundant on things that you've already incorporated in your view of what's been going on in this courtroom for the last 3 days. The judge will instruct you on the law, and we talked about it in jury selection, and it is a first-degree murder case. But to be very clear, it is not a premeditated first-degree murder case. That is, I don't have to prove premeditation. I don't have to prove that on the night of October 10th or the day of October 11th last year, they intended to kill Mr. Murray. That's not what this charge is. That's not part of my proofs. All I have to show regarding felony murder is that on that day, on October 11th, their intent was to commit a larceny. And then in the commission of that larceny, as they were doing that larceny, as the judge will instruct you,
The death of Mr. Murray was either because they intended to kill him, or they intended to do great bodily harm, or created a very high risk of death or great bodily harm in that commission of the larceny. And you're also going to hear, which we also discussed during jury selection, anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. And as you know from everything that's been presented, on October 11th, 3 people went down into that basement, but only 2 people returned from that basement. And I cannot tell you what Mr. Murray saw because he's not here. I will tell you that what you've seen in this case, especially today with the text messages, I believe it shows very clearly that this was a plan both before, between the defendants, during, and then after. And the plan was to get rich by robbing the Murray's home that day. They had a belief, which was false, that there was a lot of valuable things in that house. And there wasn't. The only thing of value that was taken on October 11th was Mr. Murray's life. It's the only thing of value. The rest of it is almost junk as far as value. A cell phone, some cash, junk. But that's what their intent was. And that intent, as you've heard, started in the process, in the works a year earlier in 2023 in October, almost exactly a year earlier, when this defendant started to have his dealings with the pawn shop of Mr. Murray and Hamtramck. He would go to that pawn shop, he would pawn items, he would get cash, he would have contact with that pawn store. And then you heard in February of 2024, he returned. And when he returned in 2024, as you heard from Hannah Hussein, he asked, as he was looking at the Rolexes, and the Rolexes, I think, have a secondary importance when you see what happened and what you saw happen at the scene. He sees the Rolexes, he spends a lot of time, 10 minutes looking at the Rolex case, and then he asks her to see the owner. And she brings the owner to him. And the owner looks him in the eye, shakes his hand, introduces himself as he's wearing a Rolex, as he has a necklace on. And that's a solid identification of how the first connection between the defendant and the victim occurs. And you heard in that statement that was played yesterday, when he's paddling everything he can to stay above water down in Cato Parish, and he throws out there, because the detectives don't have everything at that point. It's very fast. The investigation happened. It was successful, identifying the defendant very quickly. And part of it is from the obvious. You don't have to have known the defendant for your entire life to see that Ring video and say, oh, that's the defendant. Very distinctive. The focus was on him quickly. But in Cato, if you remember what he starts saying, well, this was set up by some third guy. He starts coming up with this. He was identified, the victim was identified by a third guy. No, it's not a truthful story, and you're trying to get yourself as far away from what happened as possible. In fact, you knew the victim directly. You saw the victim directly. And at that store, as you heard, Mr. Murray's Audi was always parked in the same location outside that store, visible to folks who would come and go, just like it was parked visibly in front of his house. You hear that as time develops, and he's back here in 2024, in September, you start seeing very clearly by text between the two defendants about creating this plan to get into Mr. Murray's home. And they also intend to get away with it. They're not trying to get caught. They plan on getting out of there. And what, as you see through the text, tightly linking it, what are they going to do to get out of there? The first text between the defendant and Zuazo
and also Amanda, has to do with stealing a vehicle. He texts, we need to steal a car. Okay, why is that? Well, because he doesn't want to show up in Rochester Hills in their in their Jeep with their plate on that Jeep that can be tracked back. As we all know, the Flock system tracks plates like that these days. I had no idea Lowe's tracks plates like that these days also. So license plates are a very quick way for law enforcement to identify folks. So they're on it. They're planning to steal a vehicle. And then, in fact, as you hear from the owner of that pickup truck, his vehicle was stolen, I think, on September 30th of last year from out in front of the house. So now they have that vehicle, but that vehicle has a very identifiable plate. Poco was the company name. Poco is part of the plate. So to disguise it another level, a DTE license plate gets stolen to put onto that vehicle. Poco is replaced for an actual DTE plate. That's the level of disguise that is going through. And that disguise is to get in the house and to get out of the house without getting caught. Now, you've seen the text as it progresses. The defendant is coming up with ways to make that truck look like a DTE vehicle. He is going in person on video to order that DTE nameplate for the sides of the truck. As he's doing that, he's sending those samples, his proofs of what it's going to look like to the co-defendant. And as he does that, he's also on video picking it up. The poor guy who owns the sign company was so afraid that he was somehow involved with a homicide, he immediately calls the sheriff's department after it takes place. So then you hear what else they're doing to try to disguise their appearance. They're going to Home Depot, they're going to Lowe's, they're getting other type of work materials that would look like they're DTE people to disguise themselves. You see Zuazo is communicating with one of his buddies who actually worked with DTE and had DTE equipment and helmets to get that as part of their plan. And then they're ordering at Home Depot duct tape. And after they get the duct tape, you'll hear that the plan is in place now. They're basically ready to go. But there's something that they weren't able to prepare for and buy at Home Depot or Lowe's, something they needed to accomplish that. And that something was the will to do whatever was necessary to get into that house and to commit that larceny. That will to do that comes from in here. That you can't buy. So equipped with all the things that they have pre-planned, they head to Rochester Hills on October 10th, late. They have an entire long drive to get to Rochester Hills. They don't turn around. They don't leave. They don't decide not to do it. They show up at 10 o'clock. And when they go to that door, which has Ring cameras, and I think you'll remember in passing, the deputy within seconds of getting there, before he's even been inside, he says there's Ring cameras all around this house. They're that visible. They're not secret Ring cameras. So you're on Ring camera. And as they get to this house, who's leading the way to the door? This defendant. He's at the door first. He's the one who's making contact. He's the one who's the knock on the door. And Mrs. Murray's alerted on her phone because everything bounces to the phone from Ring camera. And Mr. Murray is downstairs while she's already upstairs getting ready for bed. And as he goes to the door and answers the door, and there's the defendant with the co-defendant behind him, dressed like DTE, trying to disguise their face with the mask that they're wearing. So we're here to check the gas leak. We need to get in the house. And Mrs. Murray, who's hearing this from upstairs, says, "Isn't it a little late for a gas check?" And the defendant continues talking to Mr. Murray. And she yells down, "Sam, do you have your gun on you?" And she said it loud enough with the intent for the folks at the door to hear it. And we know that her husband did have a gun and that he would carry that gun. So as that's being said, her husband isn't letting him in at 10 o'clock. There's no smell of gas in the house. So, no, I'm not letting you in. And the defendant has a clipboard to make it look like they're there to get permission and consent. It's even part of their text messages about making it look like there's a consent form when you go to the door. More ways to trick the Murrays into letting them in. It wasn't happening on the 10th. The defendant says, we'll be back tomorrow. And he leaves. And that door shuts. And we've talked about before in jury selection, unanswered questions. And there's unanswered questions about why did they leave that night on the 10th? And those questions don't have to do with the elements to prove about what happened on the 11th. But, you know, when you're opening that door and you've heard Mr. Murray is not a small person, 6 foot tall, nearly 300 pounds. And then you hear it accompanied by Mrs. Murray saying, do you have your gun on you? So now you have the defendant who's the first one closest to Mr. Murray. So in those moments, was there a calculation that he was not going to be able to get to Mr. Murray before Mr. Murray could back up and pull his weapon? Was there a calculation that if there was going to be a struggle, it was going to take a while? And you also heard that Mrs. Murray was at the top of the stairs. And I don't know what calculation could have happened if they had gone in at that moment, but there was no way they were getting up those stairs to Mrs. Murray on the second floor before she dialed 911. No way. There wasn't any way to accomplish that. So they leave and they drive back, a long drive back. And in that drive back, do they decide we're not doing this again tomorrow? This is a mistake. Do they decide that we're not gonna go against the ring cameras? We're not gonna go against Mr. Murray. We're not gonna go against the potential that he's armed. We're not gonna go against the Oakland County Sheriff's Department if they're called. We're not gonna go against the law. Do they decide that this is a bad decision? No. Instead, they're already texting that night between the two of them about the plan for tomorrow. What time am I gonna get picked up at? And they also decide that whatever they brought on that first trip on the 10th, it wasn't enough. The plan had changed after seeing Mr. Murray at the door. Now they wanted the extra long zip ties. And those are the extra long zip ties you see, unfortunately, in that gruesome scene in the basement. Those are the extra long zip ties that you see were put into a position where it could be used like a handcuffs left on the floor because they never got that far with that set of zip ties. And at 9:30 the next morning, the defendant is back to picking up the co-defendant and headed to Lowe's. And they're headed to Lowe's to make that purchase of those zip ties and take another run. They're not going to be thwarted from getting into that house. Nothing is going to stop them from going through that house looking for riches that don't exist. And they show up that next morning at about 11. And they show up in that DTE vehicle. And you'll remember Mrs. Nyhouse, who's walking her dogs, says, I noticed a sound, and I wasn't really, it's just a weird vehicle sound. And, I look over and I finally see this slow rolling vehicle, but it's marked with DTE. And at that point, I wasn't concerned anymore because I figured they were there just going through the neighborhood. Yes, they were successful. They had tricked the neighbor into thinking it was a legitimate DTE vehicle. So now they get out of the vehicle and go up to the Murray's home to trick them to get into the house. And unfortunately, this time it worked. And you'll hear how, once again, Hernandez is leading the way through that door. And you heard again how they're saying they're there for a gas leak, which doesn't exist. And then you hear that once they get into the house, they want to get down into the basement. For some reason, they think the safe is down in the basement. So once inside the house, as you hear, Mr. Murray goes down first, the co-defendant goes down second, and then the defendant is following behind. And Mrs. Murray doesn't think anything is off at this point. She goes back to the kitchen to continue making breakfast. She says she's there 10 or 15 minutes, doesn't hear anything from downstairs, doesn't hear a commotion, doesn't hear a scream, doesn't hear anything. And as that 15 minutes goes by, she's finished with her breakfast making, and up comes defendant Hernandez first. And defendant Hernandez comes up from downstairs. They're close to each other, and he starts immediately, where's the safe? Where's the money? Where's the jewels? Now, it's instantly apparent that this is no longer a DTE visit. And she starts saying, we don't have much cash. I got $300 that's in my purse. Where's the safe? We don't have a safe. There's no safe here. Where's the jewels? There's no valuable jewelry here. He continues asking about that. And within seconds, up comes Zuazo, as she said. There was a very brief time period difference, not very long at all. And as she's asked about, where's my husband, Zuazo shows up. And she says, where's my husband? And he says, well, he's sleeping. And then she sees the blood on his front of his shirt that he's wearing. And she immediately starts screaming. And what does the defendant do? He hauls off 6'5", 450 pounds, and punches her on the left side of the face. You saw her injuries that were later photographed. That's a real hit. Are you going to keep screaming? No. So then what does he do? He starts to duct tape her. The larceny is still going. The larceny isn't over. They got a gun off of Mr. Murray down in the basement. They got his gun. We know that. And defendant Zuazo goes upstairs and starts ransacking because they're still looking for things to steal. The defendant is going through her purse, taking cell phones, taking cash, going through kitchen drawers to find those things. Larceny's not over. He doesn't go running out of the door. Zuazo doesn't go running out of the door saying, this is over, this is ridiculous. No, they're continuing with the plan. And that plan was, as you saw in the text messages, the defendant wants to buy a house with what they expect to get from this larceny. They want to buy a house. They don't want to work hard and save up for it and do all the things that you have to do to be able to buy a house. They want to go in there and steal for a house. They want to go in there, and if it takes ending Mr. Murray's life to get that money for a house, so be it. And as you hear, she's getting duct taped up by the defendant. Zuazo comes down with the drawer of jewelry. And then what? You think that it's over then? No. They both want to put her in a closet before they leave. Let's put her in the closet. And they try to put her in the closet. And they're not able to put her in the closet because of the way she's taped up. So she's left there without her cell phone, and they leave. And as soon as they leave, they continue doing what they want to do from the beginning, which is to get away with it. So they take that truck down to Detroit, because that's direct evidence. They're in that truck. There's probably going to be DNA left in that truck, and they set it ablaze. That truck goes on fire. And then you see the vehicle being followed by the defendant's wife within minutes to where the truck is found blown up within minutes, because he's still trying to get away with the larceny. So as the investigation continued, the sheriff's department very quickly, very wisely put out that video to the media. And that video went out on the media quickly, and the defendant was quickly identified as being one of the two people in it, physically distinctive. And as they do that, they start figuring out what vehicles are registered to him, where does he live, does he have any other residences, and they figure out his Jeep, they figure out the Texas residence, they figure out he's gone from where he was staying up here with his mother-in-law. That mother-in-law who identifies him as being the other person in the Ring camera, and then also identifies him as being on that Lowe's video. She did that in front of you. She'd never had the opportunity to see the Lowe's video before. She identifies both defendants an hour before this. At that point in time, they're stopped in Louisiana. Louisiana takes everything into evidence. And at that point, you hear when it's brought back, all the things of significance that is in there from Louisiana. You find the size 13 shoes, boots, that belong to him. And you see 2 pairs of 13 sneakers that weren't connected to this. So he has 3 pairs of 13. And on the bottom of those 13s, you'll see blood was discovered. And then you'll see that he's collected a lot more of the evidence that didn't even belong to him. He has Zuazo's boots. You know, he's probably tasked with destroying some of the evidence, and he's keeping that. Is he keeping that to negotiate something down the road? Who knows? But he kept it. He still has the DT clipboard. He still has the DT sign. He still has the POCO license plate. He has all these items with him, including the stolen jewelry. So what you see down in the basement, which is absolutely brutal, what you see down in the basement is, and I think very obvious, that Mr. Murray was putting up a struggle. Okay, the only blood that's ever found is Mr. Murray's blood. There's no blood of the defendants. There's DNA of the defendants, but it's not DNA from blood. But he's struggling. And when he's struggling, no matter how big or small either the defendants are, when you're struggling, they had to bind his hands. They had to bind his mouth. And they bound the hands with both duct tape and those zip ties. And why it's important, and I think it shows, not just because the doctor said the blood is in his lungs, which means he's bleeding. So there's already been that physical altercation, and he's bleeding and inhaling it. That doesn't happen if you're already dead. You don't breathe and inhale once you're dead. And at that point in time, you see very clearly in the photos, that Rolex is bound underneath those zip ties. It's bound in a way that even the ME said no, but it was secured under those zip ties. Because Hernandez likes the Rolexes. We know that, coincidentally. If he could easily have gotten that Rolex off, that would have been the most expensive item to take from that scene. But he wasn't able to do it because there was a struggle going on. You heard the multiple blows that Mr. Murray sustained in multiple areas of his head, of his face, consistent with the butt of a gun that was never found, that was taken out of there. The money was never recovered. The cell phones were never recovered. But what was recovered was the defendant's T-shirt, XL6 size, that has the victim's blood on it. What was recovered was the duct tape rolls in the basement has both defendants' DNA on it. And the other thing that you can't escape, defense is going to have a closing. I don't know what they're going to say, but you can't escape saying he's not part of that bloody scene. He wasn't upstairs when that happened, because if he's upstairs when that demolishing of Mr. Murray occurs, there isn't going to be Mr. Murray's blood on his T-shirt. There isn't going to be Mr. Murray's DNA on the bottom of his shoes. And you also heard from the crime scene that they took kind of a special type of thing to uncover any type of blood evidence that was down there. This is admitted into evidence. I'll show you what's been marked as and introduced into evidence. Exhibits 3K, 3O, and 3M. The black 13 Nikes from both sides. But look at that distinctive pattern on the bottom. That is unique. That's unique to the eye. Now there's blood found on these shoes, and that's the victim's blood. But to say he's not down there when this occurred, exhibit 2AA and 2BB. Look at that pattern that's left on the bottom of that floor. The unique ridge line on the side of those shoes on the bottom. I'll have an opportunity to address you after Ms. Lofton is finished, but I appreciate your attention.
Go ahead, Sullivan.
Thank you. Good afternoon. It is quite clear that you have been an attentive jury and you've paid attention to all of the evidence and taken notes when you felt it was appropriate. So I'm not going to stand up here and go over every single thing that we have heard in these last 3 long days. But it is important to go over a number of things that you heard and some things that you didn't hear. Since it's the prosecutor's burden, as he just mentioned, he gets to speak to you twice. So I apologize in advance for my long-windedness, as I only get to speak to you once. We have told you many times that you as juror members are here to piece together what happened on October 11th, 2024 in the city of Rochester Hills. As you were told in voir dire, the prosecutor must prove each and every element beyond a reasonable doubt. The prosecutor carries a very heavy burden. This doubt can be created by the evidence presented, but also by the lack of evidence that the prosecutor brought forth. Now, we saw a Ring camera video from October 10th. Clearly shows that in the evening, 2 individuals came to the Murray's home and asked to come inside to look for a gas leak. They were turned away. We also know from Ring camera footage that the following day, in the morning at 11:22, the same individuals returned to the home, and this time they were let in. We know from the garage Ring footage that these 2 individuals left at 11:41. So we are talking about 19 minutes. We also know that the 911 call was placed at 11:47 a.m., within 5 minutes of these 2 individuals leaving the home. We heard from Deputy Copeland and actually got to watch his body camera. He was the first responder. You can tell from that body camera that he responded and got out of his car at 11:54 a.m. Officers do not enter that basement until 12:08 p.m. He, in fact, does not check for a pulse until 12:13 after saying, "I know it's silly, but what the hell? I will check for a pulse." The paramedics arrived even minutes after that. He testified, and you could hear from the comments that were being made on his body-worn camera that he believed that Mr. Murray was shot in the head, which is usually an untreatable situation. We know from Dr. Shauna Bryan, the medical examiner, that Mr. Murray was actually still alive after the assault occurred because blood was found in his lungs, and also based on the fact that there was a large amount of blood found on the floor around him. And as the doctor explained, his heart was still pumping. It was 30 minutes from the 911 call until someone attempted to render aid. Another important detail from Deputy Copeland were his comments that he found blood on the wall and the handrail leading to the basement. This blood swipe is very similar to the one that we heard and saw that was located upstairs near the bedroom. And who did we find out was the only person that went upstairs? Mr. Zuazo. We heard from Valerie Myra, the forensic lab investigator. She was responsible for taking the photos and assisting in the processing of the scene. She told you that when collecting evidence, you never just toss it into one bag because it ruins the integrity of the DNA. She also said that when you have wet items, you put them in paper bags. You don't put them in plastic bags. She took all of the pictures of the scene and then also did some fingerprint analysis back at the lab. Now, she did photograph that swipe, that blood swipe upstairs. She was not directed to it and didn't see it or photograph the one down by the basement. We heard from another forensic lab investigator, Sierra Ramirez. She detailed her impressive academic achievements to be able to hold the position that she does. Now, she was in charge that day on collecting the evidence at the scene and then processing a number of the items for DNA. She explained that when you're collecting evidence, you need to wear gloves and wear a mask to prevent any type of DNA transfer or degradation of the DNA. You saw her not even wanting to open the package that Mr. Pietrafesa handed her without gloves and a mask. She said it is very important when collecting evidence that you put everything in separate bags. She also described that if something has a biological substance on it, like blood, and that item is put next to something that is dry, DNA can transfer. Was Mr. Hernandez's DNA on the rolls of duct tape? Yes, we know he purchased the rolls of duct tape. Mr. Hernandez's DNA was also found on a number of items that were found in the back of his car after he handled them and packed them into his car. We also know that he packed all of the items that Mr. Zuazo was wearing in a black bag, which was found in his trunk. Now, we heard some testimony from Thomas Keelan. He was the individual that worked for POCO, and he testified that his truck was stolen on September 29th. Now, like we discussed in voir dire, even if you believe that Mr. Hernandez was responsible for stealing the car, he's not charged with that. The fact that the truck was stolen does not satisfy any of the elements of the charges that he is on trial for. We also saw and heard from multiple witnesses saying that the truck was burnt. It was driven to Detroit that same day and burnt out. Again, Mr. Hernandez is not charged with anything related to the damaged vehicle. The burning of the truck does not satisfy any of the elements of what you are here to decide. We heard from Brian Broad, that was the former boss of Mr. Zuazo. We heard that he identified him from a video that was played on the news and the social media, and he immediately called the police. He also testified that Mr. Zuazo was let go due to poor performance and not following the rules, and that when he was fired, he decided to call his boss and tell him he was going to kill him. We heard from Deputy McCoy and the detective Casey Jones from Louisiana that Mr. Hernandez had an address in Katy, Texas, and that a be on the lookout was put out in the United States, and he was pulled over in Louisiana in a white Jeep. You heard that when he was pulled over, he complied with everything that was asked of him, and he pulled over immediately. We heard from Hannah Hussein. She's a family member of the Murrays and has been a store employee at that pawn shop for 20 years. She told you that in 22 and 23, Mr. Hernandez pawned items at the store that was owned by Mr. Murray. She described that in January of 2024, someone came in and redeemed the items that Mr. Hernandez had pawned. She couldn't say who that person was, but someone came in. She also told you a story that had never been previously told to police or written in a statement. Even though she agreed with me, it was an important detail. She told you at some point, which she does not know when, she remembers Mr. Hernandez entered the store when she was working and asked about a Rolex, and then asked to talk to the owner, Mr. Murray. She has worked at that store for 20 years and testified that on some days she sees 50 people. In reviewing her testimony in the jury room, I ask that you review the judge's instruction on credibility. If we are to believe that that happened and Mr. Hernandez had an interest in Rolex watches, I understand Mr. Pietrafesa's explanation of why that Rolex would not have been left on Mr. Murray's wrist if Mr. Hernandez was the one that was doing the assault. Does the fact that Mr. Hernandez went into the pawn shop owned by Mr. Murray in October of 2023 prove any of the required elements? I say no. Even if you believe that he went into the store in January of 24 to redeem his items, it does not prove any elements. There is no evidence to show that he had somehow been following Mr. Murray for over a year. Now, we heard from Linda Murray, and I think that Mrs. Murray did the absolute best job she could testifying. Definitely the worst day of her life. Now, she told you that on the night of October 10th, she yelled down to her husband asking if he had his gun on him. If we are to believe that she said that loud enough for Mr. Hernandez to hear, does it make sense that they would come back the next day with no weapon? Especially not if the plan was to injure Mr. Murray. Now, she told you that she never saw any type of weapon from either Mr. Hernandez or Mr. Zuazo. Another interesting detail she mentioned was that Mr. Zuazo went downstairs with a mask. He had it on his face. But when he came back up, he didn't have a mask on. So whatever happened in that basement with Mr. Zuazo, it caused him to lose his mask. Not Mr. Hernandez. He still had his mask on. Would a man that is 450 pounds be able to do the assault that we saw the results of and walk back upstairs with that same respirator mask on? I argue no. The most important part of her testimony in relation to Mr. Hernandez was the proximity in which Mr. Hernandez was to her for about 10 minutes of the time that he was in that home. All of the close interactions that she described happened after Mr. Hernandez had come up from the basement. She told you that he used his arm to grab her and take her to the kitchen. She told you that she watched his hands as he took off her watch, as he took her phone, as he went through her purse, as he went through the drawers in the kitchen. She was within inches of him as she watched his hands put duct tape on her wrists and on her ankles. She never saw one drop of blood on him. Not on his mask, not on his hands, not on his vest. No blood was smeared or swiped on her when he did all of those things that required him to make physical contact with her. You saw the amount of blood that was in the basement. If Mr. Hernandez did the assault on Mr. Murray, there would have been more blood on him. You saw in the autopsy photos the amount of blood that was on the face when someone used duct tape to bind him. I argue it would be impossible for Mr. Hernandez to be blood-free on his hands if he was the one that did that. Just look at the swipes of blood left by Mr. Zuazo. Now, we then heard from Detective Wiegman. He is the one you saw in the interview of Mr. Hernandez, but also the detective who testified that he talked to Mrs. Murray pretty consistently for over a week and compiled his understanding from the interviews with her. I actually read from his report and he agreed with all of the statements in it. He stated that Mrs. Murray had told him that Mr. Hernandez came up from the basement and began to ask for money, jewelry, goes through her purse, takes her phone. That there was a period of time where this happened before Mr. Zuazo came upstairs. Now, once Mr. Zuazo comes upstairs, Mrs. Murray sees the blood on him and screams. This timeline fits exactly with what Mr. Hernandez says in his interview. And obviously at the time of his interview, he had no idea what had been reported to the police, but he tells the detective, everything was fine until Mr. Zuazo comes upstairs and he has blood on him. Now, we saw a lot of text messages today that Mr. Hernandez exchanged with his wife and with Mr. Zuazo. In all of those hundreds of text messages, nothing about a gun, nothing about a weapon, nothing about killing. Now, conversations about an elaborate larceny? Absolutely. Conversations about taking things that weren't his? Yep. But Mr. Hernandez does not have a charge that you are here to decide that is alone called larceny or home invasion. Now, we heard from the medical examiner, Dr. Shauna Bryan, and she told you that Mr. Murray did not die of a gunshot wound, which was previously thought, but actually he died after being beaten in the head and the neck. She told you that blunt force injuries could have been from an object or a fist, or some of them could have even been from a fall. That while the injuries were severe, they could have been done by someone that was just 150 pounds. She also testified it takes 6 pounds of force, or as she described, the weight of a human head, to compress the neck to stop breathing. This definitely could have been done by one person. Now, after his arrest, Mr. Hernandez did not have to talk to the police. As you know, Mr. Zuazo did not. He could have remained silent, but he didn't, because he wanted the deputies to know that he was not part of the beating of Mr. Murray, and he wanted to tell them that. Now, it's usually not appropriate to talk about someone's size, but because it's been such a topic of conversation here, let's talk about it. Remember the video of the interview in Louisiana. At that time, my client was booked into the jail at 450 pounds. As you could tell from those Lowe's videos, he had some trouble walking. And if you watch at the end of that interview, he could barely get up from the seat. Now remember back to the photos of where Mr. Murray was found. That space is extremely small. I argue that there is no way that Mr. Hernandez could have been the one attacking Mr. Murray. One, I don't think he's physically able to, and keep his mask on. And two, there wasn't room. Now, Mr. Hernandez was open and honest about the fact that a truck was stolen, signs were made, outfits were purchased, forms were printed out, badges were made, clipboards, duct tape, zip ties. They bought hard hats. We saw them at Lowe's and Home Depot, all in elaborate preparation of a larceny, not a murder. You did not see them at a gun store. You did not see them buying weapons of any sort. That is because it is clear from the evidence and clear from what Mr. Hernandez kept saying in his interview. It was not supposed to happen. Mr. Murray was not supposed to die. For that whole hour, Carlos kept the same tone, the same mood, until he was asked one question. If you killed the husband, why would you leave the wife alive? It was not supposed to happen. There was never a plan to kill Mr. Murray. If there was a plan to kill, why would you need to bind someone with duct tape? If someone is dead, they don't need to be bound. Think about that. They chose to walk in with tape instead of a weapon. Does tape show intention to kill? I argue no. Dr. Bryan told you that the duct tape on his hands and feet and mouth did not kill him. If there was a plan to kill, once the gun was removed from Mr. Murray by, I believe, Mr. Zuazo, why wasn't he shot? Why then wasn't Mrs. Murray shot? Now let's talk about the mention of an insurance policy in the interview and the correlation to the black bag found in Mr. Hernandez's Jeep. In that black bag, we were told Mr. Zuazo's boots, gloves, hat, and 2 masks were located. DNA clearly shows that those items were his and they match what he wore on the Ring camera. Now, how did Mr. Murray's DNA end up on the large white t-shirt and the shoes of Mr. Hernandez? Well, unfortunately, Mr. Hernandez does not have the years of training regarding biological substances like the evidence technicians. Mr. Hernandez's own clothing was found in the same plastic bag as the bloody items from Mr. Zuazo. We learned about DNA transfer and degradation. If Mr. Hernandez had blood on him, Mrs. Murray would have seen it. I asked you in voir dire if you understood that you were not here to decide if Carlos was a nice guy, if you'd like to have him as a neighbor, or if you'd like him to have him date your daughter. Do you remember that question? And why is that important? Because again, even if you don't like him, none of the elements are satisfied by that fact alone. You may not like any of the actions that Mr. Hernandez took leading up to October 10th, on October 10th, or October 11th. The fact that he did some bad things does not then automatically mean that he committed the acts for which he is charged. Now I want to talk about the actual charges now. So we know the first count is first-degree felony murder. To prove this charge, the prosecutor must prove each and every one of the following elements. First, Mr. Hernandez caused the death of Hussein Murray, that he died as a result of neck compression and blunt force trauma. Second, Mr. Hernandez had one of the 3 states of mind. He intended to kill, he intended to do great bodily harm, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Mr. Murray, that Mr. Hernandez was committing or attempting to commit or helping someone else commit the crime of larceny. And as we all know, after the end of 3 days, a larceny is a taking of property with intent to permanently deprive the owner without consent. Now, did the prosecutor prove to you beyond a reasonable doubt that it was Mr. Hernandez that caused the death of Mr. Murray? I argue no. The prosecutor now gets 2 bites to this apple here. They are either arguing that yes, it was Mr. Hernandez who actually did the beating death of Mr. Murray, or if you don't believe that, then he is still guilty under aiding and abetting. This instruction is so important and actually very helpful to you when you go back in that jury room, so I want to go over it. The judge is going to tell you to prove the theory of aiding and abetting. The prosecutor must prove all of the following elements beyond a reasonable doubt. First, that the alleged crime, which is felony murder, was actually committed either by Mr. Hernandez or someone else. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. And third, which is the absolutely most important element. Third, at the time, Mr. Hernandez must have intended the commission of felony murder, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Was murder a natural and probable consequence of the commission of larceny? I argue absolutely not. And because of that, you have to find Mr. Hernandez not guilty of felony murder. These 2 individuals did not bring a weapon. They walked in the home with fake DTE equipment and duct tape and zip ties. Death was not the natural and probable consequence of those actions. It is clear that Mr. Hernandez went into that house thinking he could make some fast cash and get a house. There has been absolutely no evidence that Mr. Hernandez went there with the intention to kill anyone in that home, and because of that, I argue felony murder was not proven. Now, Mr. Hernandez is also charged with 2 counts of unlawful imprisonment. As we discussed in openings in voir dire, there's 1 count as to Mr. Murray, 1 count as to Mrs. Murray. The elements are the same. For count 2, unlawful imprisonment against Mr. Murray, I do believe that the prosecutor has proved the elements of this charge under the aiding and abetting theory we just went over. Mr. Hernandez went into the house after purchasing duct tape and zip ties that he shared with Mr. Zuazo. I believe the evidence then shows Mr. Zuazo used those items to restrain Mr. Murray. The binding of Mr. Murray was a natural and probable consequence of him walking in there with that tape. I believe the prosecutor proved that to you. As to count 3, unlawful imprisonment against Mrs. Murray, I do believe that the prosecutor has proved the elements of this charge. The testimony of Mrs. Murray indicates that it was Mr. Hernandez who used duct tape on her wrists and ankles prior to leaving the home. The verdict form will not say guilty or innocent. The verdict form will say guilty or not guilty. And by voting not guilty, you are voting not proven, that the prosecutor has not proven his high burden. I ask on behalf of my client, Carlos Hernandez, that you return a verdict that is consistent with the law, consistent with justice, and a verdict that is supported by all of the facts and evidence that you have heard in the last 3 days. And that would be a verdict of not guilty as to count 1 and guilty as to count 2 and 3. Thank you very much.
Thank you, Ms. Laughlin. Any rebuttal here?
Brief rebuttal. Let's go back to state closing.
Again, defense counsel starts off with talking about a plan to kill when they arrived at the house. That is not what felony murder is. That's first degree premeditated murder. That's not how you're going to be instructed regarding the elements to be proven in this case.
Bring it home,
I
sir.
would also say that there's a couple definitions that I maybe take issue with or need to be amended after this case has gone through. The first one would be forthcoming in describing the defendant's statement to the Oakland County Sheriff's detectives. What I heard, and I think it's only got little worth, but I don't think it was very forthcoming when he was talking to the detectives. If you recall, which I thought were the highlights of it, defendant says when he's supposed to be forthcoming with the detectives, he says, "I never said I was there the second day.
I never said I was there the second day when all the bad stuff happened. At that point, he's trying to portray himself as only being there on the 10th, where nothing really bad happened. That was forthcoming statement number one. Then you remember he was asked about Mr. Murray fighting back. There was no response to that question at all. Silence. He doesn't want to talk about what happened in the basement with Mr. Murray. And then shocking, he says, when asked about hitting Mrs. Murray, he says, I don't recall hitting Mrs. Murray. That was another one of his forthcoming statements that he made to the police officers. And the final term that I would change is that this was an insurance policy for him, because what he had in that black bag was anything but an insurance policy for him. Now, there was a statement about his mask not being in place and there should be more blood on the defendant. More blood, we need more blood. Well, you hear from the first deputies on scene that they're reporting as a gunshot wound. That's how much blood there is at that scene, that they believed it was a gunshot wound. That's how much blood was there at the scene. We need more blood. Okay, well, the facts give you more blood. As you heard the testimony, you have the exhibits for the defendant, C and D, that are moved into evidence. In the stuff that's found with them, face covering N95, red stain on the exterior. Defendant Hernandez on the interior, both victims on the exterior of that. Defense wants more blood. Okay, well, 7E, white t-shirt, which is into evidence before you. Swap both the inside and the outside. Defendant Hernandez on that 6XL t-shirt is in the interior. Victim Sam Murray is in the exterior of that exhibit. More blood still, we've already talked about it, those black Nikes. But not only is there the blood of the victim on the outside of those shoes, the blood of the victim and his DNA is inside the shoe also. That's how intimately connected the defendant is with that bloody scene. And then finally, as we also discussed, 7G, the black gloves that were found on the defendant when they were stopped. Exterior victim of the victim. Interior is defendant Hernandez. Also interior is victim Linda Murray. So I guess the best response I can have about trying to have it both ways, I believe that was said at some point. At no point have I ever theorized that only one of the defendants obliterated Mr. Murray in that basement. I don't believe only one of those defendants had contact with him when this was occurring. I believe both defendants had contact with him down in that basement when he put up that struggle, because they have to disarm him. And disarming him first is probably one of the main priorities. But then he's attacked from the back and his head is bleeding. Now, I tried to think about, a response to that. But growing up, I have a brother. He's 4 years younger than myself. Okay, so growing up for a long time, I was the older brother. And when we roughhouse and play around and wrestle and stuff like that, I could get both of his arms, his wrists in one hand and hold him down with one hand and a second hand free to tickle him. I don't know what you want to say, but you could hold both arms in one hand.
That was not, I don't like that comment. Tickle, stop.
When he got older, I couldn't do that anymore. And if we were going to struggle, it would take
I know you're describing something different, but I don't like the comparison. I just don't like the comparison. I'm sorry. Just
hand in each hand to do it. Now, Mr. Murray is a big guy. Mr. Murray is struggling. There's no way that you're holding down Mr. Murray as he's struggling with one person and then binding him in that position. There is no way one hand is holding him with one hand and tying him with duct tape with the other, with zip ties. Impossible.
I agree with him here. I do agree with him here that to do all that, it probably took two people to do it. But sir, I don't like that analogy.
Both of those guys were doing that down in the basement. They had the blood of the victim on it to prove it. You don't get blood on you like that if you're upstairs with Mrs. Murray asking about where the safe is. I believe the evidence has clearly shown that the defendant is guilty of charged of the murder and of the other two counts. I appreciate your time and attention. Thank you.
The form and the verdict.
Okay. So then she's going to give all the instructions and everything for them to go back and come up with a verdict. And they end out the day and everybody thought there wasn't a verdict. Well. Lo and behold, they did come back. Words are hard today, Sheila. They did come back with a verdict not long after everybody decided to end their stream on Friday. I had found out. So we're going to end with the verdict. But first, I will review with y'all my notes from today because we all know notes are important. So we're going to hide the man behind the pole. Sorry about that. I'm going to review my notes and tell you what I learned today from court. So with today, we started out with Dr. Bryan. She did the autopsy. She was a medical examiner. She said there were the strangulation marks and compression on his neck. The cause of death was a fracture to the jaw area, blunt force trauma, and asphyxiation due to the hyoid bone and neck compression. They compared the fact that Carlos was 450 pounds as compared to Joshua, who was 130, and who would have been more susceptible to causing the injuries because of their size. I got some wild hair today. They also stated that Mr. Murray had a large heart, which could have, he was at greater death perception due to his heart issues. So he may have died quicker, which I don't believe that, but okay. I mean, he may have had heart issues, but I think that has nothing to do with his cause of death. So then we went on to Jordan Conley. He was with the computer's crime unit. He was witness 17, and he collected all the cell phone data and had run through Cellbrite. The text messaging was horrible. It was, we learned that Amanda was in on a lot of stuff, and I'm sure she will be charged eventually, in my opinion. They tried to say that there was no conversation about the murder or weapons in the text messages, which I did not see evidence of the actual discussion of murder or weapons. They talked about getting a vehicle. And then they talked about all the, not labels, the magnets to go on the cars and their IDs that Amanda was having made and all that stuff. So they asked for a direct verdict. That was denied. And let's see. Just talked about the videos of purchases in the Lowe's and Home Depot, shopping for zip ties. When Zuazo came upstairs without Sam, Linda asked where her hubby was. Zuazo said he was sleeping, but she's seen blood on Zuazo, so she knew something was up. And at that time, Hernandez punched her in the face, and they searched the house. Zuazo searched the house upstairs. He ransacked it, Supposedly Hernandez did not go upstairs, according to Miss Linda. And what they feel the only valuable thing taken was Mr. Murray's life, which I agree. The truck was burnt out. And they think that Zuazo was mistaken identity, is what her closing argument, or his closing arguments, Mr. McCarthy said, which I find that hard to believe, but okay. And defense argued that the duct tape wouldn't have been used if they had planned on killing them, that the duct tape would have been to bind them in the zip ties, and they wouldn't have had intentions to kill them, which I don't agree with that. DNA was both of them. Oh, she tried to say that because the DNA was put in the same plastic bag is why Carlos had Mr. Murray's DNA. And that they wanted to make fast cash to get a house. So we are going to jump over here to the verdict. I have not watched it.
On behalf of Mr. Zuazo at 4:15 p.m. and it said, "We have reached a verdict." That note came in when we were in the other proceeding. The court was aware that a verdict had come in.
So you mean to tell me Zuazo already had a verdict ready while they were still discussing Carlos's? Okay, they're on it.
Not address the jury at all. Where's the note that they just sent? The note where they talked about, we just need to know what's going to happen. Do I have that?
Hold up. Let me boost the sound because, I'm deaf.
Oh, is it in its own envelope? Oh, here it is. Okay, yeah. So this note comes in just now at 5:53, and it says, "Is it possible to get an update on the process? We're not sure what to expect, and any info would be appreciated." All this has been communicated to all the attorneys. They're aware of it. As soon as I got the notes, I just wanted to place that on the record that those were the only two notes written on behalf of defendant Zuazo. So we're going to accept our verdict now. Let's bring our jury in.
Okay. So this is going to be the verdict on Zuazo. And this is him right here, standing there looking so profound and astute. What are we whispering about, guys? Frying the jury.
Gentlemen of the jury, please be seated.
Okay.
All right, so we are in receipt of your note that you have reached a verdict. Have you chosen a foreperson?
Yes.
All right, Mr. Foreperson, did you bring in that verdict with you? Okay, if I can just take a look at it and I just want to review it to make sure that it is signed and dated, and then I'm going to give it back to you and you can let us know what your verdict is. Okay, all right, I'm going to send this back to you. Just read as to each count what you found, please.
Count 1, first-degree felony murder. Guilty as charged with first-degree felony murder. Count 2, unlawful imprisonment. Guilty as charged. Count 3, unlawful imprisonment. Guilty as charged.
All right, thank you, Mr. Foreperson. We'll collect that verdict form from you, and you could be seated. Would anyone like the jurors polled?
Your Honor, I would make that request.
Okay, all right, juror in seat 1, sincerely appreciate the time and service that would
We
be
don't need
available.
to see the jurors being polled. And he is guilty on all 3 counts. Count 1, felony murder. Count 2, unlawful imprisonment, Mr. Hussein Murray. And count 2, the second unlawful imprisonment, who was Miss Linda Murray, was also guilty.
To say hello. Thank you.
All rise for the jury.
Bond is already denied here. Is that? All right, and bond is already denied here, is that right?
Yes, sir.
All right, so bond remains denied, and we will come back here for sentencing on
December 9th at 1 o'clock.
All right, December 9 at 1 o'clock. I'll see
That's the
everyone.
only thing
December
that-
9th, 1 o'clock, sentencing.
Where just at the time of sentencing, we do address the habitual offender notice to you for the record.
Okay, we'll do it then.
Very well.
We're all set.
Okay. He's being taken away. He says bye-bye. So are we going to get a verdict for... Okay, we're going to
Oh, are
fast
we ready?
forward.
Okay, let's call the case.
Calling people versus Carlos Hernandez, case number 2024-291-945 FC.
John Petrofessa and Andrew McGarrow on behalf of the people.
Paula Michelle Lawson on behalf and with Mr. Carlos Hernandez.
All right, tell me your name.
Carlos Hernandez.
Okay, all right, so by way of background, the jury was sent out around 5 p.m. I got a note number 1 at 5:21 p.m. It says, jury B is requesting Mr. Hernandez's t-shirt. That was submitted as evidence, as well as the photos of the back of the Nike shoes, the photos of the shoe prints at the scene, as well as the N95 mask with Mr. Hernandez's DNA on it, as well as the crime scene photos of Mr. Murray in the basement. The court discussed this off the record with the counsel, and those items were then put together and sent back to the jury. And at 5:58 p.m., the next note came in and it says jury B has reached a verdict and we will bring them in to receive same.
Okay.
All right, Mr. Foreperson says that you have reached a verdict. Did you choose a foreperson? All right, Mr. Foreperson, I'm going to have you read us that verdict, but first I just want to take a quick look at it just to make sure it's signed and dated. Thank you. Verdicts are as to each count.
Should we stand?
Sure.
For count 1, first-degree felony murder,
Sir, you should
the
stand.
jury finds defendant Hernandez guilty as charged first-degree felony murder. Count 2, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged of unlawful imprisonment. Count 3, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged with unlawful imprisonment.
Okay, all right, thank you. We're gonna get that verdict form back from you. Would anyone like the jurors polled?
Yes.
All right, juror in seat 1, is that, and thank you for your time and service. I know today's been a.
All right, jury.
Okay, so guilty across the board for both of them. Okay. I didn't expect anything less. I honestly didn't. I mean, this was pretty laid out there.
Will continue to be denied and we'll come back here for sentencing on
December 9th, 1 o'clock.
December. Yes, does that work? December. Yeah, go ahead.
My client has asked for a different sentencing date as a co-defendant, and I told him that I would ask.
Let's be fucking petty. Let's be petty now. How old are we? Excuse me. He wants a different sentencing date. Get the fuck. Sir. You're nobody special. Stop it.
December. Yeah, go ahead.
My client has asked for a different sentencing date as a co-defendant, and I told him that I would ask for.
December 9 at 1 o'clock.
Thank you.
All right, the
Thank you, Judge.
motion is denied. Anything else for the record at this
Judge,
time?
Again, there's a habitual that needs to be addressed at sentencing.
Okay, we will do that then. Ms. Lofton, anything else? Okay, all right.
How dare he even ask for a different date than his co-defendant? Like he is that special. Sir, no. Let's see if they come put some cuffs on you. There we go. Let's just watch them cut them up. You know, just for an end finale of all this. Please. Goodbye, sir. Goodbye. My goodness, my goodness. So we got it into that trial. We have a verdict of guilty across the board for both on all 3 counts, first degree felony murder, or not first degree, felony murder, and 2 counts of unlawful imprisonment on both boys. I will not call them men. I do not think they're men. They are just anyways. I plan on going live for anybody that's interested on the Rubber Ramada channel. I am working on making things a little more accessible over there and moving things. So you will be seeing me live more on the Rubber channel. I will be doing a live at 11 Central. So until then, I will go enjoy my furry little children, and I will see everybody at 11 on the Rubber channel. There has been a post made, and I have good Lord, all these things popping up on my computer. Anyways, till then, peace.